extreme urgency involved in this matter, my lord. My review application has been kept pending by the GST authority, and intimation has been
Your motion, please hand over the slip.
leave. Leave. না না, এটা লিভের জন্য আমি দিলাম। না না, এটা সার্ভার কপির দরকার নেই আমার, জাস্ট
on Monday, Saturday is not.
Yes, file it. It will appear tomorrow.
এই দুটো।
One 118.
Maybe any time today, tomorrow, so that the packet has been taken up. Because my goods are stuck with GST authority.
This was taken up once.
Not be taken up, hence it was transferred from Calcutta High Court to Jalpaiguri.
No order was passed.
Only one order was passed that the matter may be transferred to. I mentioned the matter to vacation, so it not be taken out.
118. But I 3 p.m. করে রাখুন।
Lordship, may I be permitted to mention item number 68, your Lordship? Lordship, it was taken up last Friday. The
Yes.
department sought time. Lordship, my writ will be infructuous if your Lordship doesn't take up this matter because I'm challenging the show cause notice. And the petitioner was in the custody when the pre-show cause notice was issued.
Yes,
Lordship, kindly, Lordship.
I will proceed. No. Today, please come today. Yes. Correction, yes, please hand over.
The tender matter of protection has been granted to me by the principal bench. This was to appear on 4th North brought appear. My interim protection was under the heading of extension of
Extension of interim order tomorrow. কালকে extension of interim order দিয়ে দিলেন।
Lordship, may I permit to mention a matter? The matter was, I previously cited number 52, Lordship. This matter is related to GST and perishable goods matter, Lordship. Last occasion, this was taken up for hearing, but no one represented for the respondent, Lordship.
Yes.
Kindly take it today, Lordship.
What is the item number?
Item number 52, Lordship.
Let me see. Yes.
Grateful, Lordship.
Yes. Hand over the slip. Yes.
Your Lordships, may I be allowed to mention one matter, Your Lordships?
Yes.
Your Lordship, item number 52 of today's list, Your Lordships. This is of urgent, extreme urgency is required in your
Item
Lordships
number?
in this matter. 52, 52,
Yes,
Your
let me
Lordships.
see how far I can proceed. Yes.
For the petition.
Lordship, may I be permitted to mention item number 73, Lordship?
Yes. What do you want?
Lordship, the matter is appearing under the heading application. The petitioner is not being allowed to perform the academic access and administrative duties in spite of direction by the Honorable Bench, Your Lordship.
Who is appearing for the respondent?
Lordship, North Bengal University is the concerned respondent, Your
Who
Lordship.
is the learned advocate?
Lordship, may I serve notice? Kindly fix the matter. I'm serving notice.
Please serve notice. Come at 3 p.m.
3 p.m. Yes,
72.
Your Lordship. Item 73, Lordship.
For 73, 3 p.m.
Yes, Your
Yes.
Lordship. Yes, I am serving notice. Yes.
Yes.
This you have placed.
Lordship, I represent state in this matter.
Yes.
Order date 29/10/2025. The name of the petitioner is recorded as Rahmat. It will be Rahmat. RAH.
It has been pointed out that there is a typographical error in the name of the petitioner. That there is a typographical error while recording the name of the petitioner in the cost title of the order dated October 29, 2025. The name of the petitioner was wrongly recorded as such and such instead of such and such. If such error be rectified, this order shall form part of
Another correction.
Page number 2.
Page number 2.
Yes.
The direction is given upon the sub additional, it would be subdivision. Page number 2, third line.
In place of additional, it would be divisional, subdivisional.
Subdivisional controller.
Yes.
Acha, the article, it has been pointed out that in page 2 of the said order, the direction was passed upon the additional controller, Department of Food and Supplies. instead of subdivisional controller, Department of Food and Supplies. Full stop. Let such error be rectified. This order shall fall.
Lordship, state is represented.
State is represented. 2 yes.
My lord, similar page number 2, instead of sub-additional, it will be subdivisional.
It has been pointed out that in page 2 of the order dated October 29, 2025, the direction was inadvertently passed upon the additional controller, Department of Food and Supplies, instead of subdivisional controller,
Fine.
Department of Food and Supplies. Let such error. Yes, call the next matter.
Not small investment.
Lordship, I am for the petitioner, Lordship. Lordship, in this order, the district become changed. It should be the district Coach Bihar instead of district Alipurduar, Lordship.
You are a teacher of district
Primary transfer. Lordship.
Coach Bihar.
Yes, Lordship.
It has been submitted that in the first page of the order dated November 3, 2025, it was inadvertently recorded that the petitioner is an assistant teacher of a primary school in the district of Alipurduar, whereas the petitioner is an assistant teacher of a primary school in the district of Coach Bihar. Let such
Grateful,
error
Lordship.
be rectified.
I'm appearing for the DPSC
Yes.
Coach Bihar, my lord.
Yes, please note the app. Call the next matter. 4 yes. Yes, Mr. Ghosh.
Milord, my prayer, Milord, is very simple. Milord, before, Milord, I'll just throw the papers, Milord. Milord, 2 tea gardens adjacent to each other, Milord, 2 tea gardens. Milord, earlier, both of the gardens were under the Imperial Tea Company Limited during the British time. Subsequently, Milord, it came into the hands of Eveready Industries, subsequently McLeod Russell. When McLeod Russell, Milord, left the garden, Milord, both the gardens went into different companies. Now 2 different owners. Now, Milord, a chunk of 43.87 acres of land, which was, Milord, earlier with one of the tea gardens, that is, Milord, is a bone of contention. Milord, a civil suit is pending. That tea garden has preferred a suit for recovery of possession from me. Because admittedly from the records, Milord, even from the report of the state, which is on record, it will appear that that chunk, 43.87, was under my cultivation since the last 50, 60 years, probably for a century or more. Now, Milord, I am only saying, Milord, in the suit that that garden has filed before the jurisdictional civil court for recovery of possession, Milord, there is a direction, Milord, for maintaining status quo as regards ownership, possession, everything. Now, Milord, subsequently, what has happened, Milord, recently, the block development officer, Milord, Milord, the BLLRO, Land and Land Reforms Officer, has initiated a process for renewal of the lease of that garden. I am only saying, since there is a subsisting order of status quo, you go ahead with the lease, you rectify the records, whatever you want to do, you do, but kindly exclude 43.87 acres for the time being. That is my only prayer.
No, the BLRO is giving a lease. BLRO.
No, lease is already there.
Yes.
Milord,
What
Milord,
BLRO is trying to do?
2034.
Milord, 108, Milord, once, page 108.
Number 100.
This is with regard to recording of the,
It's a correct.
Yes.
The records, the entry of the lease order.
how it can be placed before this honorable.
Milord, kindly see the last line. Now the
Record comprising the, Mr. Ghosh, this is a step taken for correction of the record of
yes,
rights.
framing of record.
Yes.
Framing of record.
Framing of
Milord,
records.
since there is an order of status quo with regard to 43.87, Milord, let that be excluded for the time being. That is
There
the
is
only
a properly
contention.
constituted tribunal, Mr. Mr.
Grateful.
Ghosh, for that.
Milord, probably for this, Milord.
Yes, correction. That's inaction,
Yes,
overaction,
everything, yes.
everything.
Milord, I am
Section 6 is there.
I am not up against any order passed under the WL.
Inaction, overaction, inaction.
Probably, Milord, to
everything.
this extent, Milord, your lordship can interfere. Milord, I am only praying for this.
Mr. Ghosh,
Milord, since there is a subsisting order of status quo, Milord,
make
any
that prayer before the
rectification.
tribunal. What prevents you from approaching the tribunal? Also because the remedy under Article 226 is available before the division bench, not before the single bench also. Single
Milord,
bench's power with regard to these issues have been taken away.
Right, Milord, I understand
So if
completely.
that is
Milord,
so, Mr.
Milord,
Ghosh,
since,
it's
since Milord, any order under the LR Act or the Estate Acquisition Act is not under challenge. Milord,
देखिए West Bengal Land Reforms Tenancy Tribunal Act, Section 6.
Milord, I am aware of the process.
Then Mr.
Milord, I
Ghosh.
am only saying, Milord, since I am not up
You are
against
aware
any
of-
the order.
I am not against order, it's action, inaction, everything.
Milord, Milord, I am
Section
only
6.
saying, Milord, it's an administrative action which is contrary to, Milord, the judicial order.
It's action by the Land Reforms Authority.
That also can be challenged before the tribunal. কোথায় এখানে land reforms and tenants আছে।
Specify একটা land reform scheme.
6B,
Sir, Milord, I have the provision.
6B, please
Yes,
take
yes.
up. Inaction,
Inaction.
culpable negligence of an authority under the specified act.
Yes, Milord, I am not, Milord, I am neither against negligence nor against inaction. Milord, I am only saying, since it is an administrative order, and Milord, it is contrary to the
It's
state
not an
report.
administrative order, it's an action taken by an authority under a specified act.
Milord, kindly consider this.
Report.
Milord, the.
Maybe
lease-
what steps, some
Yes.
steps he is contemplating to
Yes,
take.
yes.
For that, he has given a report or called for a report, whatever it might
Yes,
be.
communication specifying.
Communication made tribunal, Mr. Ghosh is the appropriate authority.
Milord, kindly records that liberty, Milord.
Yes, yes, that can. This application under Article 226 of the Constitution of India has been filed praying for setting aside the memo dated July 23, 2025, issued by the Block Land and Land Reforms Officer, Kalchini Block, in the district of Alipurduar. Full stop. Mr. Ghosh, learned advocate appearing for the petitioner, submits that a civil suit between the petitioner and the private respondent with
Number 5.
regard to
Private respondent number 5.
private respondent.
Yes,
is-
there are two
only-
respondents.
Oh, there are two
Yes,
respondents.
Milord, the company and the manager.
All right. কি বললাম? Against the private respondents, with regard to a portion of a tea garden, which the petitioner claims to be in possession for last 40 years.
Milord, 50 years.
For last 50 years, কি বললাম? No, for recovery, for recovery of possession, with regard to না করে, for recovery of possession of a portion of a, কি বললাম? For recovery? হ্যাঁ, হ্যাঁ। Full stop. He further submits that in view of the, he further submits that the concerned block land and land reforms officers have initiated, have started taking steps for correction of the record of rights in favor of the private respondents. Full stop. He further submits that since the issue with regard to the right in respect of the leasehold property is pending before the civil court, the concerned block land and land reforms officer should be restrained from taking any further steps with regard to, from taking any further steps in the matter. Just a paragraph. Mr. Paul, learned advocate, appears for the private respondents. Mr. He submits, what is your submission? You are in possession.
No. They are in possession since 2017 month. This is my contention.
Uh,
For 50 years.
So now you admit his position, otherwise your suit will go.
Suit put into your position.
That's contrary
That is
to
why
the
I
state's
asked you.
report.
I
So
hope you
submit,
understood.
disputes the contention of the disputes the contention of Mr. Ghosh that the petitioner is in possession of the portion in question, portion of the tea garden in question for last 50 years.
No. Since 2017. It's okay.
You are disputing that he is possession.
In position.
He submits that the petitioner is in possession of the tea garden since 2017.
Has included.
Has encroached upon a portion of the tea garden belonging to the private respondents in the year 2017. First up, he submits that since the petitioner has challenged an action of the Block Land and Land Reforms Officer with regard to mutation of the portion in question, the petitioner has to approach the West Bengal Land Reforms and Tenancy Tribunal for any reliefs against the Block Land and Land Reforms Officer. First up, Mr. Rahman, learned advocate, appears for the state. First up, he also raises an objection as to the maintainability of the writ petition. First up, after going through the memo dated, where is that memo?
108.
108.
After going through the memo dated July 23, 2025, it appears to this court that the Block Land and Land Reforms Officer, that the concerned Block Land and Land Reforms Officer have is taking steps for framing of record comprising the quantum of land as specifically mentioned in the said memo in favor of the private respondents. Respondent number 5. First up, in view of the provisions laid down under Section 6 of the West Bengal Land Reforms and Tenancy Tribunal Act, Section 6, read with Sections 7 and 8 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997, this court is of the considered view that this court is not inclined to entertain this writ petition. First up, accordingly, WPA number such and such stands disposed of by leaving the petitioner free to approach the West Bengal Land Reforms and to approach the appropriate forum in accordance with law for appropriate reliefs. It is however made clear, that this court has not gone into the merits of the claims and counterclaims of the respective parties, and the appropriate forum will be free to decide the same if an approach is made to such forum.
Grateful.
Grateful, Lordship. Next, call the next matter. Yes.
Well, this is my application, my lord.
Yes, what is your application?
Application for inaction of the police authority. My lord, what's happened, my lord? I have served.
Yes, Mr. Rahman.
Yeah.
You are not there. Who is there? Nobody is here. So you are appearing. Yes.
What's happened, my lord? The daughter of the petitioner, the major daughter, the daughter of the petitioner was missing from my lord 8 May 2025. But thereafter, my lord, husband of the said daughter lost the missing diary before the police authority.
Husband of the daughter.
Daughter, my major and married daughter.
Yes.
Thereafter, my
Who
lord,
are you?
I am the mother.
Yes.
I am the mother. Thereafter, no action has been taken. Subsequently,
The husband has not approached. Why?
no, because husband, mother is approached before this.
Why? I am asking you. Why the
Because,
husband
my
is
lord,
not
that is-
approaching?
my lord,
The mother is approaching.
mother is approaching because, my lord, the husband and the victim some dispute regarding family dispute.
Yes.
Thereafter, my lord, in June, May is missing. In June, one telephone calling from the Kolkata that she is in Kolkata. But police authority, I informed the police authority. Police did not take any step. Thereafter, in October, my lord, I made an application before the SP Jalpaiguri. Thereafter, no action has been taken. Thereafter, my lord, I filed this
When,
petition.
from when she was missing?
8 May 2025.
And you have lodged a complaint in October? Why?
9th May. 9th May, next day.
Oh, you have lodged a complaint?
Complaint. No action. Thereafter, I informed the SP Jalpaiguri for my grievance. Thereafter, after filing this petition, police authority recovered the girl, recovered the victim woman, and victim recovered, but she stated something in the police, and thereafter she left the.
What she stated before the police?
Nothing. Nothing information has been given by the police authority.
Yes.
Only telephone
Lordship,
instruction.
I am seeking for 1 day accommodation only, Lordship.
What steps have
For-
been
Yes,
taken,
that is why I am only seeking for.
complaint has been lodged.
Complaint has been
Person is
lodged
missing.
from Rabindranath Roy, Lordship.
Yes,
Yes.
husband.
Lordship, I will come back with instruction. Kindly fix the matter and tomorrow I will come.
আরে ঘুরে ফেলছি শুধু আমাকে ইনফরমেশন দাও এটা
The petitioner alleges
এসেছিল।
that
শুনে নিচ্ছি।
her major daughter, her major married daughter
Married daughter.
was missing on an,
8 May
since
2020.
May 8, 2025.
Yes.
And immediately on the following day, the petitioner lodged a complaint.
No, husband of the
Immediately on the following day, the husband of the
victim.
daughter of the petitioner lodged a complaint before the before whom?
Before জলপাইগুড়ি কোতোয়ালি
Before the inspector in charge, Kotwali police station. But no steps have been taken by the police authorities till date. To stop the learned advocate appearing for the state prays for a day's accommodation to take instructions to stop list this matter tomorrow under the heading for orders. Yes, next.
My lord, item number 6, I am for the petitioner. My lord, this matter pertains to transfer of a school teacher. My lord, I have applied for my general transfer application. My lord, school already issued the NOC. Now, due to suspension of portal, the application is stuck in the school authority. So I am only praying, let the school, since the school authority already issued the NOC, that is, your lordship may see page number 23 of my writ application. In transfer application, my lord, page 20, it is continued till page number 24, and page number 23 is the part of the school authority. That school authority has no objection in respect of my transfer application dated 12th September 2025.
Yes.
My lord, page 23, your lordship may turn, kindly turn page 23 once.
Yes, yes.
NOC has given by the school authority teacher in charge
Now,
of so and
now
so
what do you
school.
want?
I am only, my lord, I am only beseech your lordship, later mandamus be issued to directing the school authority to forward the same to the DI, and DI forward
School
to the
authority has
SSC
not
and let the
forwarded.
SSC.
Who is for
No,
the
no,
school
my lord, since
authority?
due to suspension of portal, my lord, I am telling, my lord, service when I am going to, my lord, it is going to affect, my lord, during the course of the day, my lord, my lord, since school authority has issued NOC, school had no objection. My lord, school, due to suspension of portal, school now unable to forward the same until and unless a direction of the honorable court. But this is the position.
The school will forward to the DI.
DI and DI forward to the SSC, and SSC will consider the same in accordance with. My lord, Mr. Sunit Kumar Rai is appearing for the SSC. He is in leg in page number courtroom number 38 in the principal bench. That just informed me.
So DI will forward to the
School Service Commission. And commission will decide the same. Only this much. I am, my
Commission
lord,
will decide on the
Final decision is to be taken by sanction. Transfer order will be passed by the board.
let the commission first decide.
Yes. If the commission decide in favor of the me, then board will issue the transfer order.
The petitioner has paid for transfer on the ground of what
distance, my lord, general ground, general distance ground. I have
On the
stated in my
ground of
awarded
long
in my
distance.
application.
Full stop. The learned advocate appearing for the petitioner submits that the school authority has already given their no objection for transfer of the petitioner. However, the application, however, the school authorities have not forwarded the said application to the concerned district inspector of schools. To stop. The learned advocate appearing for the state submits that unless the papers are forwarded to the district inspector of schools, no steps can be taken by such authority. Full stop. The learned advocate appearing for the petitioner submits that the school authority have been duly served.
Yes.
Leave is granted to the learned advocate on record of the petitioner. You
Oh,
have
yes.
affirmed.
Services, ready, it's delivered.
It has been affirmed.
Yes, it has been informed.
Acha, every service file in court today is taken on record. Full stop. None appears for the school authorities. Full stop. Paragraph. After hearing the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the headmaster of the school of Goshani Mari.
Gosaini Mari, my lord,
within bracket HS being
Gosaini
the
Mari.
sixth
Gosaini.
respondent to
Yes.
forward the application of the petitioner praying for transfer to the district inspector of schools. What is BE?
My lord. AC, my lord, it is AC.
You have said BE. District inspector of schools within bracket SE.
AC, secretary.
Kuch Bihar, who shall, upon receipt of the same, forward such application to the fourth respondent within a period of fortnight from the receipt of the application from the school authorities. To stop, the Secretary, West Bengal Central School Service Commission is directed to consider, to take appropriate steps upon receipt of the necessary papers. Full stop. ঠিক আছে, with the above directions, আচ্ছা, to take, বলে দিয়েছি তো, disposed of, take necessary steps as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of the papers from the TI.
My lord, great.
My lord, one indulgence, my lord, one indulgence, my lord, one indulgence, my lord. My lord, your lordship told a direction upon given to the headmaster. My lord, instead of headmaster, it should be teacher in charge. My lord, because my lord, school has no headmaster. Now school is running by the teacher in charge. Otherwise, it creates some difficulty.
Headmaster / teacher in charge করে দেয়।
Yes. Great.
My lord, I am appearing on. Yes.
Yes, record
Secretary
Mr.
was
Rai.
directed to consider within 4 weeks.
Yes, so upon receipt of the papers through the DI.
Grateful, my lord.
Mr.
I'm
Rai,
extremely great.
Hard Mr. Rai, learned advocate for the School Service Commission.
I'm extremely great. Extremely.
Grateful, my lord.
For the petitioner.
Transfer.
Transfer.
Yes.
Lordship, it's a corrected copy supplied.
Who shall consider?
Lordship, the DPSC chairperson of DPSC Kuch Bihar.
DPSC Kuch Bihar.
Lordship, corrected copy is there, Lordship.
Chairperson DPSC Kuch Bihar.
Respondent number 6, Lordship.
Respondent number 6.
This is the corrected copy, Lordship.
Yes.
Lordship, just one in.
Disposed of. Next.
Lordship, 8 also transfer matter, Lordship. The board will be considering authority. Lordship, this is the corrected order.
Board.
Board.
Yes, who is appearing for the board?
Lordship, primary board, Mr. Vishwas appearing, Lordship.
Secretary district, no, it's the Secretary.
Lordship.
West Bengal Board of Primary Education, fourth respondent.
Lordship, Mr. Ratul Vishwas appearing, Lordship.
All right, record the name of Mr. Vishwas.
Also, Mr. Kaushik Chaudhary, Lordship.
Yes, Mr. Chaudhary. Yes, call the next matter.
9 also same, Lordship. Board will be the concerning.
Board.
Yes.
Lordship, Mr. Vishwas and Chaudhary, Lordship.
Secretary West Bengal Board, fourth respondent shall consider. Yes, next.
Lord, I am for the petitioner, my lord.
Yes.
The affidavit service, my lord. The
Yes.
petitioner has been removed by a disciplinary authority, my lord. Subsequently, they have filed the appeal, revision, my lord, thereafter come before your lordship for the, my lord, writ petition. my lord.
All the authorities you have lost.
Yes, my lord.
So where is the scope to interfere
Yes, your lord.
under Article 226? What is the ground?
My lord,
So
kindly
within-
come,
file it in, file it in.
kindly come to page number 23, my lord.
Yes. On what ground you are challenging?
My lord, they have determined, my lord, have inquiry officer has been, inquiry officer had been inquiry officer had been, my lord, employed, my lord, nominated, my lord, at the time of charge sheet, my lord. That cannot be permitted in the law, my
No,
lord.
no, no, I could not follow your submission. What?
Inquiry officer has been, he has been nominated at the time of filing charge sheet, my lord. This is not permitted on the RPF Act, my lord. It cannot be, my lord. Service
Show me that you have taken this point. Before which authority? Show me. Show me.
My lord, one thing, my lord, the written objection may be filed by the author, the respondent.
What written opposition? Show me that you have taken that point, sir. Show me. Show me that you have taken that point.
Kindly, direction.
For none of the authorities you have taken that point.
Kindly, my lord, direction may be given.
No, no, no. No direction, no
My lord,
mechanical,
can
no mechanical direction for filing of affidavits. Please show me.
My lord,
Where is the point?
my lord, kindly,
Because the scope is very limited.
my lord,
Please show me.
my lord, kindly make it not to tomorrow, I'll do, my lord.
No, no, no.
Now,
Not
kindly, my
tomorrow,
lord.
please show me.
My lord,
You are
kindly-
ready in the matter. You are telling the point of law. Please show me
my lord, kindly,
from
my
the
lord.
facts.
I'm not that much of prepared, my lord. Kindly make it not to, my lord. This is service of a man.
Yes, you are appearing for the respondent.
Mr. Sweet Tumojan, DSG will appear.
Yes.
He is on the web.
Show me the order of the disciplinary authority.
Yes, sir. Page number, annexure P5, page number 56. my lord.
Page number
56. P56. my lord.
56. Yes.
My lord, kindly make it not to tomorrow, I'll do. my
No,
lord.
no, let me see.
Yes,
What is
sir.
there? What was the charges against you?
Charge, my lord, kindly come the charge sheet, my lord.
No, no, show me from the final order. I think charges have been recorded there.
But charges when have been recorded, which is not part of the charge sheet also, my lord. The punishment also given, my lord, some other.
Show me your representation dated 4th of April 2024.
Well, kindly make it not to tomorrow, I'll do, my lord. Tomorrow, my lord, kindly. I'm not that much of prepared, my lord.
What you have not done that much?
My lord, kindly, my lord. Well, I was.
Sir, you have admitted your guilt. Show
Sir.
me your representation dated 4th of April.
No, that is
It
not.
has been recorded by the authority. You have accepted your guilt and you have paid for exoneration.
My lord, that copy, my lord, kindly, that is also.
Show me that copy.
My lord, kindly,
Representation.
my lord, not today, my lord. Tomorrow I'll do everything, my lord. Kindly, my lord, not today. Kindly, my lord. This is the service of a man, my lord. Service of a man, my lord. Kindly make it not.
Service of a man, sir. This
Tomorrow.
kindly come to page 57.
My lord, that.
Under column number A and B, all your conducts have been recorded there.
My lord, I have.
Previous instances under
My lord, kindly make it, my lord, I will categorically, I will, my lord, answer your every question, my lord. Kindly make it not to tomorrow, I'll do, my lord. Kindly, my lord.
the yes, you are appearing for
Yes, my lord.
Respondent.
the
Tridip
petition.
Shah. Tridip Shah.
The petitioner has challenged the order passed by the disciplinary authority, which has been affirmed by the appellate authority, and the revision petition against the order was also dismissed. Full stop. The what was the penalty? Removal. Removal or dismissal?
Removal from service.
Show me where is the petitioner was inflicted with the punishment of removal from service. Full stop. In view thereof, there is no scope to pass any interim order. Full stop. Let affidavit in opposition be filed within a period of 8 weeks from date. Reply thereto, comma, if any, be filed within a period of 4 weeks thereafter. Parties will be at liberty to mention this matter under the heading hearing after the period fixed for exchange of affidavits. After the period fixed for exchange of affidavit is over. Next, call the next matter. Yes.
Your Lordship, in this matter, service has not been completed. and
What is the matter? What is the matter? Please, what is the
Even I
matter?
have received the brief today itself.
Yes, yes.
The tentative date is 17/11.
1711. Yes, what is the matter? What have you prayed for in this writ petition? Please tell me. Let me see whether service is necessary or not. Yes.
My lord, we are on instructions, my lord, we do not have the brief as of now.
The learned advocate appearing for the petitioner submits that the service of the writ petition has not been effected upon all the respondents. First up, list as paid for by the learned advocate for the petitioner, list this matter before the next available circuit bench. Petitioner is directed to complete the service upon the unserved respondents in the meantime and file an affidavit of service on the next day. Call the next matter.
12 Lordship, I am for the petition.
My lord, item number 12, my lord, I am appearing for the university.
Kindly
my
make
lord.
it a
I am
short
appearing for the
passover,
university.
Lordship. Learned
My
AG
lord,
and
then,
Mr.
my lord,
Naban
kindly
Kupal
keep
will
it
appear in
mandatory.
this matter, Lordship.
Yes, what is this matter, Mr. Dhar?
Lordship, matter relates that the petitioners are the working as professors of Kuchbihar Pancharan Bardama University. Subsequently, they have come through an advertisement issued by the Vishwabharati University. The petitioners want to participate.
Who is for the university?
Mr.
My lord, I am appearing for the university.
Oh, you are
I
appearing
am
for the
appearing for
university.
the
Yes.
My only prayer is that, Lordship, in the advertisement issued by the Vishwabharati University, they said that the already persons who are engaged in some other government college, they require.
Have you annexed the advertisement? This page?
Next it is at page, Lordship, 30. Then the relevant portion is at page 46. Item number 16. That candidates already in employment of government, autonomous body, university, other government funded organization shall apply to procurement or submit formal no objection certificate. Now I need to submit a no objection certificate.
No, under serial number?
16. Page number 46. The advertisement starts from page number 30.
No. Relevant part.
Yes. 16.
Yes.
16.
Thank you. You have marked it with orange ink marker. Thank you. Yes, candidates already in employment.
I need to.
No objection certificates during the interview if called for. Yes.
Accordingly, Lordship, there are 6 petitioners, Lordship. I have paid all the court fees. Now I have applied for all.
Court fees for all.
I have all.
Yes.
Now from page number 57, Lordship, I have prayed before the registrar of the Kuchbihar Pancharan Bardama University for grant of no objection certificate. Now, if Lordship, I take page number 57.
What happened? Rejected?
Not rejected. They said
no,
only the employer is the competent authority.
Yes, Mr. Chaudhary. Why are you not issuing the no objection certificate?
No, my lord. We are always, my lord. We want to issue what difficulty is, my lord. It is the executive council and the vice chancellor who is the competent authority. They direct the registrar to issue the no objection certificate. My lord, similar matter, my lord, petitioner is, I am grateful, my lord, I am thankful to my learned friend, page 70. Similar issue was cropped up, and my lord, similar issue was cropped up. Page 70, my lord. Similar issue was cropped up before this university. From that time, vice chancellor, this university is running, my lord, without vice chancellor. So this is the difficulty. So, my lord, my humble submission is this, my lord, if your lordship passes order in light of this judgment, my lord, university will do that.
So registrar shall grant the no objection, and if a regular vice chancellor joins,
yes, my lord, that will be
shall be taken with his approval.
Yes, my lord. Yes, my lord. In this line order may be passed, my lord, then university will be, my lord, happy, and petitioner will be also happy, my lord. There is no difficulty.
Both will be happy.
Yes,
both will be happy, my lord.
All right, thank you.
Only thing is, Lordship, kindly direct them not to take much time because page number 72 I have annexed, because the first petitioner, he has already been called for interview on 15th November. 15
Yes,
November.
Mr. Chaudhary, within 15 November you have to do because one of the petitioners have been called for interview on 15th.
Today,
So,
my lord, we are on কত তারিখ আজকে? Today, my
We
lord,
are on 6th.
6, so do that within 13th.
yes, my lord, yes.
Do that within 13th.
Within 12 because 13th
13th is an unlucky day.
No, 13th he will be traveling to Vishwanath University.
Why? How much time it takes to?
Lots of the teachers they will.
My lord, today, my lord, my lord, mail, my lord, there will be no difficulty towards you will send mail, my lord, 13th.
All right, Mr. Chaudhary, do it within 12th. Do it
My
within
lord.
12th.
My lord.
So you are a teacher.
I am an associate. 6 petitioners are there. All are working under the category of associate professor.
All are associate professors.
Associate, assistant, and professor. They are working as
Or the teaching staff.
teaching staffs.
The 6 petitioners, Ashun, 6 petitioners have joined together in this writ petition and have prayed for a direction upon the authorities of the and prayed for a direction upon the, you have said the respondents, upon the authorities of the which university?
Kuch Bihar
Panchanan Burma University.
Of the Kuch Bihar Panchanan Burma University to issue a no objection certificate in their favor for participating in the selection process / interview for appointment
to the post of professor, associate professor.
to the post of teaching staff in
Vishwabharati post.
all in
All
Vishwabharati.
in
All of you will go to Vishwabharati.
We are only trying our luck.
What this university will do then?
They have enough teachers. We
They
are
have enough.
trying our luck.
All right. You all Vishwabharati University. Mr. Dhol, honored advocate, appearing for the petitioner, submits that you have made a representation.
I have made given them representation asking for NOC that starts from
Mr. Dhol, honored advocate, appearing for the petitioner, submits that in spite of representations being submitted before the registrar of the 5th respondent university, no steps have been taken.
No, they have stated that only the employer is the competent authority to issue the NOC.
5th respondent university, the no objection certificate was not issued on the ground that the registrar is not the employer and it is the vice chancellor who can only, who is the competent authority to give no objection certificate. Mr. Dhor placed reliance upon a decision of a coordinate bench, placed reliance upon an order, dated September 4, 2023, passed by a coordinate bench in WPA 18186 of 2023 in the case of Dr. Jyoti Prasad Roy versus State of West Bengal and others in support of his contention that the coordinate bench directed the registrar to issue the no objection certificate. Full stop. Paragraph. Mr. Chaudhary, honored advocate, appearing for the 5th respondent, for the respondent number 5 and 6, submits that presently the
university is running without
the university is running without a vice chancellor. Full stop. He therefore submits that the he submits that for such reason the registrar the registrar could not issue the no objection certificate. Full stop. This court finds that the coordinate bench in the case of Dr. Jyoti Prasad Roy Supra directed the registrar to grant no objection certificate within a specified time, and if a regular vice chancellor joins the university in the meantime, the decision shall be taken with his approval. Full stop. In view thereof, WPA number such and such stands disposed of. by directing the registrar to grant no objection certificates, inverted comma moddhe, to the petitioners if they are otherwise entitled to within a on or before November 12, 2025. And if in the meantime the regular vice chancellor joins the university, the approval of the vice chancellor shall be taken prior to issuance of the no objection certificate. Yes, with the
My lord,
above
one paragraph may be added, my lord, since I have not filed maybe affidavit in opposition to that allegation.
Since no affidavits were called for, all allegations contained in the writ petition, the allegations contained in the writ petition shall not be deemed to have been admitted by the respondents.
Lord, Mr. Nirmal Rai is appearing with me, my lord. Our name may be recorded, my lord, because we are appearing virtually, my lord.
Please put it in the chat box. Yes.
Yes, my lord. We have
Please
given.
give your appearances.
I'm grateful, my lord. I'm grateful, my lord.
Atta kore din. Learned Additional Advocate General, assisted by Mr. Pal, represents the state. He submits that the university, that the Kuch Bihar such and such
Panchanan Morma.
university is the answering respondent. Yes, next.
I'm grateful, my lord.
Yes. Yes, Mr. Dor, what do you want? You are not there. Yes, who is appearing?
Returnable date is on 18th of November. It was served, my lord, day before yesterday.
None appears for the petitioner at the time of call. No accommodation has been sought for either. First of the learned advocate appearing for the state submits that in the notice served upon the state, it has been indicated that this matter will appear on
18th of November.
18th of November 2025. First up, list this matter before the next available second bench, subject to the convenience of the bench. Yes, next. Yes, yes. Who is appearing? Yes, who is appearing in this matter? None appears for the petitioner at the for the respondent. None appears for the petitioner at the time of call. No accommodation has been sought for either. State is represented by the learned additional advocate general. Since the petitioner is not represented, WPA number such and such stands dismissed for default. Call the next matter.
So child manager will appear in this matter, my lord.
Lordship, am I audible?
Yes, yes, audible, visible, both. Yes.
Grateful, my lord. Lord, 15 I beg to appear for the petitioner, Lordship.
Yes, what do you want?
Lordship, 15 is a matter that is police inaction. A case has been registered under section Lordship 64(1), that is P1 13 page annexure P1. Section 64(1), 1152 and 3512 and section 31A of the Scheduled Caste and Scheduled Tribe Act, Lordship. Lordship, my allegation is the accused, since the date when, Lordship, the FIR has been registered, the perfunctory investigation has been carried out. And since then, I has been threatened to withdraw the complaint. I have made complaint in this regard, though I must indicate very candidly in page number 16, 17, 18, though I've just completely this is my fault, Lordship. I have my junior is there. She will hand over. She can hand over the copy, but the email has been forwarded to the SP office and to the local police. They
Yes,
also
what is
has
your instruction?
My lord, first of all, my lord, the returnable date is on 70. Second, my lord. November. Second, my lord, if my lord comes
So
to
Banerjee,
1090.
you are in the
17th of?
presentation form, you are mentioning
Yes, my lord.
6th of November as the date of appearance, and in the service copy, you are giving the date of 17th of November.
Actually, there may be, may I just indicate, maybe that will be a typographical error, but nothing else.
Typographical,
Because-
Mr. Banerjee,
Yes,
most of the matters, these are being done. I do not know the purpose of that.
because
You are giving
here is
deliberately a date
no
of presentation,
private-
in the presentation form, the date of enlistment and a different date.
may,
That is after
may
11
I just
days.
indicate one thing? Yes, Lordship, may I just indicate,
You file your reports.
Lordship, may I just indicate another thing
Mr.
that
Banerjee,
may
let
be,
them file the reports because.
yes. For another purpose, may I just indicate, Lordship?
Yes.
Because Lordship, the SCST Act, that is the SCST Act, Lordship, in my opinion, Lordship, in my knowledge, that is, Lordship, proper section also has not been given. The
Mr. Banerjee, I
2As.
cannot go into that. Let the report come.
Yes.
Or
I have
I
just
will
indicate
put it
that.
before the next available circuit bench.
No,
Because
only
you have
kind of
mentioned the
a
date of.
report. A
They do
report
not
may
have
be
any
called for.
instructions.
A report may be called for.
The petitioner alleges that no steps have been taken by the police authorities accepting registration of an FIR pursuant to the complaint lodged by the petitioner. First up, the learned advocate, Mr. Shah, learned additional government pleader, appears for the state, learned additional government pleader appears and submits that he has not yet received instructions in the matter, as in the notice it has been indicated that this matter will appear only on 17th of November 2025. First up, in view thereof, the petition, which respondent shall file, Mr. Shah?
My lord,
The
women, OC, women PS.
Mr. Banerjee, however you pleaded, women police station,
Yes,
not
Lordship.
respondent.
Because the FIR was lost from there, the respondent 3, the woman
Has it
police
been
station.
correctly imputed? I am asking you, Mr.
No,
Banerjee.
Lordship. Liberty may be given, kindly.
Inspector in charge or the officer in charge?
Officer in charge.
In view thereof, the officer in charge, women police station, Kuchbihar Shodor, is directed to file a report in the form of an affidavit as to the progress of investigation. First up, let such report in the form of an affidavit be filed on 17th is the date.
Reopening day of the.
Lordship, the threat perception also, kindly.
On November 17, you cannot file it within, because you can affirm the affidavit, can file it on the next day.
My lord.
You will be here, Mr. Shah, or you will not be here. All right. On or before November 20, November 20, 2025. Yes, একদম উপরে করে দেবেন. On the prayer of Mr. Banerjee, learned advocate for the petition, leave is granted to the learned advocate on record of the petitioner to correct the typographical errors in the cost title of this writ petition.
Lordship, only one indulgence.
Yes.
Lordship, only one indulgence. As your Lordship
Yes.
pass an direction for an report in this regard of the investigation, my Lordship, my another prayer is has been threatened, Lordship.
Mr.
They may be
Banerjee,
protected and
that prayer you make on that date, because
grateful.
this much I have directed, I could not have, because
Grateful.
17th you have given the returnable date.
Lordship,
Yes, next.
Grateful.
Deeply obliged, man.
Yes. Yes, who is appearing?
I am appearing, last week your lordship considered this, this is a police in action matter,
I've considered, yes, what happened?
we withdraw it subsequently, there's an order under 151 for the police to, enforce the order of injunction, which is, not being done by them. So, the order passed under section 151 is at page 81.
Where is the order of injunction, Mr. Ghosh?
I'll just press. The order under 151 records the order of injunction.
No, please show me the order of injunction.
Yes. Ah, 31.
Page
31, my lord.
31, yes. Yes, who is for the private respondents?
The private respondent has not been served. My lord,
Has
I
not
am
been
as a
served.
candidate before Lordship, my lord, has not been served.
Yes. Now what do
My
you
lord,
want
Mr.
now?
Miss Basu is there for the state, my lord. Police has conducted an inquiry, my lord. Kindly see the report. Absolutely ridiculous.
Where is the report?
My lord, page 82. My lord, the private respondents are saying that alleged persons violated the court order and stated the police admits that alleged persons violated the court order and stated that they have honorable high court orders in this matter, but they did not produce.
Yes, what is their instruction? What steps have we taken?
Lordship, first of all, the returnability is 17/11/2025. Lordship, if Lordship come to the page 82, this report has been filed before the Civil Judge Junior Division,
Yes.
Jalpaiguri, Lordship.
Yes.
And already this is the admitting fact that the.
Oh, this was filed before the civil
Yes,
judge
Lordship.
junior
Yes,
division.
Let the Civil Judge Junior Division will decide the matter. Lordship, already we have submitted the report before them. And we have complied the order, we have issued the, initiate the prosecution case against the private respondent.
Till
That is
date,
the.
an subsisting order of injunction is passed by the civil court. You have to obey the order
Yes,
of the
Lordship,
civil
we have
court.
OPE and we have initiate prosecution case against the.
You have made any
Yes, Lordship.
representation to the police authority?
Yes.
Complaint, where is
Well,
that?
several of them.
No. What is your prayer here?
My prayer is, Millard,
Deputy police personnel, Lordship. Let the civil.
Posting police personnel.
Yes, Lordship.
Millard, if required,
Let
we'll
the civil-
deposit the cost, no difficulty.
Lordship,
You
let
apply,
civil-
who is the appropriate authority?
So the superintendent of police.
Apply before the superintendent of police, pay police costs, that will be granted.
Yes, we are ready to
But
deposit.
Lordship, let the civil court will decide the matter because already we have informed this.
Madam, that is one way of looking at it,
Yes,
but he's
Lordship.
entitled to, I think police regulation 662 or
Yes.
669.
Yes.
What is the relevant regulation?
61.
না 61 না পরের দিকে
662 or
আমি এক্স্যাক্টলি মনে
669.
পড়ে না আমার Millard, there is a provision.
So let him apply, you consider that, take steps. If he is willing to
Lordship, then-
deposit police cost, take police cost, post police personnel. Ashun, the petitioner has alleged that the police authorities have not taken any steps pursuant to the order of injunction
Lordship,
passed by the
small indulgence, Lordship. Then I will come back with a report, Lordship, whether
What?
they have deputed anything or not.
whether
the-
they are,
Depute any police personnel or not, Lordship.
you will not depute any police officer. Without cost, you will depute.
No, Lordship. What measure
Don't
they
say
have?
that, let them pay police cost, then let them make an application. I'm not directing you now to
Lordship.
civil court. First up, Mr. Ghosh, learned advocate, appearing for the petitioner, submits that the petitioner filed, what was the suit for?
Millard, declaration and injunction.
Filed a suit for declaration of title and permanent injunction, and the learned trial judge passed an ad interim order.
Yes, sir.
Ad interim order of injunction restraining the private respondents from disturbing the peaceful possession of the petitioner in respect of the property in question. So he further submits that since the police authorities were not obeying the order of injunction, the petitioner filed an application under section 151 of the Code of Civil Procedure, and the civil court allowed such application, directing the police authorities to comply with the order passed by the civil court. So Mr. Ghosh submits that no steps have been taken by the police authorities in spite of an order passed by the civil court on an application under section 151 of the Code of Civil Procedure. So the learned advocate appearing for the state submits that the police authorities have already filed the report before the Learned Civil Court, and the Civil Court be directed to consider such report and pass orders accordingly. First up, in reply, Mr. Ghosh submits that the private respondents are creating trouble and are disturbing the peaceful possession of the petitioner, and the petitioner is willing to deposit the police cost for deployment of police personnel at the property in question. First up, paragraph, after going through the materials on record, this court finds that the Civil Court has directed the officer in charge of Rajganj Police Station to comply with the order passed by the Civil Court and to see that such order is not violated in any manner, causing any serious breach of peace there. First up, it is the duty of the police authorities.
Lordship, we have already complied.
It is the duty of the police authorities to comply with the subsisting order passed by the it is the duty of the police authorities to comply with the order dated 13th of March 2025 unless the same is modified or vacated by any competent court of law. First up, since the report has been filed by the police authorities before the civil court, it will be open to the civil court to consider such report and pass orders accordingly. First up, it will be open to the petitioner to file an appropriate application / representation before the competent authority under the relevant regulations, praying for deployment of police personnel. First of all, if such a representation is made before the appropriate authority, such authority shall consider such application and take steps in accordance with law. The above observations, such and such disposed of.
Great.
Next.
Item number 17.
Lordship, I am for the petitioner. Lordship, I am led by Mr. Amritam Mondol. Lordship, kindly place this matter in the next circuit, Lordship.
Before, you are led by?
Mr. Amritam Mondol.
Yes, where is Mr. Mondol?
Lordship, kindly leave this matter in the next circuit, Lordship.
Why? Why next circuit?
Lordship,
What is this matter? Please let me see.
he is to come, he is to do the matter physically, Lordship. The petition is voluminous.
On the last circuit also he appeared virtually. He's very
Lordship,
comfortable in appearing virtually.
as this matter is voluminous, that's why several
You have
annexures
made it
are there.
voluminous, but the issue may be a simple one. Yes, Mr. Shah, what is the issue?
My lord, the tragedy is this. After getting this brief, I have tried my level best to contact DFO.
Yes.
Today.
What is the order on the challenge, madam? You are the
Lordship.
advocate on record. Please show me the order impugned.
Lordship, it is at the last page. It is the DFO's order.
Yes,
Lordship,
please show me that. Page.
Lordship, the main
Please show me the page.
Lordship, the main brief is lying with my senior Lordship. Kindly make it next circuit.
Yes, not. Where is Mr. Mondol? Ask him to join
Lordship,
at
kindly.
12. Ask him to join at 12. Otherwise, I will dismiss this. Ask him to join.
Lordship, kindly.
At 12. Yes, at about a show. Yes, next.
My lord, I am taking a leave to appear virtually, my lord, in the next matter. Item number 18, my lord.
Yes.
My lord, this is regarding cancellation of registration due to non-filing of return, my lord. A
Who is
similar order
appearing?
may be filed.
GST, WBGST or CGST?
WBGST, my lord. WBGST, my lord.
Yes, madam.
Well, at 6 months return, they did not.
Give me the order.
My lord, page number 13, my lord. Annex
Wrong call,
P4.
where is that?
That one, I don't.
You do not have, Ashun.
Well, I didn't bring the order. I didn't bring the order.
Ashun. This application under Article 226 of the Constitution of India is directed against an order dated December 24, 2024, passed by the
My lord, Assistant Commissioner Jalpaiguri
passed
charge,
by
my
the
lord.
Assistant Commissioner, Siliguri, charge being the second respondent, thereby cancelling the registration of the petitioner for
Page 11, that is failure to furnish return for continuous period of 6 months.
on the ground of failure to furnish returns for a continuous period of 6 months. Full stop. The learned advocate appearing for the petitioner submits that the that it is now well settled that a petitioner is to be given an opportunity to remedy the breach. Full stop. Hard Ms. Sarkar, learned advocate for the WBGST authorities. Mr. Shah, you are leading her. Hard Mr. Shah, learned additional government pleader, assisted by Ms. Sarkar for the WBGST authorities. First of all, after hearing the learned advocates for the respective parties, this court is of the considered view that the interest of the petitioner and the revenue shall be protected if the petitioner is afforded an opportunity to remedy the breach. Full stop. In view thereof, WPA number such and such stands allowed, and the order dated December 24, 2024, passed by the second respondent is set aside, subject to the condition that the petitioner shall file the returns, pay / deposit the tax, interest and penalty for the entire period of default, and if the same is paid, the registration of the petitioner shall be restored by the concerned jurisdictional officer. First of it is, however, made clear that in the event the petitioner fails to comply with the directions mentioned herein before, this order shall not inure to the benefit of the petitioner, and this writ petition shall automatically stands dismissed without any further reference to this court. To stop. In order to ensure compliance of the aforesaid directions, the respondent authorities are directed to open the portal so that the petitioner can file returns and remit the tax, interest and penalty within the time limit mentioned here before. Time limit ta bole deben, shall file returns, pay Yopurer party within a period of 3 weeks from the date of receipt of a server copy of this order.
My lord, humble prayer, my lord, that will be, my lord, not penalty, but late fee, my lord, because penalty is not imposed, late fees are imposed, my lord, for filing of it.
Penalty na
Deeply obliged, my lord.
Yes. Call the next matter. 19, yes.
Item number 19, my lord, I am for the petitioner, my lord.
Yes.
My lord, I am appearing for the DPSC Kuch Bihar, my lord.
My lord, petitioner pair for transfer on medical gown, page 28, my lord.
Yes, who will consider?
My lord, Secretary West Bengal Board of Higher Education. Respondent number 4, my lord.
Respondent number 4.
Yes, my lord.
Yes. Transfer. Respondent number 4 to consider.
Yes, my lord. On medical gown.
Medical gown. Yes. Next.
Yes.
Item number 20, I'm praying for a short pass over, your lordship.
Why? What is the respondent person? What is this issue?
This is not maintainable, lordship.
Why?
They are come for the adjudication order. There is the appeal.
Pass over, your lordship.
Appeal remedy is here, lordship.
The Learned Counsel is on his legs, your lordship. Kindly fix this matter at 12.
It's only the factual matters, lordship. Page 53.
Who is the learned counsel?
Dr. Navin Badish, your lordship.
Pass over.
English passable.
Short password, yes.
Great, your lordship.
Yes, how much short?
With 10 minutes maybe, your lordship.
All right, yes, call the next matter. 21, yes. Yes.
21, I am for the petitioner.
Yes.
Lordship, I am praying for short passover. Mr.
Why?
All
All matters
will
cannot be popular.
sending.
Yes, yes, what is this matter?
The violation of the building rules and carrying on construction.
Who is carrying on construction?
Lordship, municipality
Right.
is sending the brief, your lordship.
You are for the municipality?
Your lordship.
All right, private respondent is making illegal
Yes,
construction.
yes, yes.
Where is your representation?
Representation that till since 19 and lastly on 18/10/2025.
Which page?
62. And since
Yes.
2019.
You are for the municipality.
Municipal, your lordship.
You consider this?
Lordship, municipality is sending the brief. Brief has not come.
In the meantime, my lord, interim order of stay be given because the construction work is still going on. Even after receiving the
Petitioner alleges that the private respondents are carrying on illegal construction. Have you served upon the private respondents?
yes.
কি বললাম? The petitioner alleges that ওই affidavit সার্ভিসটা উপরে করে দেবেন। Affidavit service filed in court today is taken on
Oh,
record.
affidavit service.
তারপরে লিখেন petitioner alleges that the private respondents are carrying on illegal construction at what premises? Where have you where this illegal construction is being carried on?
In his premises, his purchased land.
Where is have you mentioned that?
Yes. Mohamayapara.
RS plot number 1219
Yes, my lord.
are carrying on illegal construction work. Full stop. The learned advocate appearing for the petitioner submits that a representation dated October 18, 2025 has been submitted before the municipal authorities, but till date, no steps have been taken by the municipal authorities in that regard. Full stop. Yes, you are for the private respondent. Yes, what is the submission? Full stop. Heard the learned advocate for the respective parties. Full stop. Since the petitioner has lodged a complaint alleging illegal construction, it is the duty of the municipal authorities to cause an inspection of such premises and to take steps in accordance with law. Full stop. In view thereof, WPA number such and such stands disposed of by directing the municipality by directing the Jalpaiguri municipality to by directing the concerned authority of the Jalpaiguri municipality to depute competent officials for the purpose of inspection of the property in question, and if it is found that any illegal construction is being carried on, appropriate steps in accordance with law shall be taken, which shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the date of communication of this order. Full stop. In the event the municipal authorities shall take steps to restrain the private respondents from making any illegal construction at the premises in question.
My lord, the premises, it is better to mention the holding number and ward number.
Holding number, what is the holding number?
52 slash
52
A
slash
A.
slash 79 slash B.
হ্যাঁ,
আচ্ছা করে দিন ওই প্রথমে যেটা বলেছে না
ward
petitioner
number
allege-
16.
alleges that the private respondents are carrying on illegal construction. Construction what? At holding number 52 slash capital A slash 79 slash capital B within what number?
16.
Within what number 16 of the Jalpaiguri municipality.
Municipal.
Yes, disposed of. Next. Yes, yes.
My lord, I'm for the petitioner, my lord.
Yes.
My lord, this was the matter which I mentioned. My lord, may I make my lord, it's on 4th, my lord, when we have served a copy of my writ petition to all the respondents, my lord. But when we approached the learned additional government pleader's office, my lord, he refused to accept service, my lord.
All right, that is the matter.
My lord, let me get report. Yesterday at 5:30, clerk approached.
Day
All
before
right,
yesterday.
all right, Mr. Sar.
Yesterday. Then he said that the matter was mentioned and leave is given. I asked this court, I require about the court officer. He replied me.
No, my lord, it was not the
All
lead,
right.
my lord, I had mentioned the matter since the
All right,
urgency, my
Mr.
lord.
Sar, let me hear it. Yes.
My lord, the matter is very short and innocuous. Prayer has been sought, my lord. The petitioner herein is the owner of 4 kathas of land, wherein he is operating a hotel, my lord, a small hotel. Now, my lord, on Friday, my lord, the authorities of the SJDA, accompanied by police authorities, without any notice, my lord, they have come and tried to oust the petitioner from his land, my lord. My lord, when they inquired, they have informed that the land has been acquired. My lord, he is the owner of the land since 2005. My lord, he had mutated his land in his name. In 2011, the land was duly converted by the office of the land reforms officer, my lord. But till date, they could not show any notice that has been served upon the petitioner saying that this particular land of the petitioner has been acquired, my lord. My prayer in this writ petition is, my lord, the petitioner should not be ousted without following the due process of law, my lord. If the land is being required, my lord, there is a due process under the Land Acquisition Act and in the 2013 Act, my lord. But without giving any opportunity, without sending any notice, without awarding any compensation, my lord, if the land is acquired, my lord, the petitioner shall suffer irreparable loss. And my lord, this is the short writ petition, my lord, and under urgency we have filed this, my lord. That because they had given 2 days time to remove all the materials from that land so that they would take the possession, my lord. I have served all the respondents, my lord, in person, my lord. My lord, kindly seize my affidavit
Maybe
of
the
service,
GP
my
has
lord. Even
not
in
been
Darjeeling,
served,
I have effected.
but you have special land acquisition officer.
Yes, my
has
lord, I
been
have served,
served.
my lord.
Special land acquisition officer has been served.
ADM has been served, my lord. DM has.
Yesterday was a holiday.
Day before yesterday, I have served, my lord. On my lord, even the police have served on 3rd, the day of filing. My lord, I
Show me
went.
your affidavit service.
My lord, I have served. I have given my affidavit of service, my lord. Every respondent has been served in their office, my lord. But the learned AGP did not accept the brief, my lord, despite request.
Mr.
You can,
Stop.
sir, you have
Don't
a
get
senior
agitated.
responsible officer of the state, sir. Accepting service is your duty, sir. Accepting service is your duty. I had to serve him through email also. No, I had mentioned. Leave was not the words I had mentioned, and Honorable Court said it will appear as per my representation reflected in my presentation form. It was on 6th. My lord, what they do not accept the service, my lord, after 2 o'clock. My lord, after 2 o'clock, AGP office does not accept service, my lord. That is very unfortunate, my lord. No, my lord, kindly.
Yes, all right, Mr. Shah, please give him a copy.
My lord, I have
Please give him a
copies ready,
copy.
my lord.
Yes, please take instructions, whether any steps have been taken.
My lord, in the
Because,
meantime, my lord, it should not be, he
one-
should not be ousted, my lord. That's my prayer.
One thing is that you cannot take steps without due process of law. So please see whether you are contemplating anything tomorrow, by tomorrow.
My lord, SJD is the concerned. SJD is the concerned.
Who is for the SJDA?
They have been served, my lord.
Yes, Mr. Dor, why are you standing there? Your authority has been served.
Then the lordship.
Are you taking any steps? Don't take any steps till tomorrow.
If the matter tomorrow, we shall take instructions.
All right, but don't evict him by tomorrow.
Lordship,
If you say, I will record your undertaking,
Yes,
no,
my lord.
can-
Kindly that be
then I'm
recorded.
passing an interim order.
2 p.m. 2 p.m.
All right, come at 2 p.m.
Deep
Back
here.
off.
2 p.m. roughly. Yes. Mr. Shah, also you take instructions from the special land acquisition authority. Yes. You have given a copy.
Yeah, I've given.
Please give a copy to
I
Mr.
gave
Dhar
both
also.
of
You
them.
have
my
also
lord.
got copy.
Both of them have given.
Yes.
Lordship, item number 23 to 26, these are the same matters. I am for the
Yes.
petitioner, my lords.
Yes,
Lordship
yes.
will just kindly bear with me the facts. This is a very innocuous prayer today, Lordship. I'm in a little bit of slippery grounds. Lordship will kindly just bear with me. The petitioner is a quasi-statutory body, Lordship. They are established under the West Bengal Agricultural Produce Marketing Regulation Acts of 1972, and it is also managed and run under the aegis of the government. Now, Lordship, the issue over here is the non-filing of income tax returns. The petitioner was under a bona fide belief that because they're exempted under the Income Tax Act from filing their returns, they actually did not even file their
Sir,
income
what
tax
are you
returns.
challenging? Please,
Lordship,
what
I'm
is the
telling.
challenge?
Lordship, page 58, order of the appeal court, Lordship.
Order of
Lordship, of the income tax appeal, Lordship. Page 58. Order passed by the Commissioner of Income Tax Appeals.
Yes, so an appeal lies
I'll-
before the tribunal against that.
I'll tell you, Lordship. I'll tell you, Lordship. The reason I'm seeking, Lordship, is a consideration of a prayer made in page 63. A very innocuous prayer. Lordship, I'll tell you, Lordship, why I have come and why I'm before your Lordship today. Lordship, we were under an impression that we do not need to file an ITR. And we have also intimated to them that any other regulatory body which is in the adjacent districts also do not file any ITR. On basis of that, we got a 147 order. We preferred an appeal. The appeal order is there in page 58. Now, Lordship will just kindly take up that order once. Just kindly bears with me, Lordship. Page 59. Lordship just sees the grounds of appeal and statements of fact that they themselves have set out in their order. Page 59.
Yes.
Lordship kindly just takes up 3.2. The appellant is an agricultural marketing committee established under the West Bengal Agricultural Produce Marketing Act 1972. Point 3, any income of the Agricultural Produce Marketing Committee for the purpose regulating the marketing of agricultural produce is totally exempted of Income Tax Act under Section 1026A, and neither needs to
So did you
file
take
any
this
income
point
tax.
before the appellate authority?
Lordship, this is the grounds of appeal which has been laid out in their own order. This is in their own order, Lordship. I'm showing you.
Show me how it has been dealt with.
Lordship, this has not been dealt. Lordship kindly comes to the next page, page 60, the decision. Lordship, the only reason of dismissal is that we have thereafter not pursued the appeal. That is the only reason that my appeal stands disallowed. Page 62, 6.3 is the final decision.
You have not appeared before the appellate
Now,
authority.
Lordship, the only thing is, Lordship's aware that if today I go and file a statutory appeal against this, I would be required to submit and deposit money.
Maybe.
Lordship, that
you
would
have
be
to
a
do.
little. Lordship kindly sees page 63.
No, at the time of filing the appeal before the appellate authority, also you had
I
to
could not.
deposit.
Absolutely. Lordship just kindly sees page 63. What is my request that I want them to consider only because I am a statutory body looking into the marginal farmer's produce. I'm not a private individual and I'm not running away. Lordship
Make
kindly
that
see.
prayer before the tribunal.
I have made the prayer. Lordship kindly
not
sees
here,
page
before
63
the
once.
tribunal.
Lordship
Please
kindly
make
sees.
that prayer before the tribunal.
Lordship kindly just sees page
148
63 once.
notice in
Lordship, I understand.
2023, followed by an assessment.
Yes.
Thereafter, challenge
Yes.
before the appellate authority.
Yes.
Thereafter,
I bow
you are
down.
seeking
I
to
bow
file,
down. I bow down to that.
returns. Please
I
approach the
bow down.
tribunal.
Lordship just kindly sees page 63 once. Just one thing. I have admitted that there
Yes.
was a misunderstanding of the provision. I
Alright.
was unable to
So you have
file.
a very,
Kindly allow
very
me.
good case before the tribunal. Please make that prayer. Ashun. In view, tar aage likho. The petitioner has challenged the notice issued under section 148 of the Income Tax Act, dated
19th April 2023, my lords. Page 25.
19th of April, 2023. Oh, you have not challenged the orders of adjudication
I
here?
I have challenged everything pursuing to that, my lord.
No. Show me.
Lordship kindly sees my press.
Yes. And all proceedings
All proceedings pursuant thereof.
has challenged and has paid for setting aside all proceedings initiated pursuant to the said notice. First stop. The petitioner where is the order of assessment?
Lordship, the order of assessment is page 36, my lords. Assessment order under 147. Page 36.
147.
Page 36, my lord.
Yes.
Under section 147.9, Lordship, please.
কি বললাম? An assessment order under section 147 read with section 144 and 144 capital B of the Income Tax Act was passed on February 28, 2025. Full stop. Petitioner thereafter preferred an appeal.
Page 48, my lords.
Against the assessment order and the Commissioner of Income Tax within bracket appeals dismiss such appeal under section 250 of the Income Tax Act 1961 by an order dated 19th of September 2025. Full stop. Since there is since an alternative efficacious remedy before a properly constituted tribunal is available, and such tribunal is the ultimate authority to adjudicate both on facts and law, this court is not inclined to entertain this writ petition. Full stop. In view thereof, WPA number such and such stands disposed of with liberty to the petitioner to approach the appropriate forum in accordance with law. Yes.
My lord,
Next.
same for the next 3 writ petitions.
Next 3 same. Order
Yes, Lordship.
dates different.
The order dated appeal. The appeal order is the same, Lordship. The notices are in a different date.
I'll
just
23, 24, 25.
Yes, 26 also.
24, 25 শুধু ওই ডেটস গুলো একটু দেখে নেবেন, যে ডেট গুলো বলেছি সেই ডেট গুলো একটু দেখে নেবেন। Yes, next. 26. Yes, madam, 26 you are appearing. 23,
Lordship, 23 to 26. 4 writ petition.
Or up to 26.
26.
Up to 26.
4 analogous matters.
Up to 26 same order. Yes, call 27.
Lordship, Barai is there, 20. If serial number 20, Lordship.
Lordship, for item number 27, I have a very innocuous prayer, Your Lordship, in this
Yes.
matter. Your Lordship, this petitioner is a financially illiterate person. he did not, he filed his returns through one of his PAN cards for the assessment years 2010 to
Yes, who is for the income
2020.
tax authority? Yes,
You
where is
one of-
Mr. Singhania left? Yes, Mr. Singhania, you have a series of matters and you are leaving after doing one matter.
Affidavit of service.
Yes, Mr. Majumdar, what happened to your finger?
Caterpillar attack. CVM alert.
Yes, what do you say? Yes.
Lordship. Lordship, just an innocuous prayer to file the appeal manually. Nothing else, Your Lordship.
Appeal, there is a provision for condonation.
Yes, Your Lordship. Lordship, but time and again, income tax departments have accepted manual and physical appeals. Lordship, we personally have filed. Over here as well, we have tried to file Form 35, but they didn't receive. They are not acting upon our physical service. So for that reason, we are approaching this honorable court for a direction.
Like you can file online. File
Lordship,
online.
that is the main point in this petition, that this petitioner is facing problem with his PAN linkage with his Aadhaar card. So for that reason, he could not file his appeals on time online. However, we have shipped off our Form 35s as soon as we were aware of the assessment orders.
So now, then now you can file your online.
Lordship, both the PANs are inactive. They are not working on the income tax portal.
Mr. Singhani, then in this case, what can be done? Mr. Singhani, there are two ways of looking at it. If you say no, physical filing as well as online filing in this case cannot be permitted, then writ is maintainable. I will entertain the writ. Choice is yours. If there is no remedy, he cannot approach the appellate remedy, then writ is maintainable. Court has the discretion to entertain the writ petition. If you say yes, physical filing will accept, I will direct them to file physically. Section 5, whatever decision you can take. I'm coming after 5 minutes.
No, my
Take
lord,
instruction.
the honorable court direct that is paramount. Yeah, any direction of the court has to be obeyed.
No, please take instructions.
I will come
Please
back.
take instructions. Come at when can you come back? At 1? Come back within 1. Take instructions. I will allow her only to file physically. Accept that with if section 5 or whatever it may be. You take a decision. I am not
No,
on
I
merit.
understand, my lord.
Take instructions.
Nothing
Come back.
on merit, only to allow them to avail that.
Yes, because if you have to allow either online or physical. She says that online will cannot be accepted because there are some discrepancies. PAN is inactive or such and such. If that is there, because online those he has to fill up all those entries.
By verified OTP.
Yes. So if that is not possible, then
we'll come back.
I'm fixing it at 1. Please take instructions from the concerned
Why not?
authority. I will only direct filing. I'm coming after 5 minutes.
Grateful, Your Lordship.
Yes.
Item number 70.
Yes. Yes. Yes, Mr. Mundol.
Your lordship had fixed the matter at 12, my lord. I just got the brief. If your lordship keeps it tomorrow, my lord.
Yes. All right, tomorrow. Kalke rekhe.
Tomorrow, your lordship.
Yes, next.
Deeply obliged.
My lord, apologies for not appearing when the matter was called. My lord, this also matter, this it pertains to service tax matter, assessment year 2015-16 remedy for repeat. But why we are here, that's a different issue. And just consider one aspect. There are 3 points of challenge that we have raised. I'll place the documents once. 3 points of challenge. One, my lord, the paramount challenge why we are before the High Court is that it's barred by law. Not the point of limitation, extended period suppression, that's not. My lords, we are carrying judgments where my lords have heard the suppressions cannot be per se said that 26A is coming onto record, suppression. That's not. That's a different thing. But here we say it's barred by law under section 73 capital 4 B, A, B, small clause B. My lord will see, take to the provision. I'll just, my lord will take.
Limitation is a mixed question of law and fact.
No.
Better the authorities decide that.
No, what has
Cannot the appellate authority cannot decide the issue of limitation?
No, my lord, it can, but my lord, since the period of limitation, my lord, is essentially a matter of jurisdiction. My lords have
The
held.
appellate authority can also decide.
Can
the
also decide.
Question of jurisdiction. It's a longish order.
Yes.
Well considered
Runs
order.
from the-
All issues can be decided once for all there.
Yes,
Because you can also raise the issue of, I will record that you are raising the issue that it's barred by law. I will.
It's barred by law. My lord, why we are carrying judgment, my lord? This issue went up to the Supreme Court, my lord. Barred by law issue under 17(4)(b). Can it consider this provision and this judgment, sir? Take to the paragraph 14 from 11.
Paragraph 11.
11, 16, 26 and 30. Excellent.
74. Section?
74. 73, 4B. It না আমি citation দিচ্ছি এক সেকেন্ড আমার একটাই আছে একটু পড়ে নিই
74. Section?
73 4B capital Delhi High Court, Madras High Court, Patna High Court. Similar views. Paragraph 26, last part will be very clear.
Paragraph
26. A coordinate bench in National Building Construction Corporation. This judgment, my lord.
Kindly see the, give me the copy so that I can also assist.
No, I just going to have I can.
Show me that you have taken this point before the adjudicating authority.
But adjudicating authority, my lord, the second point of argument, we were not heard before the adjudicating authority. We were not heard before the adjudicating authority.
Why?
That's the point, my lord. My lord will take the notice, my lord will take the show cause, man, at page 30.
Yes.
My lord, page 30 show cause, my lord will see if the show cause was issued on 27/4/2021.
Yes.
My lord, now upon this show cause, we filed, the notice was issued by Durgapur Commissionerate, my lord, after 2 years.
No, Siliguri Commissionerate.
No, this is the show cause of Siliguri
Yes,
Commissionerate.
yes.
Show cause notice was issued by Durgapur Commission. The reply was filed before the Durgapur Commission, my lord, will find at page 34.
No, why you filed before the Durgapur Commissionerate? Because the show cause was by the...
By the Siliguri, but the notice was issued by the Durgapur Commissionerate. You will find this at page 61.
No, but in the show cause notice, it's clear that it was by Siliguri Commissionerate, not Durgapur Commissionerate.
Show cause notice was issued by Siliguri Commissionerate.
Yes.
Hearing notice was issued by Durgapur Commissionerate.
Where is that?
We'll find at page 58, my lord.
58.
Yes.
Page.
Page 58.
Huh?
Page 58.
58. 58 adjudication order.
Adjudication order. I'll just. Malad has page 58, Malad.
Yes. So what? This was assigned to that authority and notice was served upon you. You replied to that same. One day the notice was, opportunity of hearing was given. You gave a reply wherein you have mentioned certain things which are also taken note of.
Yes.
So you have duly replied to that.
Yes.
Yes, my lord, I'm sorry. Page 79, man. I'm so sorry. Page 79.
79, yes.
70. Yes. Malad, 5.1. Can I read?
Yes.
I have carefully gone through the case record. This is the final order passed by Siliguri Commission. I have carefully gone through the case record.
By the Siliguri or Durgapur?
This is filed by the final order in 2025 was passed by Siliguri Commission.
Hearing by?
By Durgapur. My lord will see 5.1.
Mr. Agarwal, if that is so, how can it be done?
Change of jurisdiction also.
Then?
Actually,
whether the same officer heard this or a different officer.
Different officer.
If one officer heard, another officer can pass an order.
Today morning only I got this copy of the read.
Please consider this, because if one authority has heard, because he says that initially the Siliguri Commissionerate issued a show cause notice. He has replied to that same. Thereafter, matter was assigned to Durgapur Commissionerate. No difficulty of that. Durgapur Commissionerate also issued a hearing notice. He has replied. So he was aware of that. Now he says the matter was heard by the Durgapur Commissionerate, but the order is passed by the Siliguri Commissionerate. It's a different authority. Can one authority hear and another authority pass an order?
Reply, all documents were filed before the Durgapur Commission.
Did you attend before the Siliguri Commissionerate?
Yes, we went and said the same thing. We went.
If you have appeared before that authority, so that Siliguri Commissionerate heard you.
No. That we'll find at 5.2 also. 5.
No, you are not heard by the Siliguri Commissionerate.
No.
You are heard by the Durgapur
Commissionerate.
Commissionerate.
All documents were submitted, everything.
Documents were submitted, I appreciate, before the Durgapur Commissionerate. My question to you is
whether
you are personally heard by the Durgapur Commissionerate or the Siliguri Commissionerate?
We were heard by Durgapur Commissionerate. Subsequent, after 2 years, a notice was given by Siliguri Commissionerate.
Yes.
We appeared before the Siliguri Commissionerate, said that we have been heard before Durgapur Commissionerate. He said, you have submitted a reply, submit a reply also here. We submitted a reply on that
cannot be done. Yes, but there he was given a personal hearing.
Yeah.
Now you have submitted a fresh notice, Siliguri Commissionerate. He appeared and said that I had made a submission personally. He said, yes, you have filed a reply, file it reply here. That's not sufficient. If the statute provides for a personal hearing, he is entitled to a personal hearing. Otherwise, there is no necessity, Mr. Agarwal, for giving all of you a personal hearing also. You have filed the documents here. I can say, all right, documents are filed. Yes, there is no necessity for personal hearing. Will you accept that? He has not made any submissions on merits. He has only said I appeared before that Durgapur authority. I had made submissions. He said you file a reply. Cannot be done in that fashion. You ought to have given him a personal hearing. So, Mr. Agarwal, you take instructions because this, if he had heard that finally, then nothing. But if he has not given, all right, that is why, because take instructions only on that. If the Siliguri Commissioner had given him a personal hearing, yes, there is nothing he has to approach. And if he has not done, then it is to be set aside.
Because,
Then
yes.
he can
recently-
decide that after giving him a personal hearing, decide all points.
Yes.
The
He
learned
appointed records, yes, that's the thing.
The learned advocate appearing for the petitioner submits that the show cause notice was issued by the Joint Commissioner, CGST, Siliguri Commissionerate. কি বলে শুরু করলো? হ্যাঁ, and pursuant to such show cause notice, you've submitted a reply before Durgapur Commissionerate.
Durgapur Commission.
And subsequent thereto, the petitioner was intimated that the matter has been transferred to the Durgapur Commissionerate. And the petitioner duly submitted the reply to the show cause notice before the Durgapur Commissionerate, and such authority had also afforded a personal hearing to the petitioner. Full stop. He further submits that thereafter,
My lord, only one thing, my lord, one indulge, my lord. Kindly considers the delay, but we, since 2 years.
Though that is a different
After 4 years.
That is a different thing altogether. I'm on this jurisdiction whether he can.
Great.
All issues, if you want, if you say I can relegate you to the appellate authority, you can raise all points there. If you want, I can relegate you to the appellate authority, raise all points, including the question of jurisdiction.
My lord, but we'll miss a forum, that's the only, we'll miss a forum.
Why you will miss a forum?
Adjudication.
Against this, no, adjudication, you can raise all points before the appellate forum. If the appellate forum is satisfied, he can also remand it back to the adjudicating forum. You are not losing any forum.
That normally, my lord, appeal, my lord, that's, they say that we don't have the power to remand back.
They can decide it finally.
Finally, they can.
It's the final authority on facts as well as on law. He can decide it finally also. No difficulty on that. All issues, but by limitation, all records are there.
Yes, all records.
So, no difficulty. If you want, I can ask you to prefer an appeal, give you liberty to prefer an appeal, give liberty to you to raise all points. The appellate authority will decide that.
Well, there is an, we can raise, but we miss a chance to this challenge.
Why? I will allow you to make this challenge also. All points to
73 capital 4B.
Every all points. I am not specifying any points. All points available to you, you can raise all points, including the question of jurisdiction. All right. I'm giving them liberty to file an appeal. So all points to be raised. This is an order under section 73(9).
73(9).
73(9).
This is since it is service tax, it will 74. It will be 73.
Page 70.
At page 55.
Oh, 55, yes. And the operating part is at
operating
part order. 35-page order.
Yes, sir.
The petitioner has challenged the order in original passed by the additional commissioner, CGST and Central Excise, Siliguri Commissionerate.
27/2/2025.
Full stop. Mr. Agarwal, learned advocate, what is the, which section appeal is maintainable?
Appeal is maintained under 85.
85 of the Service Tax
Service
Act.
Tax Act. Well, the book.
Finance Act 1994. Mr. Agarwal, learned advocate, appearing for the revenue authorities, raises an objection as to the maintainability of this writ petition in view of existence of an appellate remedy provided under section 85. 85 of the Finance Act 1994. '53. Yes. All right. 85 of the Finance Act 1994. First up, the learned advocate appearing for the petitioner submits that the issuance of the show cause notice was barred under the provisions of the Finance Act 1994. Which section you said?
Well, I said section 73, capital A, 4A, small
73 within bracket 4A within bracket
small b.
Small b. Small b of the Finance Act. First up. He further submits that the show cause notice was issued by the authority of the Siliguri Commissionerate, and the matter was thereafter transferred to the Durgapur Commissionerate, and ultimately the order in original was passed by the Siliguri Commissionerate. First up, he submits that when the Durgapur Commissionerate had heard the matter, had given a personal hearing to the petitioner, the Siliguri Commissionerate, Durgapur Commissionerate the Siliguri Commissionerate could not have passed the final order. Final order in original. First paragraph. Mr. Agarwal, learned advocate, disputes the aforesaid submission made by the learned advocate for the petitioner. First up, however, since various factual and legal issues have been raised in this writ petition, this court is of the considered view that the petitioner ought to have approached the alternative appellate remedy. First up, for such reason, this court is not inclined to entertain this writ petition. First up, WPA number such and such stands disposed of by giving liberty to the petitioner to approach the appropriate forum in accordance with law. First up, there's a period of limitation.
There's a period of limitation.
So
4 months.
So is it within that period?
No. That is crossed now.
In the event the appeal is preferred within a period of 2 weeks, within a period of 2 weeks from date, the appellate authority shall consider the appeal on its merit without dismissing the same on the ground of limitation.
Great.
First of all, it will be open to the petitioner to raise all points before such authority in accordance with law.
Great. Great.
Yes. 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 Who is appearing?
First time appearing on the.
Yes.
This is my affidavit of service.
Yes. Yes, what is this matter?
Actually, the petitioner is a widow lady. and filing this writ
Oh,
petition
thank you. Thank you so
from
much.
Paschim Midnapur.
From?
Paschim Midnapur.
Yes.
Her residential premises situated at.
Consider the representation quantum of compensation.
Yes.
Consider person orders. Yes, submitted a representation. Say, where is your representation?
My representation is multiple representation I have.
No, which representation you wanted to consider? 29th of April, where is that? 29th of April, it is page 40. You are for the railway authorities. So you consider that, take a decision. What instructions? All right, I am not passing any orders on merit. You consider this representation, pass an order. If you want to reject it, but give reasons for that. The petitioner has alleged that the respondent authorities have not taken any steps pursuant to the representation dated April 29, 2024, filed by the petitioner. Who will award compensation?
Family of the deceased.
Which is the competent authority? Inspector General of Police cannot decide that. State is not a party. It appears from the record that the railways are represented by their learned advocate. He submits that some time be given to the railways to some time be given to him to take instructions. To stop paragraph. It appears from the record that the petitioner has filed, has submitted a representation before the member secretary, Northeast Frontier Railway, praying for award of compensation arising out of unnatural and untimely death of her husband in a railway accident that took place on 4th of July 2019. And an unnatural death case being number 20/2019 dated 4th of July 2019 was registered. To stop, without entering into the merits of the claim made by the petitioner in the representation dated 29th of April 2025, the writ petition stands disposed of by directing the member secretary, Northeast Frontier Railway, by directing the inspector in charge, Siliguri Town Government Railway Police, being the seventh respondent, to consider the representation of the petitioner and to communicate the decision to the petitioner as expeditiously as possible, but positively within a period of 3 weeks from the date of receipt of a copy of this server copy of this order, along with a copy of the representation dated 29th of April 2025. Yes, next. Yes.
Because question.
Yes.
I am led by Mr. Because question, Lordship. Is on the virtual mode.
Yes.
Item number 29, my lord. I am for the petitioner, my lord.
Yes, yes.
My lord. My lord, I am before your lordship challenging the action of the respondent authorities in not granting the post of Registrar of Alipurduar University as a permanent post to me, my lord. What has happened, my lord? In 1/10/2018, Alipurduar University Act
Who is
was
representing the
enacted.
Alipurduar University?
Lordship, we have served.
Have you served
Yes,
them?
yes, affidavit of service.
My lord, I have served, my lord.
When they have received?
My lord, my junior is there. He will show the affidavit of
Yes,
service
yes.
to you.
I'm asking Mr. Dot to ascertain.
Lordship, it has been scheduled 29 September.
Yes.
29 September.
29 September.
Yes.
My lord.
All right, yes.
My lord.
No, no,
Alipurduar University was notified in the Kolkata Gazette on 1/10/2018, my lord. At the initial stage, my lord, petitioner was recommended as the principal of the Alipurduar College. And then, my lord, when the Alipurduar University Act, my lord, then the governing body of the college abolished and the principal for the post of principal was also abolished, my lord. Then one option was given to all the employees of the Alipurduar College to opt for whether they were given options whether they want to go to the any college or they will be absorbed in the university or not. I have given option that yes, we all want to go to the university. Then what has happened, my lord? My lord, if your lordship,
where is your option given?
My lord, I'm coming to that, my lord. Before that, my lord, if your lordship kindly come, the government has issued one SOP, my lord, standard procedure, my lord. If your lordship kindly come to page 31, my lord. Page 31.
Yes.
Page 31. This is the, my lord, standard operating procedure, my lord. My lord, may I read, my lord? Only 2 paragraphs I will read on the head note and the next one. In terms of the provisions contained in section 64 of the Alipurduar University Act 2018, and as per the recommendation of the committee, the governor is hereby pleased to formulate the following standard operating procedure for smooth transitions, which is as follows. Number 1. All principal, teachers and librarians of the Alipurduar College who have been appointed in a permanent substantive vacancy shall be deemed to have been absorbed in the university with their respective post along with their respective privileges with effect from the date of commencement of the act, provided such principal or teachers of the librarian possess required qualifications for appointment as a teacher of the university or librarian of the university as prescribed by the Extent University Grant Commission's regulations, followed by the rules of the state government. The Alipurduar University Act shall immediately issue a notification for absorption. That was the procedure, my lord, what the government has raised.
Yes.
What the government is saying that all the principal will be absorbed with the respective post.
So what has been done thereafter?
Thereafter, my lord, I made some representations to the principal secretary, to the vice chancellors and others, my lord. Your lordship will find my first representation at page 62, my lord.
What is the decision? What is the decision given?
My lord, at page 62, no decision was given, my lord. One thing they have given decisions on 11/6 to 2025 at page 28, my lord.
28.
Page 28, my lord. 28. My lord, may I read, my lord?
Yes.
Whereas the Alipurduar University Act 2008, which came into force on 1/10/2018, has provision for absorption of the employees of Alipurduar College erstwhile in Alipurduar University through exercise of option. And whereas the employees of the Alipurduar College erstwhile exercised their option in terms of Section 64 of the Alipurduar University Act 2018, and whereas the standard operating procedure SOP, White Order number such and such dated 10/2/2025 regarding absorption in the employees
You
of
have been
the
absorbed as professor.
My lord.
Yes. So you have been absorbed as professor.
My lord, what they are stating, my lord, now therefore in terms of provisions of contained in Section 61 Alipurduar College Act, Joydeep Ray, the principal, asked to Alipurduar College who have been absorbed as professor, my lord. Now, my lord, if your lordship kindly have a look to the Alipurduar University Act, Section 64, my lord. I have shown to your lordship the SOP, my lord, what the government is saying, that if employee is to be absorbed in the university, you have to give in to the respective post along with their privileges, my lord. Now, my lord, kindly have a look at the section.
So since you have been absorbed, you will be having that privileges.
My lord.
Wherefrom you are saying that you have been deprived of those privileges.
Yes, my lord. As because, my lord, principal is an administrative post, my lord. As a principal, all the principals of any college are enjoying some privileges, my lord. Whereas if I go down to the professor post, that is the teaching post, and principal is an administrative post, those privileges will be curtailed, my lord. That is the main problem, my lord. And I am working as a registrar since the inception of the university, my lord. By on temporary basis, by extending my period. My period is still up to December, my lord. Now they are planning that I will be ousted from that post as because there is an order to be absorbed as a professor, my lord, which they cannot, as because Act says otherwise, my lord. If your lordship kindly have a look at section 64, my lord. My lord, my junior will hand over the Alipurduar University Act, my lord.
Yes, then
I'll apply.
yes, 64, yes.
My lord, 64, 1 and 2, my lord.
Yes.
May I read, my lord?
Yes, yes.
64, 1. All principal, teachers and librarians of the Alipurduar College who have been appointed in a permanent substantive vacancy shall be deemed to have been absorbed in the university with their respective posts along with the respective privileges. Here also it is written, my lord, with the respective privileges. With effect from the date of commencement of this act, provided such principal or teacher or librarian possesses required qualification for appointment as a teacher of the university or a librarian of the university as prescribed by the Extent University Grant Commission regulations, followed by the rules prescribed by the state government, my lord. And the state government has stated that yes, I will be absorbed in the university with my respective post along with my privileges. Now, what they are saying, I will be go down to the teaching post, that is the professor post, and my privileges will be curtailed. That is against the section 64 of the Alipurduar University Act and also against the SOP, my lord. Given standard procedure rightly done by the state government, my lord. That is my only problem, my lord.
Yes.
And I am acting as a registrar since inception, my lord. If your lordship, I'll show to your lordship, my lord. Kindly have a look at page, my lord. That is at page. My lord, page 20 to 27, my lord. Page 20 to 27.
Yes. But who is for the university?
Appointment page 20. My lord, this is the first time. 24/12/2020, my lord. This is the first day, my lord. From since inception, I am acting as a registrar, my lord. As per the Alipurduar University Act 2018, I do hereby appoint you as the registrar additional charge with effect from 24/12/2020.
No, where is your initial appointment letter?
My lord, as a principal, that was as a principal, my lord.
Page 20.
My lord, joining department, page 17 and 18, my lord.
17 and
18, my lord.
No, that is in the college.
20, that is in the college. After that, my lord, and after enactment of the act, my lord, college transformed into university.
Yes.
The option was given. I have given my option to be absorbed in the university. Section 64 is very specific, my lord. I will be absorbed along with my extended post, along with privileges, my lord. And the SOP is also saying that I am in the post of registrar, and registrar is an administrative post, and erstwhile principal post was also an administrative post.
No, registrar is the additional charge.
Additional
The
charge, my lord.
Parent charge. It's an
My lord,
additional charge, sir.
yes,
So in
yes, yes.
addition, you have been asked to perform duties as a registrar.
My lord,
It's an additional charge. So
in
in
my
addition to your parent functions, you have been given an additional charge. This does not mean you have been appointed to the substantive post of a registrar.
but my lord, kindly appreciate only one thing. Section 64 is very specific.
Yes,
I have
but
to give them
in
to
a
my-
substantive vacancy,
Yes.
but you have not been appointed as a registrar. You have been appointed, you have been in some other post with an additional charge of a registrar. That does not mean you have been appointed in a substantial post of a registrar. There's a gulf of a difference being appointed in a substantive post of a
My lord,
registrar
I
and an
understand. I
additional
understand
charge
your
of a
lordship
registrar
point.
being given.
I understand your lordship point. My lord,
Yes,
one
yes,
thing, my
sir.
lord, one
No.
thing, my lord. My lord, kindly see, University Act was enacted in 2018. It started function is 2020.
Maybe, sir, but you have not been appointed as a registrar. You have
No, my
not
lord.
been appointed as a registrar. Show me
My
your
lord,
main appointment. This is an additional charge.
My lord,
Addition is
additional-
something in addition to the duties you have been asked to perform.
that they are saying, my
Maybe
lord,
some
that
other allowances in addition you may be entitled to, but you are not entitled to the privileges of the post of a registrar.
my lord, I'm questioning this question. I'm asking this question to myself. Why? As because when I was in the post of principal, I was enjoying those privileges, my lord.
Maybe you have opted for that, but you have not been appointed in the post of registrar, sir.
My lord,
You have not been appointed in the post of
my
registrar.
lord, one cannot be directed to go down, my lord. As because I was the principal of the college.
That is the different thing. You ought to have challenged your appointment.
My lord, option was
what functions you are performing? You are
My-
performing the functions of a professor. Are you
Also-
teaching?
also register as additional charge.
Sir, what is the? Are you in a? Are you teaching?
My lord, yes, I'm teaching.
Yes. So that was your parent appointment in a substantive post. That is why you have been appointed as a professor.
My lord, I'm
Register
challenging
is an
that.
additional charge given to you.
My point of challenge is that, my lord, I cannot go to the teaching post, my lord. I'm an administrative person, my lord. When I was functioning the post of principal, now in the university, I've given my option. I want
Show
to
me
go
what
to
you have challenged. Show me what you have challenged.
My lord.
The absorption, my lord.
Absorption as a registrar, you are not appointed. Show me that you are appointed as a registrar, not as an additional charge. Your
My lord, I
parent
was
appointment
appointed as
was
registrar
as
for on temporary basis, and that was extended from time to time, from 2020 to 2025.
that does
my lord.
not. Yes, temporary basis. There are two things:
My lord.
appointment against a substantive vacancy and a temporary appointment. It's an additional charge given to you.
My
It's
lord.
not a permanent appointment, sir.
Now, my lord, how a principal can be said that yes,
Let them
you go
file
down to the
affidavits.
professor,
Let
my
them
lord.
file affidavits. There is no scope to pass any. Yes, Mr. Additional Advocate General, what is the submission?
My lord, absolutely correct, my lord. The post of principal is not a professor. It's a rank professor. Rank of professor is given. It's number one. And through the College Service Commission, on the basis of recommendation to a governing body of the college, he was appointed as a principal. One chapter. Then after the establishment of the university, the vice chancellor thought it without, my lord, as of now, there is no executive council in the university. So without the concurrence of the executive council, meaning the apex body of the university, no such appointment can be given. Number two, in the statute below, the qualification has been prescribed, and after the advertisement to be made, then only if he is eligible, then on the basis of the committee to be constituted, selection committee, then he would be appointed. So nothing has happened here.
All right, let
Yes,
affidavits be filed. Ashun, the petitioner
My lord,
has.
in the meantime, let there be an interim order in terms of
No,
prayer
no.
G.
What interim order? What interim order,
in
sir?
terms of prayer G, my lord.
No, you are serving as an registrar. You serve as a registrar as an additional charge. interim order amounting to granting final relief. Can it be done, sir, as an
No, no, my
interim
lord.
stage?
I'm not, my lord, what I'm on, my lord, kindly appreciate, my lord. To pass an interim order directly
Sir, cannot be done. Sir, cannot be done. Don't
directing the
invite those
respondent,
observations, otherwise.
64 will not, my lord.
my lord, to allow the petitioner to serve as registrar of the university till the disposal of the writ
But that
petition, my
also
lord.
cannot be given. There is a discussion of university, my lord.
That's additional charge. It's for the university to decide. It's an additional charge. Tomorrow they can think, no, I will give someone as an additional charge, not you.
My lord, I'm working since inception, my lord.
Maybe, sir,
No.
it's up. Till now you are functioning. They have not disturbed your functioning.
No, my lord.
But you cannot enjoy with the protection of the court. Whatever you are enjoying, enjoy that. Be happy with that. Court cannot give you protection for that. This cannot be
But
done.
my privileges will go, my lord. If they go on like this, but my privileges will go.
Section 64, my lord.
The petitioner has paid for issuance of a mandamus directing the respondent authorities to absorb the petitioner to the post of the registrar permanently. Full stop. The learned advocate appearing for the petitioner submits that the petitioner was initially the principal of the Alipurduar College and after formation of the Alipurduar and since the said college has been upgraded as Alipurduar University and the petitioner is serving as the registrar within bracket addition.
Not upgraded. Still, my lord, the college is there. College is also functioning.
He has said that
in
which
the
has
campus,
No, my lord, the
in the
college is
campus
not
of a
functioning. It's
college, the
not true, my lord.
university is functioning.
All right. কি বললাম?
My lord, the governing body has dissolved, my lord. If the governing body
Upgraded না
dissolves,
করে
everything dissolves.
and since the petitioner is presently serving since the petitioner has been appointed and serving
Not
as the
appointed, but
registrar,
additional charge was given as a registrar.
serving appointed and serving as the registrar within bracket additional charge / officiating.
Only additional charge, no official.
Additional charge, that's his case. I am recording his case.
But the appointment letter, this.
I will come to that.
Your lordship, please, may I go court number 4, my lord?
Yes, has been appointed and have been serving as registrar within bracket additional charge / officiating bracket of the university. A direction be passed upon the university to absorb him permanently in the post of registrar. First up, if every service filed in court today is taken on record, in spite of service, none appears for the university. First up, state is represented by the learned additional advocate general. First up, after going through the materials on record, this court finds that the petitioner was only given the additional charge of a registrar. First up, the petitioner has prayed for passing an interim order directing the respondents to allow him to serve his duty as registrar of Alipurduar University till the disposal of the instant writ petition. First up, such an interim order, such prayer for interim order cannot be accepted as since the petitioner was only given an additional charge of a registrar and it is for the university to decide on such issue. Full stop, paragraph, let affidavit in opposition be filed within 2 weeks from date, semicolon, reply thereto, if any, be filed within a week thereafter. Parties will be at liberty to mention this matter for enlistment under the heading hearing after expiry of the period fixed for exchange.
My lord, kindly direct this matter to appear under 4 orders. For hearing, I will not gather.
It is a hearing matter, sir, not as 4 orders.
My lord.
to be filed with the university.
My lord,
Both of you
your
have
lordship
given
has
affidavit
said-
opposition, you can also file your. আচ্ছা একটা
My lord,
যেটা লার্নেড additional advocate general appears for the state ওখানে একটা লিখে দিন he raises an objection as to the maintainability of the writ petition.
my lord, one thing, my lord,
Of
may I submit, my
Maintainability
lord?
of the writ petition is kept open.
My lord, one
Yes.
thing may I submit, my lord? Your lordship has
yes.
said while dictating the order that Alipurduar University is at liberty to go on filling up the post of register permanently, my lord. In that case, my lord, if your lordship record, if I am found suitable and eligible, then my candidature will also be considered along with others, my lord.
Sir, I can give you that liberty.
My lord.
If you want
Considering
that.
considering my
I think
seniority,
then nothing remains to be decided in this writ petition. If I accept your that prayer, nothing
Right.
remains to be decided. That's your challenge.
Yes.
If you want, I can give you liberty. But then nothing remains to be decided in the writ petition. If they go on for appointment, I can give you liberty to apply for that and to participate in that if you are otherwise eligible.
But it's open, my lord. I may apply for that post, my lord.
It is his apprehension that they are going to fill up the post of registrar.
The learned advocate appearing for the petitioner, after this order is passed, the learned advocate appearing for the petitioner submits that in the event the university takes any steps for filling up the post of the registrar, the petitioner may be allowed to participate in the selection process. Full stop. It is however made clear that in the event the university makes any attempt to fill up the post of the registrar, it will be open to the petitioner to apply for the said post, and the university authorities shall consider such prayer if he is otherwise eligible to apply for such post.
I'm grateful, my lord. I'm grateful, my lord.
Yes. We will consider and pass an order and take a decision. We'll consider and take a decision if it is otherwise.
By giving an opportunity, my lord. Oh.
No
Oh, then-
opportunity.
No opportunity. No opportunity. No.
Participation again, opportunity.
My lord, my lord, my lord, my lord, my lord.
Item number 27.
Then this petition will become practice one.
Die its natural death.
On the basis of apprehension.
Mr. Pal, it will die its natural death. After that, no. Till now, no steps have been taken.
My lords,
Mere apprehension.
If is. Yes.
27, I appear for the petitioner, my lords. My junior had already mentioned you about this matter. Our
Yes.
prayer is an innocuous prayer, my lords. We want to file an appeal against 3 orders.
No, this is that physical filing.
Yes, my lords.
Yes,
My
where
lords,
is
the
Mr. Singhania? Where is Mr. Singhania? They were to take instructions.
Yes, sir.
Mr. Singhania, Mr. Mojumdar, where are they? All right, passing it over. Yes.
Very good.
Yes, next. Number 30.
Lordship, item number 30, I beg to appear for the petitioner.
Yes, yes. Yes.
Yes. Yes, Lordship, before I start, I just make one thing very clear, Lordship. Item number 15, Lordship. Just just an hour back, there was one difficulty in the date 117. I have checked from my clerk that why there was the difficulty. Because of the GP office, Lordship, because of yesterday was holiday. So he went to file up the matter. 4th was the date. 48 hours is required, Lordship. So for that reason, they have given that date 17, Lordship. Nothing else. I just
But,
made my thing clear.
No, but in the presentation form, you have to also mention the date accordingly.
Lordship, it was the GP office who said we will not accept that.
All right.
But we have filed that matter on 3rd, Lordship. This is the whole difficulty. I just made
All right.
myself
Yes.
clear.
Yes, what is this matter?
His lordship, lordship heard this matter.
Yes.
Almost heard this matter. This was in regard to the Matigara police station. Earlier, lordship, there was an order to go before the police to give the signature for the FIR. As
Yes.
there was an apprehension,
Yes, yes.
and there was a lordship passed an order, and we went there, put our signature. Probably the case will start whatsoever. Now, lordship, here the difficulty is something else. Lordship, kindly come to page number 15 once.
15, yes.
Yes, lordship. Lordship, page number 15, that was the order which has been passed in regard to the FIR which is against me, that is 50925. Not to
Yes.
take any coercive steps, and there was a direction to join the investigation, lordship.
Yes.
Now, lordship, I am eager to join the investigation. What prompts me, lordship, that I have already earlier also occasion I have dictated that lordship, there was a continuous pressure from the IO that there are certain complaints, though lordship that is been recorded, only one FIR that has been registered, the order itself is annexed over there, lordship. This is the difficulty, lordship, whenever I am trying to go to the outpost. This is not the Matigara police station, this is a Matigara outpost. Whenever I have made an attempt to go to the outpost, lordship, they have claimed that amount, that avertment is there, complaint I have made, lordship. I am unable to join the investigation, lordship, though in spite of having the protection order is with me.
Yes.
Lordship, first of all, Matigara outpost is under the Matigara police station, Lordship.
Yes.
Lordship, in the earlier occasion when he
Was preventing him from participating in the investigation.
Lordship, we are not, Lordship. As per the order of the Lordship, he already went there.
Yes, yes, that he has done.
If-
Now, this is not in connection with that FIR. This
Yes.
is in connection with the FIR where, in respect of which he has
I
got
am
a
accused.
protection.
Yes, Lordship.
So now he says that he is willing to participate in the investigation, but when he is going to the outpost, he is not being allowed to do so.
Lordship, now I will submit my report, Lordship. In the earlier occasion also, we have mentioned that, Lordship, we
Yes.
have issued him the notice under section 41, that's the 35(3),
Yes.
BNSS notice, but he did not comply. Lordship, we are trying to contact with him. Despite of our contact, he will not turn up, Lordship.
Lordship, after that we have filed the
Even, Lordship, we
482.
have assured that we will not arrest him, we will cooperate with him. He went there, put his signature. Now the separate sang, he will started to sing. Now, Lordship, kindly come to 1, 2, 3, 4. Paragraph 4 of our petition, Lordship.
Of your report.
Yes, Lordship.
Yes.
In your report, kindly come to paragraph 4, Lordship. 1,
Yes.
3, 4. In paragraph 7, the petitioner states that he is unable to participate in the process of the investigation due to demand of money, Lordship. This is his allegation, Lordship. But even he did not mention how the IO has demanded the money, everything. Even, Lordship, in our earlier report, if Lordship will recall that so many FIR has been lost against in
Mr. Banerjee, your client is
district-
making false allegations against the investigating officer.
So, Lordship, kindly,
If you make this type of allegations, it's difficult.
Lordship, for a time being, kindly
The
allow me
Lordship
for.
will remember, Lordship, in our earlier report, we have mentioned that in every district there is a FIR,
Yes.
there is a complaint lodged by this various person against
Very
this
good.
writ petitioner, Lordship.
Very
There
good.
is an allegation that you are not turning up. I'm recording that.
Earlier occasion also, Lordship, have recorded
Yes.
this.
Yes,
What
Lordship.
is the next date when you have asked the petitioner to appear?
Lordship, they have. Lordship, may I
Lordship,
just may I just make my submission? Lordship, kindly.
Yes.
Lordship, one FIR has been
Even
started.
he is enjoying the order of the Honorable High Court, Lordship. What police will do with him?
Yes.
Lordship, may I?
We have the
May I?
protection order.
We have a
Lordship,
protection order
Lordship,
to
Yes.
participate in the investigation.
Lordship, may I?
What police will do, Lordship? How
Baba.
police will violate that?
Really kindly allow, Lordship, kindly allow me for
Yes,
submission.
yes.
Lordship, the fact is there was a one case has been made against me. That is 509, Lordship. They have issued one notice against me, Lordship. I have go to the court, that is 482. The matter is pending over there, Lordship. a protection order has been given and there is a further order to join the investigation.
Yes.
The notice was given much prior to that and I have perused that, Lordship. Now what prompts me, kindly Lordship, kindly.
Banerjee, do one thing.
Yes, Lordship.
You are participating in the investigation pursuant to this order passed in the application for anticipatory bail.
Yes, Lordship.
Yes, Lordship.
So if you find any difficulty, make an application in that matter.
Lordship,
Let
what will
that bench
happen?
consider both the issues.
It is still pending in
Yes,
the
yes.
court,
I give you liberty.
Lordship, that will create another difficulty.
No,
for me.
no
Because
difficulty.
kindly
Mr.
allow me,
Banerjee, it's
Lordship.
better. Because this is, you have been directed by the coordinate bench in an application for anticipatory bail to participate in the investigation. According to you, the investigating officer is acting in violation of that order. He is not
Yes.
allowing you to participate in the investigation. I give you liberty to file an application there.
Lordship, by saying just one line, I have candidly cleared that, Lordship, and this court can pass this order. What
No,
Lordship
no.
he is saying, Lordship kindly, Lordship kindly. What he is saying that yes, there is one FIR. When you will arrive, there are multiple complaints.
No, I'm
which
not
is
going
same in
into that.
nature.
Mr.
Lordship,
Banerjee, say all
otherwise,
those things before that.
Lordship,
thing.
otherwise,
Ashwin.
Lordship, otherwise, it will portray
No.
that I am evade from the investigation, which I am not, Lordship. Kindly.
No, it's better, Mr. Banerjee, you make that application in that application for anticipatory bail. Not here. Because that court has to consider both these issues.
Lordship, Lordship, can they do that, Lordship?
No, they
If
cannot do
have-
that. Mr. Banerjee, I am saying they cannot do that. So that is why I am asking you, because you are enjoying a protection order. And
Lordship, I am not
you are
even
obliged.
enjoying.
Mr. Banerjee, you are obliged to comply with the court's order. You are facing difficulty. Please draw the attention of that court. It's better. Ashwin.
As your
The
Lordship.
learned advocate, the petitioner has filed this application under Article 226 of the Constitution of India, alleging that the petitioner is not being allowed to participate in the investigation by the authorities of Matigara police station. Full stop. The learned advocate appearing for the state submits now files a report of the inspector in charge, Matigara police station, dated November 2, 2025. Full stop. It has been specifically stated therein that in spite of direction of the Honorable High Court, the petitioner did not turn up, neither participated in the process of investigation. Full stop. Paragraph.
Lordship, I deny that. Lordship, I
Yes.
deny that.
Yes, the Mr.
deny.
Banerjee, learned advocate appearing for the petitioner, disputes the
Dreadful.
statement recorded in the report of the inspector in charge, Matigara police station. Full stop. However, it is not in dispute that an application for anticipatory bail, being CRM within bracket A 666 of 2025, is pending before this court, and the petitioner is in which paragraph that protection has been given, which page?
Lordship, that is in page number 15, page number 16, Lordship.
কি বললাম?
Para 4.
Wherein it was observed that no coercive action be taken against the petitioners, and the wherein you have been directed to participate in the investigation.
Yes, Lordship, just.
Which paragraph?
Lordship, Learned Counsel got his honor, the filed a defect on the state. Segment was already ceased to investigate the status report to let the matter.
And it was recorded,
yes,
that
Lordship.
the police is investigating the matter.
Yes.
Full stop. Since the investigation is in progress and it has been alleged by the petitioner that he is not being allowed to participate in the investigation, this court is of the considered view that the petitioner should be given liberty to, this court is of the considered view that any allegation with regard to the petitioner not being allowed to participate in the investigation should be raised in the pending application for anticipatory bail. Full stop. In view thereof, WPA number such and such stands disposed of by giving liberty to the petitioner to make an appropriate application in CRM with bracket A 666 of 2025, raising the issues, raising the issue with regard to.
Lordship, there are other prayers also.
Yes, what are the other prayers?
Lordship, the other prayers is, Lordship, the same if there is.
To register any FIR, Lordship.
No,
This is
not
there.
that. If
Kindly come to
in nature
prayer,
of 509, Lordship, I'm guided by the judgment, Lordship. Lordship is well known
Not
about
to
the fact.
register any further FIR.
Lordship, not in
that
general.
Is registered, Mr. Banerjee, if that is registered, you have your remedies. You can challenge that.
Lordship, they have not. Kindly appreciate
Directing
one thing,
to allow
Lordship.
the petitioner to join the investigation.
Yes, this Lordship, this is one aspect. The another aspect is not to register any FIR which is in
To pray for
same nature to
appropriate
509.
In case, to pay for appropriate reliefs in CRM, in case the petitioner faces any difficulty in participating in the investigation.
Grateful, Lordship. Grateful.
Yes, call the next matter.
My lord, am I appearing for the petitioner in
31,
item number
yes.
31? Yes, I'm appearing for the petitioner, Lordship.
Yes.
My lord, this matter, what has happened, this is a revenue neutral matter. Why I'm saying so? Here, my lord, I had made certain purchases from the Indian Railways. Now, Indian Railways, these purchases, the tax was to be paid on the reverse charge mechanism. That is to say,
yes,
Indian
Mr. Bhattacharya,
Railways,
how much time it will take?
Not much.
I think
10
it will
minutes.
take some time.
10 minutes maximum.
Adjudication, he has not preferred an appeal. Let him approach to
No,
the
no.
appellate forum.
No, this is a second round of litigation.
Then we will use the affidavit, my lord.
Then let affidavits be filed, let it be decided, Mr. Bhattacharya.
My lord, only one aspect that.
Or I am posting it before the next
No.
circuit
My
bench.
lord, only thing is, let the matter not be, no coercive action be taken against me. Affidavit be filed. No, my lord will see.
Either I am placing it before the next circuit bench or I will direct filing of the affidavits.
My lord will give me 10 minutes after the recess, if lordship so pleases. 10 minutes. I will
Mr.
not take
Bhattacharya,
more than 10 minutes.
This has to be considered because there is a provision of appeal. So all materials have to be
No, my lord,
considered.
what has happened, the appeal will not bear any fruit. Because
Yes,
it's a
yes,
question of
factual-
law. It's a
Yes,
pure
yes.
question of
Not
law.
only the pure provision of law, my lord.
No, it's
All right.
a pure question of
Next
law.
circuit,
my
my
lord.
lord.
Next circuit, I am placing it before the next circuit bench.
My lord, then the very well. Very well.
This matter before the next available circuit bench. Yes, next. Yes, Mr. Ghosh.
My lord, may I have a small indulgence, my lord?
Yes.
My lord, since this is at the fag end of this circuit, lordship, may I have a small
Yes, yes.
indulgence, lordship?
Yes, Mr. Ghosh, what is this?
The challenging establishment of a dumping ground is the heart of the town. When I am one of the plot owners that both the petitioners
Oh, on your plot, dumping ground has been.
clearly enclosed. I'll show the map that how that thoughtfully it has been done. Where I just place the map once and where that is annexed to the writ petition also.
Yes.
There is absolutely clear in blatant violation of the solid waste management rules. I'll also show the this 5 meters away from the river. 5 meters away from the river. 100
Yes.
meters away from residential flats. And
Yes.
probably 150 meters away from a public park.
Yes.
All of which is prohibited under the solid waste management. And in spite of having a permanent dumping ground pillar for the municipality, pillar there using it as a temporary dumping ground, and recently, what concretely to approach the lordship, the pillar they have installed a board showing that they have floated a tender for construction of sheds and
Who has floated a tender?
the municipality.
Who is for the municipality? Yes, how could you do this?
My lord,
On a property of a private?
no, my lord, I am submitting on inspection that we are not dumping any garbage on their property. What is vested upon us on the municipality, we are dumping it there.
What is your plot, Mr. Ghosh?
Just consider this map once.
So please show me where have you stated what is your plot? And he says that he is not, I will record his submission,
yes,
I will direct him to file a report that he is not doing anything. Then you are protected, Mr. Ghosh.
That's the very that I'm anticipating. I was anticipating this submission. That's why I have come with the map. And my plot is a 3.35 acre plot.
Yes.
Adjacent to the plot and the road, there is a narrow strip of two plots. Plot number 10 and another plot number. This two plot is absolutely mirrored. I'll show from the map. Mirrored the width of that plot, which they are claiming that they're using that, is mirrored at most 45 feet.
Yes.
45 feet. So, and I will
You
show
do not have any right over that strip, to two strips of plot.
I will have a right, because in between my plot and the road, this narrow strip of land is like that. And Millard,
Ingress and egress to
ingress and egress is gone. And Millard would imagine Millard in his commonsensical application of 9 Millard, a 45 feet stretch of land cannot be used as a dumping ground. And Millard, can you see the picture? Just at the first flash. Millard takes Millard page 50 onwards. Millard, if they say that this is 45 feet of land, narrow strip which is being used as a dumping ground, Millard, absorption.
Then, Mr. Ghosh, they have to be given a chance to disclose their stand.
Yes.
Have they taken any decision?
There's no question of decision.
So,
Something angular, it is 5 meters away. Even if they are using their plot, 5
yes.
meters away from a river, it is in blatant violation of the solid waste management rules. They cannot do it. I'm praying for a interim stay of using this plot as a let them come up with the report, whatever they want, interim stay, absolute violation of the rules. Kindly take the solid waste management rules once.
Yes. All right, come at 2 p.m. There are some, I think, contempt matters or some fixed at 2 p.m.
I don't think more than 5.
Panchayat Act, Miller. And but they didn't act, Miller. They simply send me later, Miller, the copy of the letter. That's it.
Yes, what happened on 23rd of July?
Nothing has happened. We just attended one meeting called by the Panchayat, Miller. Thereafter, we could not. And I'm relying upon the judgment of our Honorable High Court, Miller.
What?
Sir,
For what?
this is regarding illegal construction, Miller.
Illegal construction is all right, but what happened? It was hearing was fixed. What
hearing-
happened on that date?
We attended, Miller.
Where have you said that you have attended?
After filing of this contempt only, Miller, they served this notice to us.
No, no.
And-
Where have you said that you have attended the hearing? Show me.
I haven't said,
Then-
not mentioned in the contempt, Miller.
Then
It was filed prior to the getting this notice, Miller. After receiving this notice, Miller, contempt notice, this respondent number 1 organized or called one meeting, Miller.
you have to disclose that, file a supplementary affidavit stating that this hearing was conducted and no order has been communicated.
Miller.
The
I'm for the Pradhan.
oh, yes.
So Millet, I am told Millet that they have adopted a resolution, but that copy
Communicate
is
it to
not
him.
with me, Millet. Today. Otherwise I would have handed it over.
So
to
I'm
Millet.
directing, I'm giving you a time to communicate.
Yes, yes. Millet, 1 week's time, Millet, by that
All right.
time I'll come.
You should have said, Mr. Ghosh. I was thinking that nobody is appearing. This is an application alleging, this is an application for contempt alleging willful and deliberate violation of the order dated January 10, 2024 in WPS 60 of 2024. Full stop. The learned advocate appearing for the petitioner submits that only a hearing notice dated July 16, 2025 has been served upon him, and in spite of the fact that the petitioner duly attended the hearing fixed on July 23, 2025, no decision has been communicated to the petitioner till date. First paragraph. Mr. Ghosh, learned advocate, appears for the alleged contemner. First he submits that a decision has already been taken, but
The resolution has been adopted, but I'm not aware of that. Well, it's very difficult until I see the paper myself.
I'm saying decision, that is why I'm not saying order. So I'm giving you 1 week's time, do that with anything, communicate that. Submits that a decision has been taken and prays for some time to communicate the order to the petitioner. Full stop. As prayed for by the learned advocate, as prayed for by Mr. Ghosh, learned advocate, for the alleged contemner, the alleged contemner is directed to communicate the reasoned order to the petitioner within a period of 2 weeks from the date of receipt of a server. 2 or 3, Mr. Ghosh, please tell me. Within a period of 3 weeks from the date of receipt of a server copy of this order. Full stop. With the above observations, the contempt application stands disposed of. Yes, next.
Yes, my lordship. May it please your lordship. In the presenting on behalf of the petition of the contempt petition, actually the direction was there.
No, have you stopped?
Yes, I serve. Here is a tag report. I serve all.
No, when direction was passed to serve? Was any direction passed to serve?
No, no direction. But I communicated the,
Could not serve without direction being passed. Yes, Mr. Dhar, why have you not taken steps?
where is it? My lord, the last portion of the order sheet reflects that, the last portion, the order sheet reflects that, however, this order shall not prevent the municipal authority from removing encroachment, if any, upon municipal road.
There was no direction upon them. There was no direction upon them. So if you are, if you have alleged, you file afresh.
But this
No direction was passed. Contempt is for violation. Shall not prevent. That is merely an observation. Ashun. This application has been filed alleging willful and deliberate violation of the order dated April 3, 2025, passed in WPA 2525 of 2024. First up, after going through the said order, this court finds that the writ petition was dismissed, was disposed of without granting any relief to the petitioner. First up, however, it was observed that the order shall not prevent the municipal authority from removing encroachment, if any, on the municipal road. First up, however, in the event the petitioner produces any materials before the municipal authority with regard to encroachment of encroachment upon the municipal road, it will be open to the municipality to consider the same in accordance with law. With the above observations, the contempt application stands disposed of. Yes, next.
Now for the petition.
Yes.
22 Lordship, I am led by Mr. Arjun Ramgaj.
Yes, SJDA.
SJDA.
Yes, yes. Yes, Mr. Shah, have you got his, Mr. Pal, have you got instruction?
We have got the instructions, Lordship.
Yes, what instruction?
Kindly, Lordship, the land was acquired.
Was acquired?
Yes.
No information has been.
All right, I'm directing you to take steps. It has been
Kindly
acquired.
text paragraph from the second page, page number, column number 10.
Oh, a list of
Awardees. He did not turn up to receive the compensation.
Never received any notice, madam.
I'm hearing him. Please allow him to make submissions. His name is appearing in this list.
Yes, item number 10.
Item number
10, Nirendranath Sarkar.
Nirendranath Sarkar. All right, you take steps.
But he is there, Lordship. My senior is there, Lordship.
Yes, yes, Mr. Rai Mukherjee. Yes, Mr. Rai Mukherjee.
My lord, I have handed over, my lord. Kindly, I will request Mr. Dhar, my lord, to hand over a
Yes,
document,
yes,
my
yes,
lord. This
handed
was
over. You have
issued.
a very competent junior appearing physically.
Yes, my lord. Yes, ma'am. And my lord, your lordship find there's a land acquisition proceeding initiated. And my lord, your lordship will also find from page 2 and 3, serial number 10 and serial number 5. Serial number 10 at page 2, your lordship will find.
Oh, there are two
Nirendranath
plots.
Sarkar, that is the petitioner, son of.
And the next page, Lordship?
Yes, my lord, two plots.
There are two
151
proceedings. Two
and
proceedings.
148. My lord.
Yes, and plot number is what is the plot number?
151, 140.
My lord. My lord, there are two plots, my lord.
Yes, my lord.
151 and 148.
Yes, my lord.
Yes, those
My
two.
lord, my
Both the
lord.
plots are subject matter of acquisition. Acquisition
Yes, my-
proceedings initiated in 2005.
But no
Yes.
such communication has ever made
Must
to the
be there is a
petitioner.
communication.
No, my lord, they should show that notices, my lord. that-
All right, you challenge those proceedings. Your name is appearing in the list of awards.
But my lord, I have never been intimated, my lord. That is my
Take steps,
case.
take steps. It has been awarded.
The my lord, not to be
acquisition
ousted without due process of law. That
Now it's due process of
My
law.
lord, I've never been,
No,
my lord,
alright, sir.
my contention in the writ petition
You
is.
challenge those proceedings. Whether you have been given notice or not, that cannot be decided now.
My lord, but they should not evict me because I'm in possession, my lord. Till now, nothing has been done, my lord. Let them give me a notice of pass the award.
This is the list of award.
My lord, the award has never been communicated, my lord. If they do it with behind their backs, my lord, it's not supported by any document, my lord.
Yes,
Showing
show me
that
you
service,
have communicated, issued
show
notice
that,
upon them.
service upon the award to me, or even the notice that it has been acquired.
Yes, show me the
Something they have to
notice.
show, my
It is
lord.
written that he did not turn up to receive the.
Where is the
Where,
notice
where
that
is,
you asked
where
me
is
to
the
come?
notice? Show me the copy of the notice.
My lord, the notice and everything, my lord, that the state, my lord, the your lordship will find the appropriate
Mr. Pal.
authority, referral number 6, the land acquisition officer, Darjeeling.
Yes, Mr. Rai Mukherjee, are you taking any steps for evicting the petitioner?
My lord,
Yes.
my lord, I found that they have taken some instruction.
Yes.
But so far, my lord, this proceeding is concerned, my lord. That is, my lord, the land acquisition officer can apprise your lordship, the state advocate, my lord, that what notice was issued when the award was passed. But from this document, my lord, I found that
No,
his
are you
name is
going to
appearing.
Mr. Rai Mukherjee? Yes, acquisition proceeding was initiated. His name appears in the list of awardees. That is fine. I'm asking you, are you going to demolish the building of the petitioner?
I have to take instruction, but I do not have. But I, from the pleading, I found that they have.
Joint field inquiry was conducted on 21st of March 2020, 2025. And when the award was passed.
From
the LA case numbers, my lord, is 2005, 2006.
You know everything, sir.
No, my lord.
Yes, yes. You know everything.
My lord, let them bring up an affidavit showing they have communicated the notice and the award to the petitioner, my lord. Then I have no case, my lord. Otherwise, my lord, I could not be ousted with this, my lord.
Yes, yes. Award was passed. Take compensation amount if you are aggrieved.
My lord, in the meantime, my lord, let my writ petition be considered and of reasoned order be passed.
What?
All my
What
claims,
they will?
my lord,
there is
because
no
they have not served it upon me. This is my allegation.
That you have to challenge that proceeding. I cannot.
But
pass
my
an
lord,
order. I give you liberty to take steps in accordance with law.
But till then, I let my possession be protected, my lord.
no.
I should not be ousted like this, my lord.
I give you liberty to take steps. I'm recording their submission. I give you liberty to take
My
steps.
lord, I should
to
not be
challenge the
ousted. That is
acquisition
my
proceeding.
innocuous prayer, my lord.
The
Proceedings.
This writ petition has been filed, alleging that the respondent authorities are taking steps to dispossess the petitioner without following due process of law. Full stop. The learned advocate appearing for the SJDA authorities submits that the तार आगे लिखो बोलो to dispose the petitioner from plot numbers. Where have you stated the plot numbers?
My lord, in
from plot
148 and
numbers
51, my lord.
148 and
There are three, my lord.
151 within Moja, Dokhin Bagdogra, in the district of Darjeeling near Bagdogra International Airport. Full stop.
Para 7 and 8, my lord, of my pleadings.
The learned advocate appearing for the petitioner files a bunch of papers showing the list of awardees and payment status with regard to acquisition of land for construction of cargo complex under LA case number 3/4 of 2005-6 and construction of multi-utility to Bagdogra Airport under LA case number 4/4 of 2005-6. Full stop. After going through these bunch of documents produced by the learned advocate appearing for the SJDA authorities, it appears that the plot number 151 is the subject matter of LA case number 3/4 of 2005-6, and plot number 148 is the subject matter of LA case number 4/4 of 2005-06. Full stop. It appears that the name of the petitioner is appearing under serial number under serial number 10 of the list of awardees in respect of LA case number 3/4 of 2005-6, and it has been and the remarks column, it has been stated that the petitioner did not turn up to receive LA compensation. Full stop. In respect of plot number 148, the name of the petitioner is appearing under serial number 5 in the list of awardees in respect of LA case number 4/4 of 2005-6, and in the remarks column, it has been stated that the petitioner did not turn up to receive LA compensation. Full stop. Thus, it appears that appropriate steps for acquisition of the land in question was taken, and for such reason, this court is not inclined
May I
to
submit, my lord? They have not
accept
submitted to me.
to accept the submission of to accept the contention of the petitioner that the respondent authorities are taking steps to dispossess the petitioner from his property without following due process of law. Full stop. The learned advocate appearing for the petitioner submits that no notices as contemplated under the relevant statute has been served upon him, and no notice for receiving the award has been also served upon the petitioner. Full stop. Such facts cannot be gone into in this writ petition, as the only case made out in the writ petition was that he was sought to be is that the respondent authorities were trying to dispossess him without following due process of law. Full stop. It will be open to the petitioner to challenge it will be open to the petitioner to approach the appropriate forum in case the petitioner is aggrieved by the action, is aggrieved by the steps taken for acquisition of the land in question, and is aggrieved by the amount of compensation awarded.
My lord, my
to the
difficulty, my lord,
petitioner.
they have not communicated it to me, my lord. My
That is-
cause of action,
I'm giving you liberty to challenge
my
that.
lord, in the meantime, my lord, if they come and forcefully oust me, my lord, it
Nothing-
will be
nothing.
unlawful, my lord.
It's
This
a
is my case,
proceeding.
my lord. Kindly
Please
take para
stop.
8, my lord. Kindly takes my para 8.
You file a writ petition challenging
Writ-
those. This next.
My
with the
kindly,
above observations-
kindly records this that special land acquisition officer could not produce any notices, my lord. That
What?
it has been served upon me. The notices were not served, my lord. Kindly records that, my lord.
What
Upon-
notices?
my lord,
You
the not-
challenge,
My
you
lord,
challenge that
it's their
proceeding.
burden to prove, my lord, because if they have initiated it lawfully, my lord, that notice should be served to me, my lord. They should have an endorsement to that effect.
You file a writ petition.
My lord, I
challenging
shall
that
file
now.
it, my lord. This is the
Now,
writ
now these
petition, my lord.
particulars are here. I'm giving you liberty to challenge.
My lord, in the meantime, I be protected, my lord, at
No,
least
no.
for a limited period, my lord.
Nothing.
My lord, in the meantime, my lord, kindly protects, otherwise, my lord, they'll take.
It's a proceedings from 2005-6.
My lord,
Your name
they
is
have,
appearing.
my lord, on
It
Thursday,
is
my
not
lord, Friday
believable,
they have
sir.
come without documents, my lord.
It's not believable, sir. that you are not aware of.
My lord, it is the fact, my lord. My
You are
lord, kindly
carrying on-
ask them to show them documents, my
You are
lord. Or
carrying on-
records it, at least they could not be able to show the documents, my lord.
All right, Mr. Shah, produce tomorrow.
Yes, my lord.
Uh,
Let them produce that it has been served upon the petitioner.
The documents. ঠিক আছে? The learned advocate appearing for the petitioner submits that no documents have been produced by the state in support of the acquisition proceedings. Post of list is
Service upon me, my lord, to the petitioner.
to dispose of the category. List is better tomorrow under the heading for orders to enable the learned advocate for the state to produce materials. To produce materials to show that the petitioner did not turn up to receive the compensation amount in spite of a notice being served. Yes, list this matter tomorrow under the orders. Yes, next.
Deeply obliged, my lord.
Oh, আচ্ছা ঠিক আছে তার আগে লিখুন in spite of service উপরে লিখে দেবেন none appears for the state to stop all right in spite of service upon the respondent authorities none appears for the state একদম উপরে লিখে দেবেন this court requested Mr. Shaha, learned additional government pleader, and Mr. Pal, learned advocate, to appear in this matter. Full stop. Let the appearance of Mr. Shaha and Mr. Pal be regularized by the competent authority. Full stop. This court requested Mr. Pal, Mr. Shaha to take instructions. Full stop. তারপরে হচ্ছে লিস্ট দিস ম্যাটার ওই ডিসপোজ অফ ওই জায়গাটা কেটে দেবে ইজ নট ইনক্লাইন্ড টু পাস এনি ইন্ট্রিম অর্ডার অ্যাট দিস স্টেজ ইয়েস নেক্সট
Deeply obliged.
Yes, Mr. Ghosh. For that matter?
Yes, ma'am.
Yes.
Milord, kindly takes Milord page 51.
50.
50.
Yes.
Milord would find, Milord, at the left side of the site, Milord, there is a boundary wall, a grill kind of installment. Milord, just adjacent to
Pillars
that,
are there and some.
and there is a grill. Milord, just adjacent to that is the river corridor. Milord can visually, Milord, make an impression how far the site is from the river. Now, Milord kindly takes Milord the.
Now, which is your plot according to you?
Milord, this the entire plot, except Milord a
No,
stretch of 30 feet from the road. Milord, this picture is taken from the road.
Oh, yes.
So there is a public road.
Yes.
Adjacent to this, Milord, there are two plots, which are wastelands.
No. So this board
Yes.
is on your property.
No, the board as such is on the road.
Board is not on the road. That's after that.
Milord,
that
slightly,
concrete-
slightly after the road, slightly
Yes.
adjacent to the road. Now, adjacent to this road, Milord, there is a
So this board is on the property of other person.
board is on the not the municipality. It's a waste plot. There is nothing on record to show that the state has allowed municipality.
All right. So
allowing
it's a
them to
wastage,
use
it's
this.
not your plot.
It's not my plot.
Yes.
Now, there the wasteland.
So after that is your plot.
After that is my plot. Now, Milord, kindly considers this map once. Milord, it will be very convenient for your lordship. Milord, kindly.
No, now, till now, the garbage is not been thrown there.
Absolutely on my plot. Milord, why I am saying this? Milord, kindly take
No,
that
this,
plot.
on this photograph, no garbage is visible.
Milord, Milord, kindly turns over. Milord, the next page.
Oh.
Milord, it is taken a little far away. That's why Milord, probably at the micro scale it is not visible. The next photographs, Milord can turn over 2-3 pages.
All right. Then, yes.
Now, Milord kindly considers the map once.
Map you are annexed? No.
Map is annexed. Map is annexed, Milord. There's a Milord, a micro version. That's why I've Milord kindly sees, Milord, there's a large chunk of land highlighted with pink. That is 106. That is my plot. 106.
Oh, this is entire plot is yours.
Entire plot, in the entire plot, there are 5 co-sharers.
All
We are the 2 co-sharers.
Yes.
And Milord, adjacent to the plot, Milord would find there are 2 other plots, plot number 10 and plot number 82, the narrow stretches which I was indicating.
Narrow stretches.
Yes,
On
adjacent
which-
to 106 on the top.
Which is the north? On the top.
On the top. 106, Milord would find
10 and
10 and 82, two thin stretches,
yes, yes,
2 plots.
Yes, yes.
These 2 Milord are vested plots.
Yes. And thereafter is the road.
Thereafter is the road.
Yes.
So what they're
So
doing,
the river is on the right side.
river is on the right side of the map.
Yes.
Milord would find the plot boundary is there, adjacent to that is the river. So
Yes.
Milord, what they're doing is, Milord, they're portraying a case as if they're using the vested plot for as a dumping ground. But what is physically happening is they're using a substantial chunk of my land as dumping ground. And because this 82 and 10, this stretches for about 450 meters physically.
Now, Mr. Ghosh, there is something blank in between these 2 plots. What is
Yes.
there?
But
So there is a way.
there's no way physically.
No, so because there are 2 plots.
Yes.
In the middle, there is something.
There is something, but physically there is no demarcation. They are using the entire plot
No.
as a dumping
So
ground.
there may not be any physical demarcation with
Yes.
regard to this, but as per the map, there is.
As per
something-
the map,
So this
as
is
per-
your plot. So
this is my 106 is my
So
plot,
there is something in between these 2 plots also, which
Yes.
is your property.
which is my property. Which is my
So,
property.
physically or not physically, so you have a right of way through this passage to the main road.
This passes to the main road.
But your grievance is that since the garbage is being dumped on this plot as well as on your plot, you
Yes.
cannot come over to
Yes.
the main road.
To the main road. Number 1. Number 2 is these 2 plots which Milord is seeing in the map. This is Milord a stretch of maximum 35 to 36 feet. So this is like a strip of land. So whether you dump garbage there or in my plot, it is essentially it is all the same. And in any event, even if this is a waste plot, you cannot do it according to the solid waste management rules which I was referring. I'll just show to your lordship. Rules are copy that. Milord would kindly take Milord schedule 1. Schedule 1 at page 803. Specifications for sanitary landfills.
Yes.
Criteria for site selection. Milord is there with me? Now, Milord kindly turns over to the next page. Clause 7, Roman 7.
Yes.
Milord, I'll just read it out. The landfill site shall be 100 meters away from the river. Clause 7.
Landfill has been defined.
Yes, landfill, Milord, is as such not defined, but it is, Milord, the legal term used for dumping sites.
Does not be defined. yet.
Landfill has not as such been defined, Milord. So far, Milord, I have gone through. Landfill, Milord, has not been defined.
All right. Yes. All right, yes.
Milord would find, Milord, shall be 100 meter away from the river, 200 meter from a pond, 200 meter from highways,
So according to
habitations.
This has been violated.
Absolutely violated. Milord will find, Milord, we have page 55 of the writ petition. Milord, we have given Milord a demonstrative sketch map. Page 55.
Yes.
Milord has, if Milord can locate the dumping site, Milord would find within 5 meters river Corolla, within 25 meters just opposite to the road is a public park, and within 30 to 40 meters, Milord, there are residential apartments. And Milord, this is the reason why, Milord, usage of this site, Milord, has created, Milord, a huge public uproar leading to protests, etc. Milord, all the newspaper reports, Milord, reporting the incident. my lord, I have annexed with the writ petition, my lord would just have a look, my lord, at page 47. Page 47.
Yes.
My lord would find শহরের মাঝে dumping ground, my lord, the kind of protest that has happened over the land, my lord, the next page, page
So it's a
48.
residential area.
Absolutely, adjacent to a residential area. So according to the rules, it has to be at least 200 meters away from a habitation. And most importantly, my lord, the river which is flowing through the only lifeline of Jalpaiguri town, it is not even 5-6 meters away from the river. Just adjacent to the river is the plot. And they're using it as a dumping site. More so, they have a permanent dumping site, which is at Bolapada. But for unknown reasons, my lord, some things which eyes don't meet right now, I don't want to open my mouth too wide. My lord, this is, my lord, an absolutely malified exercise. Absolutely malified exercise, my lord, to grab this property.
Yes.
My lord, in Jalpaiguri municipality, the town produces at an average of 450 grams of solid waste per day, per person. Secondly, my lord, this is not a permanent dumping site. What we do is we collect the garbage, most of it from the town. There is a compactor machine provided by the state government.
No, one thing is that whether you can, whether this is in violation of this solid waste management rules, this clause 7.
My lord, if there is a violation of the solid waste management rules, that will go to the environment, and that has to go to the
That is a different thing altogether. For that, you cannot say that, yes, I will use that.
Yes.
So whether it will go to the environment or not, that will be taken care of.
Yes, ma'am.
So you cannot violate this. You cannot also use for a temporary purpose first. Second is that you also cannot use a private property.
We are not using.
So let an investigation be done
Of course.
with regard to this Moja mob. Let this be demarcated.
Yes.
Which
No
property,
difficulty.
so let the BLRO do that job
Yes, ma'am.
and where it has been done first. Second is you cannot dump anything in violation of this.
Well, on the private land, we are not dumping anything. And if
No, also not on private land, also on public land, you also cannot do this. Please don't dump anything there.
no, my lord,
Because this is in violation of 100 meters away from the river. So are you suggesting that it is beyond 500 meters from the river,
My lord.
200 meters from a pond? You file an affidavit with
yes,
regard
my
to
lord,
that.
that's what I said.
Yes, that is one, but you cannot use that property as a dumping ground for.
Grateful,
No,
grateful.
my lord, if
Extremely
that were to be happen, my lord, the entirety of the Jalpaiguri municipality, the town area, my lord, the municipality waste management will be affected by that. Let us be direction of filing affidavit, will not dump any garbage on the land, alleged land of the petitioner. Let there be demarcation.
Also, you will not violate this. I will record that.
My lord, then
Yes, my lord.
let me.
You will not violate this. You cannot violate these rules.
Of course, I cannot violate this.
So I will record that there will be no dumping in violation of this.
Yes.
Of the rules.
Grateful.
Yes, of these rules.
Yes.
If any.
You will not violate, not if any. So if you are not doing that, you are not doing that. I will restrain you from dumping in violation of this.
And my lord, they have floated a tender. My lord, would kindly see the tender. My
Don't
lord.
take
Will it-
further steps with regard to that
Absolutely,
tender.
yes. Because my lord, the
That is for
tender, my
construction,
lord, the tender board
That's why construction.
says
that
construction,
The machine that we bring there.
the construction of car shed, boundary wall,
That
and
you cannot do
temporary
now.
dumping ground. My lord,
That
let
you
them,
cannot
let
do
them,
now.
my lord, my lord, let them lay their hands away from this till the time, my lord, this exercise is being done.
Well, that has nothing to do with dumping. Well,
No, it
construction of the-
says temporary dumping
On
ground.
my
What
land,
are
I
you
can
saying?
Construct a shed. On my land, I can construct a shed. On my.
But not in violation of this.
Yes.
So I'm not
Do
dumping. I'm not dumping this. The construction may be done for the dumping.
Construction of what?
Well, the shade for the car of the municipality, the compacted car, that for the shade we are giving.
There is an ancillary activity connected with dumping.
No, Mr. Ghosh, that they can do.
No, my lord,
But if it is not, they are not using it for dumping now. They are not using it for dumping those solid waste. They can keep any vehicle there. How can you stop keeping
Miller-
vehicle in their plot?
Miller, I am only saying this because, Miller, physically it is only a 30-35 feet stretch of
Yes,
land that there.
first that
Yes.
that
Let the
demarcation has to be done.
as of now, Miller, let them lay their hands away from this tender in any manner. Once the demarcation report comes, let the court allow them. If they are within their right to do it, they will do it.
No, for the car part, if we're keeping the.
Do that, please. Wait for some. How long this demarcation? Who is for the state? Yes, how long you will take for demarcation? Do it within a week.
We have no difficulty, my lord. On
Do it within a week.
It is to us within a week.
So, I will direct this matter to be posted before the next available.
On the first
petition.
day of the next circuit, I have no
Yes.
difficulty.
Just one.
Do that with demarcation within a week, not 2 weeks. Municipality is saying they have urgency, they have to park cars there.
And Millard also,
And they have the entire dumping.
Millard also records they in the report municipality must produce that the state has allowed them to use that vested land for this purpose. Otherwise, that's again unauthorized.
I will make my affidavit also what part of the land of the petitioner I have to deal with the allegations in the petition matter. But just one more submission, my lord, let it be recorded that we will not violate any violation of the rules, any dumping done by the violation of the rules, that will not, but except the violation of the rules, whatever dumping is done, there shouldn't be any restraint to that. If there is no violation of the rules.
That you can do, not if it is not in violation of that rules. If you are dumping on the property of a private person who gives you consent beyond the stage, that you can do.
Millard, one of the most beautiful part of the Jalpaiguri town, Millard, I don't know for what good reasons. Millard, in spite of having a permanent dumping ground, Millard has been rendered Millard in an absolutely.
Where have you stated, Mr. Ghosh, the particulars of your property?
Yes, Millard would take Millard. Millard can take my record of rights. Millard can record the description from there, Millard.
No, but where have you stated that?
Yes, Millard, take Millard paragraph 9.
Paragraph 9.
9.
LR.
No, Millard, paragraph 5 also.
The error plot number 82 and 10 is not of the petition.
Millard, paragraph
No.
5. Paragraph 5.
Part of 106 is of the petition.
LR plot number 106.
106.
Yes.
The large plot which I have shown.
Like after the demarcation, whatever of the petitioner, that will not come.
Ashun. This application under Article 1, under Article 226 of the Constitution of India is at the instance of a recorded owner.
Two recorded owners.
Is at the instance of the recorded owners of a plot of land, alleging that is at the instance of the recorded owners of a plot of land praying for an order directing the respondent municipality to recall the notice inviting tender dated August 11, 2025 and restraining the authorities of the Jalpaiguri municipality, Jalpaiguri municipality from using the property of the petitioner as well as the using the property of the petitioner as a dumping ground. First paragraph. The petitioner, one or two petitioners claim to be the recorded owners of LR plot number 106 measuring about what is the total measurement?
Millard, petitioner number 1 is Millard 0.12 and petitioner number 2 is Millard 0.32.
So it's 0.44 acres.
Yes.
No, others are also there.
Others are also there. Millard can take page 44. Page 44,
what is
the
the
plot
total measurement
information
of the plot?
Millard, total measurement is 3.80 acres. Page 44 once, Millard.
Page 44.
Yes, that will give Millard your lordship a comprehensive picture. Page 44.
Ki bolna? Total measuring about 3.81 acres. কি বললাম are they along with others claim the petitioners along with others claim to be ঠিক আছে? It has been alleged in the writ petition that the authorities of the Jalpaiguri municipality are throwing garbage on the property of the petitioners without taking consent of the petitioners for such use. Full stop. Paragraph. Mr. Ghosh, learned advocate appearing for the petitioner, submits that the two adjacent plots being LR plot number 10 and 82.
Right.
Being plot numbers 10 and 82. Along with the property of the petitioner being LR plot number 106 are being used as the dumping ground. He submits that the area in question is a predominantly residential area and there is a river very near to the plot of the petitioner and the other plots where the garbage is being thrown at present. And where is that chart, Mr. Ghosh?
Page 55, my lord.
There's a school, you said? No.
Yes, school is there, my lord. That is, my lord, the school will be about 100 meters. School and temple also.
I believe, my lord.
Mr. Ghosh further submits, Mr. Ghosh refers to a sketch map at page 55 of the writ petition and submits that very near to the dumping site, there are public parks and
Residential apartment.
no residential, I've said.
My lord, sports complex, the Sports Authority of
public
India
park,
Sports Complex.
Sports complex, etc. Mr. Ghosh further submits that the locality is a very densely populated locality. Paragraph. Mr. Das, learned advocate, appears for the Jalpaiguri municipality. He disputes the allegation made in the writ petition. Now, he disputes the submission made by Mr. Ghosh. Stop. He submits that no garbage is being dumped on the plot of the petitioner and the vested property are being used as a temporary dumping ground and a tender has been floated. Now, and a notice inviting tender has been issued. And a notice inviting tender has been issued for the purpose of inviting the interested persons to participate in the tender for the purpose of
Tender has been offered to a company.
Let construction of car shed.
For the purpose of construction
of car shed.
Of car shed.
Boundary wall and
Boundary
temporary
wall
dumping
and
ground.
temporary dumping ground. Full stop. আচ্ছা ওই তার আগে না he further submits that none of the provisions of the solid waste management rules 2016 has been violated by the authorities of the municipality. যেখানে মিস্টার ঘোষের সাবমিশনটা ওখানে একটু করে লিখুন তো। Mr. Ghosh refers to the criteria for site selection, which has been specifically mentioned under Schedule 1 to the Solid Waste Management Rules 2016 and submits that the site where the municipality is presently dumping the garbage falls within the restricted area as mentioned under clause VII under under paragraph A of Schedule 1, which deals with criteria for site selection.
For your lordship satisfaction, since your lordship had posed a query on this for the definition, kindly transfer to rule 15 once.
1.5.
1.5. The schedule refers to rule 15, pursuant to which this criteria has been framed. Rule 15 at page 796, internal page. Rule 15.
796. Yes.
Millard would find the marginal note, duties and responsibilities of local authorities, includes municipalities and village panchayats of census towns and urban agglomerations. And Millard would just have a cursory glance. The entire solid waste management plan, door-to-door segregation, collection, dumping, everything is covered under Rule 15. And this schedule, which Millard I have shown your lordship, is Millard framed pursuant to this Millard Rule 15.
Yes. Heard the learned advocate.
Well, one more question. Well, the entire garbage management of the Jalpaiguri town and municipality severely be hampered if this plot is not.
Achha. The learned advocate appearing for the municipality submits that the entire garbage management of the Jalpaiguri municipality will be affected if any interim order is passed. First of paragraph. Heard the learned advocate for the state. First, the first issue that arises for consideration is whether a property of a private person. Now, the first issue that arises for consideration is whether the property of the petitioners can be utilized for temporary, for a dumping ground, whether temporary or permanent, without obtaining any consent from the recorded owners or by way of acquisition or requisition of such property in accordance with law. Full stop. It is not the case of the petition, it is not the case of the municipality that the property of the petitioner has been acquired or requisitioned for the purpose of using the same as a dumping ground. Full stop. On the contrary, it is the submission of the learned advocate for the municipality that the adjacent plots being plot number 10 and 82,
LR.
being LR plot numbers 10 and 82 are being utilized for dumping garbage thereon for a temporary period. Full stop. There is no as it appears from the submission, and as it transpired from the submission of the learned advocates for the respective parties, that there is no physical that there is no boundary wall demarcating that there is no boundary wall separating plot numbers 1082, LR plot numbers 1082 and 106. Full stop. In view thereof, it is necessary to demarcate the plot numbers 1082, LR plot numbers 1082 and 106. Full stop.
Respondent number 7.
The Block Land and Land Reforms Officer, Jalpaiguri Sodor, is directed to cause an inspection of the disputed plots through competent surveyors, cause an inspection of the disputed plots and engage competent surveyors for the who shall survey the disputed plot numbers 10, 82 and 106 and prepare a sketch map and the Block Land and Land Reforms Officer Jalpaiguri Sodor shall file a report annexing the copies of the sketch map. The work of demarcation shall be completed as expeditiously as possible, but positively within a period of but positively on or before November 13, 2025, and the report thereof shall be filed before this court, and the report shall be served, and an advance copy of the report shall be served upon the learned advocate for the petitioner since when the next circuit is starting?
17.
17. On or before November 17, 2025. Full stop.
Notice of demarcation to be given to us also, so that we are physically present. All the plot owners.
Advance copy of the report বললাম যেখানে ওই shall cause an inspection of the property বলেছি না, upon serving cause an inspection of the suit property and engage কি বললাম for the purpose of such inspection shall be carried out upon serving a notice in advance to the petitioners, to the petitioners, or any other person who may be affected, who are necessary for the purpose of, whose presence may be necessary at the time of making such survey/demarcation of the plots.
Also the responding municipality.
And the Jalpaiguri municipality.
Yep.
ঠিক আছে? Full stop. Paragraph. After going through the Solid Waste Management Rules 2016. This court finds that Rule 15 deals with the duties and responsibilities of local authorities and village panchayats of census towns and urban agglomeration. Schedule 1 deals with specifications for sanitary landfills and one of the criteria for site selection as mentioned under clause VIII states as follows. বলে এটা না সেট আউট করবেন। In the sketch map annexed to the writ petition, it has been indicated that page 55.
Page 55, and Millard, in my pleadings, Millard, I have prepared a chart also. Millard, page 10 of the writ petition. That would be, Millard, more convenient for your lordship to consider.
Will I dispute this, my lord?
Yes, yes. Aja. In paragraph 13 of the writ petition, it has been specifically stated that there is a decade-old temple within 70-80 meters, semicolon, a school within 70-80 meters, residential apartments within 30 to 40 meters, semicolon, a sports complex. This is Bangla a sports complex administered by Sports Authority of India within 70 meters, semicolon, public park adjacent to Kerala River situated within 25 meters, and Kerala River is exactly opposite is adjacent to the dumping ground that is within 5 to 10 meters thereof.
Yes.
Paragraph. Mr. Das, learned advocate appearing for the Jalpaiguri municipality, disputes the statements made in paragraph 13 of the writ petition. He further submits that the property of the property where the LR plots of land being numbers 10 and 82, which the municipality is presently using as a temporary dumping ground, is not within the restricted area as mentioned under clause VII under serial number A of Schedule 1. Full stop. After going through clause VII of under paragraph A of Schedule 1, it appears to this court that a landfill site shall be 100 meters away from river, 200 meters from a pond, 200 meters from highways, habitations, public parks and water supply wells, and 20 kilometers away from airports or airbase. To stop. After going through the sketch map and the MOSA map produced by the petitioners in course of hearing,
The photographs also, photographs.
as well as the photographs produced by the petitioner, as well as the photographs annexed to this writ petition, it prima facie appears to this court that the property which the municipality, that plot numbers 10, LR plot numbers 1082, which the municipality claims to be using as a temporary dumping ground, is within 100 meters of the Corolla River and in a densely populated locality and in a densely populated residential area. Full stop. For such reason, this court is inclined to pass an interim order. Full stop. Let affidavit let a report in the form of an affidavit be filed by the municipality on or before November 17, 2025, indicating specifically the right of the municipality to use LR plot numbers 10 and 82 to use the same as a temporary dumping ground. Full stop. Paragraph. There shall be an interim order restraining the municipality from using the property of the petitioner from utilizing the property of the petitioner as a dumping ground until further orders. Full stop. The municipality is also restrained from dumping any from utilizing any plot from utilizing plot numbers 10 and 82, LR plot numbers 10 and 82 as a temporary dumping ground if the same is falls within the restricted area as mentioned under clause VII under paragraph A of Schedule 1. Until further orders. Full stop. Yes, what is the stage of that tender?
Nothing happened.
Nothing happened.
Let
So
them
you
let
can
their hands off
let
from
them proceed with the tender, but no final decision shall be, no work order shall
work
be.
order has been granted. On field, no construction has started.
Work order has been
yes,
granted.
Yes, so
Okay.
let them lay their hands off from the dumping.
The learned advocate appearing for the municipality submits that work order in respect of the notice inviting tender dated August 11, 2025 has been issued, but no steps for construction pursuant to the said work order has started till date. To stop, there shall be an order restraining the but whether the successful tenderer is a party.
We have not made them a party as of. So let the municipality not give any effect to the tender.
The municipality is directed to restrain. Now, the municipality is directed not to take any steps, is restrained from making any construction pursuant to the said notice inviting tender through the successful through any successful bidder until further orders.
My lord, grateful.
Full stop. List this matter. Under the heading motion on November 17, 2025. Full stop. Parties will be at liberty to mention this matter before the bench if the occasion so arises.
My lord, I claim for that, my lord, whatever there is no violation, what part of the land is not violated by the solid waste management rules and not the land of the.
I've only restrained you.
My lord, just may record that, my lord. That
What? I've only restrained you. You cannot do
just
that.
one line for my satisfaction. That, my lord,
What?
the part where there is no violation, we can use that for dumping. If there is no violation.
My lord, how can they?
No. If there is no violation of the
This
management
property
rules,
you cannot utilize.
property we are not utilizing. My lord, may just record
Well,
that for my-
until and unless, my lord, that is
For my
demarcated, my lord, in any event, they cannot
no,
utilize.
demarcation-
Until and unless the
It is
demarcation is being done.
outside that, you are not in any way.
Outside, solid waste management rules will
That-
come in the way.
He said outside that. If
Outside
it is,
violation of-
if it is
Except
beyond
this-
yes. Mr. Das, learned advocate, appearing for the municipality submits that the municipality be permitted to use any property as a dumping ground in accordance with the criteria for selection of site as mentioned in the
Solid
waste management rules 2016.
Yes.
To stop, it will be open to the municipality to select a site in accordance with the provisions of the solid waste management rules 2016.
Yes.
Grateful.
My lord, if I can take back the map.
Map, all right, take it back.
My lord, that's annexed to the writ petition
So
also.
it has been annexed.
Yes. Since that's slightly in a smaller scale, I handed up the. Grateful.
Yes.
Is it item number 33, my lord?
73, yes.
My lord, in
Anything
this
was
matter,
mentioned,
Lord,
who has mentioned?
Lord, in this matter, Lord, I appear virtually from Kolkata.
Yes.
Actually, matter, Lord, this is a third can in the pending writ petition. Lord, I appear for the petitioner. Lord, there was a sexual harassment case against the petitioner. Suspension was there, that has been lifted. Can 1 was disposed. Then, Lord, financial benefits, second can, that was also disposed. The third can is still pending, Lord, which is before your lordship. That's why it was mentioned before your lordship today in the morning. Now, thing is this, Lord, the petitioner is not being allowed by the university. He is an associate professor in the and Lord, head of the Department of Botany in North Bengal University. Now, Lord, thing is this, Lord, he is not being allowed despite, Lord, suspension order has been lifted. Lord, and Lord, the last order that was, Lord, recorded on 29th April 2025. Lord, university was directed to allow the petitioner, Lord, to perform his regular academic and administrative duties. That is not being allowed. That is the only problem now.
So if that is not being allowed, so you can pray for violation of the file a contempt application. An order of the coordinate bench has been violated. So you can file a contempt application. Why a fresh application?
No, Lord, in fact, Lord, there was a direction to file a report by the university. That has not been filed as yet.
So that is a different thing altogether. So, but in the CAN application, you have prayed for a relief that has already been granted.
Your lordship, kindly consider prayer B and C of the third application. Prayer B and C. Can 3. Those are the two prayers, Lord, which I want to, Lord, canvass before your lordship. Lord, that should be allowed.
But there is one thing. By
Yes.
the order dated 29th of April,
Yes,
you are the university was directed to allow you to perform your normal duties.
Right,
Normal
right.
duties includes everything. So that is exactly what you are praying under clause B, prayer B. So that has been
Yes.
already granted. So if that is
No.
granted, no separate order is necessary. And if there is a
No.
violation, you have to file contempt.
But,
Clause C says, consider and dispose of the petitioner's representation for promotion.
Yes.
That was not part of the original writ petition. Prayers are not aligned with the original writ petition. Separate can petitions are filed on different cause of action. Well, see the prayers in the writ
But even if
sexual harassment case, ICC committee was. ICC
So what happened to that?
ICC recommended punishment.
Yes.
Now, within that punishment period, that punishment was lifted because it was a mere minimum punishment of 1 year. Now, my lord, during the pendency of the writ petition, this 1 year expired. Suspensions was lifted by the order of the court. We will find the order of the court. The suspension lifted. Now, immediately he was allowed to resume duty. Now, what has been? This is a post of a professor, my lord. The allegation was for grave sexual harassment.
So
Now,
what have you done? What disciplinary proceedings have you initiated?
No disciplinary proceeding initiated. ICC initiated.
ICC is a different thing altogether. ICC can only make a recommendation.
My lord, what has?
So after that, it has to be a disciplinary. So what have you done? What's the stage now?
I'll tell you.
Nothing has been done.
Not have.
Mr. Rai, please, yes.
Not, my lord knows under the North Bengal University Act, section, we can only apply section 10. What has happened? The university does not have a vice chancellor for the last 3 years.
For that, you cannot keep a person suspended or from not attending for times.
That is not the issue.
That's your headache. Whether you have a vice chancellor or not.
Let me appraise.
Yes.
My lord, registrar has immediately allowed him to resume duty.
Yes.
The departmental committee has allowed to resume all class. Calendars were provided, calendars everything. Now his grievances is, since my PhD scholars are not coming to me, that's the grievances which I have said. What has happened? Few, my lord, lady, there were students who had joined him on for a research scholar. Now subsequently, probably for some reason, they wanted to withdraw from him. Now he is under the impression that the disciplinary committee is someone trying to provoke and not allowing him to.
No, but now, as on date,
he has provided me a calendar.
There was some recommendation by the ICC.
Right.
So ICC recommended a disciplinary proceedings to be initiated.
Right.
That's the only domain of the ICC.
Yes.
ICC cannot
go further.
Yes, travel further. So now, after the ICC's recommendation, you have not taken any further steps.
We have some.
You have not taken any further steps. If you have not taken any further steps, then the
proceeding is dropped. In a way, it is dropped.
Yes. So if the proceedings is dropped, so what remains in the writ petition?
There's nothing.
What is the challenge in the writ petition?
See in the writ petition. Look at page 13 and 14. All has been met.
No, but the question, there are some things. Have you released any all the areas? Have you exonerated him?
Exonerated him, my lord. That
has to be. If you do not, either you have to commence a disciplinary proceedings and to conclude that within a time frame. If not, yes, you have to exonerate him and he is to be entitled to everything. So why these prayers are not to be allowed here?
My lord, he has to be exonerated.
Yes, who will exonerate him?
Exonerate the committee of vice chancellor, VC and control.
Sir, if the VC is not appointed, someone is to act as a VC, is being given the charge of a VC. I think that
no one.
But
no one is
in the last
performing the
order,
duties.
register was directed.
So if that is not been done, so then you have to exonerate him.
But who will do it? That's the issue.
That was the direction. Register was directed.
Who has no disciplinary proceedings? Who has initiated the disciplinary? So there is no disciplinary proceedings. So release all areas. How can you withhold those?
Areas, I'll have
It's
to hear.
up to you to initiate a disciplinary proceedings.
Yes.
If you say, I do not have a vice chancellor, I do not have an acting vice chancellor, it's your problem. But it is that you have not initiated any disciplinary proceedings. If you have not initiated any disciplinary proceedings pursuant to the recommendation of the ICC, you cannot withhold any payment. Please release everything.
Payment
He is
actually-
entitled to career advancement, everything, give it to
I
him.
think that's done, my lord, because that's not the part of the prayer in this care. I think that's done.
What is done?
Area, everything.
Paid.
Paid.
Career advancement,
That I'll have to take instructions.
that is his prayer.
No, in this can, my lord, that's not the prayer.
Yes, prayer C. Promotion you cannot also withhold because there is no disciplinary proceedings either initiated or contemplated as on date.
Career advance, my lord. It
Yes.
means that an application has been filed, my lord.
Yes.
What is, my lord, can we, allow me one day, my lord. I'll come with whatever instruction it is tomorrow, my lord, I can appraise, my lord, on this aspect. That I can do.
Either you punish,
My lord,
you initiate a proceedings, punish him, whatever you do. You cannot keep him by saying yes, I do not have vice chancellor, I do not have anything. Yes, you stay there as it is. I will not pay you anything. You will not be entitled to career advancement, nothing. You cannot go on with that.
My lord, under the act, my lord, no one is involved. That's the problem.
It's your headache.
That's my headache. But
Yes.
so we see the controller.
May I just
The
may I
registrar
just
say,
request
look,
your
I'm also
lordship
not. But he has been duly given an academic calendar. He's doing his job. But there are some disputes. But this I'll have to look at.
No, with regard to whether those scholars are coming to him or not, that's a different thing altogether. The court also cannot direct in view of the allegation. But he's entitled to all the benefits, areas, if you have paid,
I
it's
think
one
that's
thing.
what I can appreciate.
Career advancement, all the benefits, you cannot withhold any benefits of the petitioner as on date when there is no disciplinary proceedings initiated.
Can we file a report, my lord, to be said?
What report? Take instructions. If there is nothing, I will direct you to consider. Yes, Mr. Rai, I'm directing, I will let him take instructions because you want the other reliefs have already been granted. If according to you there is any violation, you have to apply for contempt. And with regard to the prayer C, career advancement, let him take instructions.
Yes, but prayer B and C, your lordship kindly consider this, Lord.
Prayer B, Mr. Rai, has already been granted in your favor by a coordinate bench. How can I cannot again pass on a similar order.
But administrative and academic duties are being restricted, Lord. That is the whole problem.
Mr. Rai, the order of 29th of April states that directed to permit to perform his regular duties, provided there is no order restricting him to do the same.
But since Lord register was directed to file a report and Lord comply with your lordship's order.
No, yes, whether he is being allowed to perform regular duties.
Yes, my lord, I can, with all impunity, I can say yes.
I'm recording your submission.
Record.
Yes, Mr. Rai, he is saying that you have been allowed to perform your regular duties.
Lord, only Lord, I am repeating, Lord, prayer B and C are not being allowed. Prayer B and C.
Prayer B. What is your prayer B?
Regular academic and administrative duties. Lord, some hindrances are there when university is not taking proper steps in accordance with your lordship's order. Grant of
Then let
access
them
to
file.
research scholar.
Let them file an opposition to this application. Let them file that application.
A report was directed to be filed on the last occasion. That has not been done.
No, report on the scan. Not on the scan.
On the scan.
Where
on
is that? Which order?
Report was directed to be filed.
Which order?
Lord, 29.4, your lordship kindly sees. 29.4.
29.4, can 3 was not taken up. It was only can 1. Can 3 was not taken up.
Can 3 was not taken up. Right.
Yes.
Lord.
So I'm directing them to use an opposition to this.
All
or
right.
a report. File a report. Ashun. Mr. Rai, learned advocate appearing for the Mr. Rai, learned senior advocate appearing for the petitioner, submits that the university authorities have not allowed the petitioner to perform his regular duties. To stop, he further submits that the university authorities have also not considered the petitioner, they considered the entitlement of the petitioner to be promoted from assistant professors within bracket stage 4.
Associate professor 2.
From assistant professor stage 4.
Associate professor.
Oh, sorry, associate professor stage 4 to professor stage 5 under the career advancement scheme. Full stop. The learner let a report in the form of an affidavit be filed by the, which respondent will file?
2 and 3, man.
2 and 3 both.
3 will file, but since 2 is not the only allowed 3.
Be filed by the Registrar University of North Bengal being the third respondent within a period of?
Man, will to give me 2 weeks, man.
Within a period of 2 weeks from date. List this matter under the heading application before the
only one submission, Lord. Kindly, Lord, record that the university should exonerate me by later, because no departmental proceeding has been initiated, as your lordship has observed.
That is not the prayer in the can, Mr. Rai. Those observations are
correct. Since your lordship has observed, Lord, that would definitely, Lord, in your justice to the
can
petition.
be taken up, and the writ petition, if that is exonerated, that order is passed, nothing remains to be decided in the writ petition, Mr. Rai. Then they cannot file a report on the can. If the main
Since your lordship has observed that they have exonerated me, let it be in speaking.
No. I have not
Let
said
there
they have
be
exonerated you.
I
I have said that they have to.
My learned friend appearing for the university has said that they have not taken any steps. So let it be recorded, Lord. As on date, they have not taken any initiative.
Can 3 order pass. List can 3 of 2025 under the heading application after 2 weeks. Yes, call the next matter.
My lord, in this matter, I appear for the petitioner. I'm being led by Mr. Pulkrit Verma.
My lord,
Appearing virtually.
You are led by Mr.
Verma. Appearing
Yes.
virtually.
my lords, in item number 118.
And Mr. Bonik is also appearing virtually, I believe, for Union of India.
My lord, the senior counsel, Mr. Bonik, is not able to appear because he has gone to the funeral of a ex learned counsel, my lords.
My lords may keep it tomorrow. I have no issues. My lords.
Then let it appear before the next.
My lord, there is an urgency,
What
my
is
lord.
the
My lords, the urgency, my lords, that why I am putting emphasis for tomorrow, my lords, it's only because
Yes,
I
then
need-
move your application. Yes, let me see what is the urgency. Yes.
My lord, this is a challenge to the order which has been passed under 129.3. For a moment, my lords may have section 129.3.
149.3 of which act?
129 of the Central GST Act, my lords.
Yes.
It says, my lords, that
ওই এটা নেই section
129 of the
yes
Central GST Act, my lords.
Yes.
Notwithstanding anything contained in this act where any person transports any goods or stores any goods while they were in transit in contravention to the provisions of this act or the rules made thereunder, all such goods and conveyance used by the means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable for the detention or seizure, and after detention or seizure shall be released upon payment of penalty equivalent to 200% of the tax payable, and in case of exempted goods and on payment of an amount equal to 2% of the value of goods or 25,000, whichever is less, where the owner comes forward. Now, my lord, my only dispute is regarding the word owner. Who will be considered as the owner in this case, my lords?
Sir, where is the impugned order 17th of July? Which page?
Yes, my lords. The impugned order is at page, my lords.
46 to 47.
147, my lords.
147.
146, my lords.
146.
Yes.
My lords, the relevant is at page 152. Paragraph number 8, 9 and 10, my lords.
Yes.
My lords, the main dispute is that at paragraph number, my lords,
Yes.
yes, my lords, they have written that I have not attended the personal hearing. They have offered me on 29/7/2025, my lords. I was there at that place. The gate pass, I also have the gate pass, my lords. They can also verify from it. No personal hearing was offered to me, my lords. The penalty was being levied equal to the amount of value of goods, my lords. That is my main contention, my lords. Despite I was available, I have the tickets, I have annexed it at Annex to P23, my lords. I went there for the personal hearing. They did not grant me any personal hearing. The officer
This
was
is an appellable order.
no, my lords, why I'm saying it, my lords, there are two reasons for it. There is a non-application of mine because none of my submissions has been considered. Second, my lords, he has levied penalty under 129(1)(a) as well as B, which he cannot do that. Under 129(1)(a), the penalty is 200% of the tax payable. However, he have also levied the penalty under 129(b), but which is 100% equal to 100% of the value of the goods, my lords. That completely shows the non-application of mind. I was not given any opportunity. The penalty has been levied on me. I have given the representation to them to release my goods. I am ready to pay the penalty under 129(1)(a). They have not given me any answer. That's why I am before your lordships in this case, that at least my goods shall be released, my lords, on immediate basis upon a furnishing a bank guarantee under 129(1)(a). My only relief,
My lord,
urgent relief is this for this matter, my lords.
Yes. Yes, what do you
my
say?
lord, the learned petitioner has misconstrued the notice, the order, because in the order, my lords may turn to page 47.
Page
47, my lords.
Yes.
There are not only the current petitioner is not only the noticee or the noticee, there are 4 persons in total notices.
Yes.
And my lords, we kindly look at the section 129. There are 2 provisions, A and B, in which A is for the person, is the owner.
Yes.
My lord, A is provision A is is applicable only when the owners of the goods come
When the
forth.
goods were intercepted. Sir, when
My
the
lord?
goods were intercepted.
My goods were intercepted on 11th of July 2 a.m.
Yes, what is the nature of the goods?
My lord, dried
It's,
Erica nuts. Erica nuts.
And the my
And
lord,
when you have
may
filed the
kindly
writ petition,
My
when
lord,
you have filed the writ petition,
my lord, this writ petition
They
was
filed
filed on 3rd of October, my lords.
so after 3 months.
No, my lords, why it has been filed,
Yes,
there is a reason. I have given a specific representation to them in the meanwhile to release my goods so that I can get my goods released. I am merely paying for it that my goods may released under 129(1)(a), my lords. I am ready to pay the bank guarantee and statute.
What do you say to that? If he agrees to pay the bank guarantee for that amount?
So that I can avail my
lord,
yes.
All right. Mr. Bonik will be available tomorrow.
Yes, my lords, may keep in the top of the list, my lords.
All right. List this matter tomorrow. Yes. An accommodation has been sought for on the ground of Mr. Bonik, learned advocate, appearing for the CGST authorities.
My lord, any specific time at what time it will be? Then I'll ask him to do that.
Yes.
My lord, any specific time?
Specific time, madam, please follow the list. Yes. Next.
But I was the petitioner, my lord.
Yes.
And in this application, we are challenging the appellate order dated 31st July 2025.
passed by the appellate authority. Well, kindly come to page 49. This is impugned order is annexed in the writ petition.
Page?
Page 49 of the writ petition, madam.
Yes.
The appeal was rejected on the ground of there is a delay in filing appeal, and the notices, all the show cause notices and the intimation, as well as the adjudication order was uploaded in the additional notices and orders.
When?
And in the year 2024, my lord. The first show cause
24 when?
23rd of
Prior
February.
to 16 January or after 16 January?
The 23rd of February 2024, my lord.
So on that date, Mr. Mojumdar, the GST portal was rectified and the
Well, it's-
additional notice was also can be visible.
No, man, it was particularly, my lord, it was saying, my lord, department is saying that it was rectified, but subsequently I have found, man, I have done many cases. It was uploaded after July also, my lord. They have uploaded in the July also additional notices.
It was, where have you stated that when it was uploaded here?
My lord, in the writ petition I have stated, my lord, kindly come to paragraph, my lord. And also they have kindly see the impugned order itself, my lord. Kindly come to paragraph 2, my lord. Page 49.
Paragraph 2, page?
Page 49, my lord. Page 49, the impugned order itself, my lord, kindly.
Yes.
The reason why, my lord, clause B, the reason shown by you by your filing of the appeal with the delay of 7 months.
Yes, who is for
was
the
due to
WBGST?
Yes, my lord.
Yes, what do you say? Give me the similar order.
My lord, in case of Shankar Agarwal, my lord has passed on my junior appeal on the last occasion. That is on the 3rd of November 2025.
This appeal was filed after the condonable period. Mr.
Yes, my
Majumdar,
lord.
this
There is a delay, my lord. We came to know only on in the month of June 2025. Then we filed an appeal on 6th of June 2025.
page 49, page 49. Mr. Majumdar, you also could not file the reply to the show cause notice.
No reply, my lord. We could not file any reply to the show cause notice. Neither file the reply to the DRC 01A, that is intimation also. But intimation is page 23 and the show cause notice is page 32 of the writ petition.
So I'm relegating that to the stage of the filing of the reply to the show cause notice because no useful purpose will be served in directing the appeal to be heard on merits.
Yes, madam. Grateful, madam.
This application under Article 226 of the Constitution of India is directed against an order dated. Which page is the appellate order? Is
Page
directed against
49, madam. Page 49.
Against an order dated
31st
July 31, 2025, passed by the additional commissioner being the appellate authority, Siliguri Circle and Rayaganj Circle, Siliguri Circle and Rayaganj Circle.
Yes, ma'am.
Full stop. By the order impugned, the appeal was rejected on the ground that the same was filed beyond the condonable period. Full stop. The petitioner, where is the show cause notice?
Page, my lord, page 32.
Page 32.
My lord, before that, there is a DRC 01A, the intimation at page 21, 23 and 21. This is the intimation.
All right. So a show cause, what is the date of the show cause notice?
Show cause notice dated 2nd May 2024.
A show cause notice dated May 2, 2024 was issued alleging that certain discrepancies were found upon examination of the returns filed for the period 1/4/2019 to 31/3/2020, and the petitioner was directed to pay the tax, interest, and any other amount arising from such discrepancy or furnish an explanation for the discrepancy indicated in the show cause notice. Full stop. The show cause notice was followed by an adjudication order passed under section 73 within bracket 9 of the WBGST.
Yes,
of the
madam.
WBGST Act.
Page 37, my lord. Page 37, order
was
dated.
followed by an on 31/7/2025. First of paragraph. Mr. Mojumdar, learned advocate, appearing for the petitioner, submits that the petitioner could not file. The petitioner was not aware of the issuance of the show cause notice, as the same was uploaded under the additional notices and orders, double inverted comma মধ্যে tab, as opposed to the normal tab, TAB, as opposed to the normal tab. Full stop. He therefore he submits that immediately after coming to immediately after being aware of the adjudication order, the petitioner preferred an appeal, and since there was a delay in filing such appeal, an application for condonation of delay was also filed. Mr. Mojumdar submits that the delay in presenting the appeal was only because the petitioner was not aware of the uploading of the show cause notice. Mr. Mojumdar places reliance upon an order, upon a judgment dated November 3, 2025, passed by this court in WPA 2116 of 2025, in the case of Shankar Agarwala versus the Joint Commissioner of CGST and Central Excise within bracket appeal bracket close Siliguri Appeal Commissionerate and others, in support of his contention that the petitioner should be afforded an opportunity to contest these proceedings from the stage of filing the reply to the show cause notice.
Yes,
Heard the learned advocate for the WBGST authorities. He submits that the petitioner he submits that since the appeal was presented beyond the condonable period, the appellate authority was right in dismissing this appeal on the ground of limitation. On the ground that the same was time barred. On the ground that the same was time barred. Paragraph. It is not in dispute that the show cause notice was uploaded under the additional tab as opposed to the normal tab. It is well settled that the period of limited, it is well settled that there has to be an effective communication of a show cause notice to enable the party against whom contemplated to the same. Section 74 within bracket 5 of the WBGST Act states that Section 75 within bracket 4 of the WBGST Act lays down the general provisions relating to determination of tax. It has been, it states that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. First of all, after going through the show cause notice, this court finds that an adverse decision was contemplated against the petitioner. First of, this court has already observed that there was no effective communication of the show cause notice, as the same was uploaded under the normal tab and not under the was uploaded under the additional tab and not under the normal tab. First up, since the petitioner did not get any opportunity, since the petitioner was prevented by sufficient cause for not filing the reply to the show cause notice, this court is inclined to grant a last opportunity to the petitioner to contest the proceeding from the stage of filing the reply to the show cause notice.
Great.
The decision in the case of in Shankar Agarwala, within bracket Supra, this court on more or less identical facts had allowed the petitioner therein to file a reply to the show cause notice after setting aside the order passed by the appellate authority dismissing the appeal on the ground that the appeal was time barred. The said decision shall squarely apply to the case on hand. Full stop. For all the reasons as aforesaid, the writ petition stands allowed. The order of adjudication dated
30th July 2024, my lord. Page 37.
Page 37.
In this one.
The order of adjudication dated July 30, 2024, and the appellate order dated 31st of July 2025 are set aside subject to the condition that the petitioner shall file the reply to the show cause notice dated.
Show cause notice dated, my lord, that is 2nd May 2024.
2nd May
2024.
2nd May
Page 32.
2024, within a period of 3 weeks from the date of receipt
Grateful.
of a server copy of this order.
Grateful, my lord.
In the event the reply to the show cause notice is filed within the time limit mentioned herein before, the adjudicating authority being the which respondent? Second respondent.
Two, my lord.
Second
Respondent number
respondent
two.
shall fix a date and time of hearing after serving and shall serve a notice of hearing to the petitioner. First up, it is however made clear that in the event the petitioner fails to submit the reply within the time limit indicated herein before, this order shall not inure to the benefit of the petitioner, and the writ petition shall automatically stand dismissed without any further reference to this court. To stop with the above observations and directions. Now, ওটা তো বলে দিয়েছি stands allowed বলে বলা আছে, ঠিক আছে?
Grateful, my lord.
No order as to costs. Yes, next.
Grateful.
Call the next matter.
Item number 34, I am having the petition.
Yes, yes.
School teacher, teacher is claiming the interest on only area coming.
Yes, Mr. Shah, what do you say? Yes, yes.
Taking the interest on area coming. I have made the necessary correction.
Yes, Mr. Shah. Next. Yes.
But I'm for the state.
Yes.
Sir, I'm for the petition. Matter related to transfer of a
Transfer.
primary.
Who will consider?
Respondent
Respondent number 6 to consider disposed of next. Yes,
35, my lord, I am appearing for the DPSC Kuch Bihar, my lord.
please give your appearance. Yes.
Yes, my lord.
36, who is appearing? What is this matter?
Traveling without e-way bill and tax invoice. The vehicle was traveling without e-way bill and tax invoice. So they have been
Without e-way bill or the validity period expired?
without e-way bill.
If I may be pleased, your lordship, I am for the petitioner. In this matter, your lordship, the only allegation is that I could not produce a physical copy of the tax invoice or the e-way bill. They have not
Physical copy of the e-way bill.
tax invoice. They have stated that physical copy of the documents. They have not mentioned that the tax invoice or the e-way bill. Later on, when we have produced
What were the documents you are carrying at the time of movement
tax
of the
invoice
goods?
and the e-way bill, both, your lordship.
Both.
Both, your lordship.
Both physical copy.
Both digital copy we have, and we have produced that before the adjudicating
I think
authority.
I have passed an order on that.
Yes, your lordship.
Once kindly see the invoice page number 30.
Page 30. Yes.
Says bill to Manish Kumar. It doesn't bear any GSTN number. But this person has a GSTN number. And it was dispatched from Manish Kumar, Ghuramor Shilugu. And my lord, they have suppressed those facts, my lord, in the tax invoice and in the e-way bill.
Where is the
Your
order?
lordship.
Where is the
My lord,
Your lordship, if I may place my case before.
all right, all right.
Yes, your lordship. I'm grateful, your lordship. Your lordship, the simple facts are, if your lordship can come to page 35, your lordship. Your lordship is,
35?
yes, your lordship.
Yes.
The MOV1. The MOV1 states that your lordship, no document. On the upper hand, they says physical copy tendered. It is not the case of the adjudicating authority or the appellate authority that there was any discrepancy with regard to the tax invoice, the details of the tax invoice or anything with that sort.
Yes.
With that, your lordship, kindly come to page 53, the order of the adjudicating authority.
Yes.
The order of the adjudicating authority, they have the last para, your lordship.
Yes.
Fourth line. The advocate, Mr. produced the tax invoice supposedly to this transaction. Therefore, we have produced the tax.
53.
53, your lordship. This is the order, impugned order, the order of the adjudicating authority.
So where have you said the advocate? Where is that?
The last portion, your lordship. It would be pertinent to take,
Yes.
to take note, your lordship, the fourth paragraph. The advocate, Mr.
Oh, yes. The advocate, yes.
Yes, produces a tax invoice supposedly to this transaction, have reasons to believe that it may be prepared after the interception of the conveyance. Your lordship, in the e-way bill which we have generated, and it was there, it was produced before the interception, and there the tax invoice number was also there.
Where is the e-way bill?
E-way bill is at page 31, your lordship.
31.
31. Your lordship, the document number is also there. The time of e-way bill is 10:11 p.m.
But did you produce the e-way bill
Yes,
when it
your
was intercepted?
Yes, your lordship. We have produced it in the digital copy.
You have produced in the
Digital copy. And it was also,
Where have you stated that?
your lordship, we have stated in my writ petition, your lordship, that all the invoices were produced, all the documents were produced in the digital copy. Even they have not disputed that. Even they have not
Where have you said
disputed.
which paragraph?
Your lordship.
I mean, Sarkar, the reasons was that no physical copy was produced.
Yes.
81.
Page 4, para D, I have stated that, your lordship, that we have produced the digital copies.
Yes.
second para onwards.
Yes.
On query, the learned heir admitted that the tax invoice issued was not an e-invoice and physical copy of the tax invoice was not with the driver in charge.
Yes.
He submitted that though the tax invoice and e-way bill were issued on 14/8/2024 before the interception of the vehicle on 14/8/2024, but no physical copies carried with the consignment by the driver in charge. She argued that the driver of the vehicle shown the WhatsApp copies of both tax invoice and e-way bill on interception. She further argued that as the e-way bill was generated before the interception of the vehicle, hence that proved the absence of any modified intention of evasion. Learned heir was asked to clarify if the relevant tax invoice, not a e-invoice uploaded at this stage, was issued on 14/8/2024 before the movement of the goods initiated, then why the same was not with the driver of the vehicle in charge. But she failed to explain the reason and remained silent. Again, it was observed that from the tax invoice uploaded with APL 01, in the instant case, goods were sold by Messrs. Sri Balaji Bhandar, having GSTN such and such of Dhanbad to Manish Kumar, URP of Purnia, but invoice lacking any identifiable address of the recipient. Again, the invoice uploaded with the APL 01 has no signature of the consignor, violating Rule 46E and 46Q. Hence, the uploaded tax invoice not qualified as a valid tax invoice under Rule 46 of the Act. Again, from the uploaded tax invoice, it is observed that the goods were dispatched from Manish Kumar, Bhora Mode, Siliguri, and delivery shown to Manish Kumar, Punia, Bihar. From the BO portal, it is observed that appellant has no additional place of business at Siliguri or anywhere in West Bengal. Consignment notes produced uploaded at this stage, though the transaction described as an interstate transaction on query, learned AR failed to explain the same satisfactorily.
Your Lordship, was this the case of the adjudicating intercepting officer? It was not. Whereas, Your Lordship, the second page of the appellate authority says.
On facts, let affidavits be
Your
filed.
Lordship, I have.
Let affidavit
Your
in
Lordship,
opposition. Let affidavit in opposition be filed.
Your Lordship, can you give given on the next circuit, Your Lordship? I'll take it
Let
to the next
affidavit in
circuit.
opposition be filed.
Your Lordship, please.
Within 2 weeks from date. Reply thereto. 3 weeks from date. Reply thereto.
Your
Madam, please do it within 2 weeks so that they can avail the next.
Your Lordship,
In opposition, my lord.
and they do not file the one.
My lord.
You will get 1 week entire. You will get.
3 weeks, my lord. Make it 3 weeks.
Your Lordship, kindly give it to the next circuit. Before Your Lordship, covered by Your Lordship decision.
2 weeks from the. This is.
No, Your Lordship,
I
if
know, I'm
Your
aware
Lordship
of
could
that
take
order.
it to page
These are the
82.
factual disputes. Those were not.
Your Lordship, kindly take page 82, Your Lordship. Kindly take page
aware
82.
of that. Before you said, I have asked. I have told Ms. Sarkar that I have delivered a judgment on this.
Yes, Your Lordship, the men's state, the
here
men's
the
is
fact-
not important.
Here the facts are in dispute. You will let affidavit in opposition be filed within 2 weeks from date.
Yes.
Full stop reply thereto be filed within a week thereafter. Parties will be at liberty to mention this matter for enlistment under the heading hearing immediately after expiry of the time fixed for exchange of affidavits. Yes, call the next matter.
Lordship, in the next matter, again,
Without exchange of affidavit, this tax
the
amount-
allegations were there that the
disputed
physical,
tax, my lord.
the digital invoice was produced, the
No,
physical
difference
copy
quantity
wasn't
of
in.
goods, no tax invoice
Lordship,
produced.
the difference in the quantity of
Both the
goods,
supplier and
Lordship,
buyer-
I
Same order.
My lord. I'm grateful.
Yes, next.
Item number 38, my lord, I appear for the petitioner, my lord. 38, my lord, I appear for the petitioner.
Yes.
My lord, very innocuous prayer has been made by the petitioner that, my lord, Section 8 of the Land Acquisition Act 1894 has not been complied with. As, my lord, a part of the, my lord, land of our predecessors, my lord, was acquired. We are not challenging the acquisition, but it has not been demarcated properly, and no, my lord, plan has been, my lord, prepared by the Land Acquisition Authority. My lord, kindly have a look, my lord. Section 8 of the, my lord, Land Acquisition Act 1894. My junior is there, my lord, with the book. My prayer is very innocuous, my lord. The portion which was acquired, my lord, I am not challenging that.
When
Only
this
that
was acquired?
My lord, kindly have a look, my lord, page 28, my lord, their reply. Page
When
28.
this was acquired?
My lord, it was acquired, my lord, by virtue of the LA case of 2008. My lord, we got the information, my lord, kindly have a look, my lord, annexure P4, page 28. Lordship, kindly have a look, man.
Have you received compensation?
No, my lord, I am not on that. My lord, kindly have a look, page 28, my lord. Kindly have a look, man.
Yes.
My lord, here, my lord, the acquired area has been described as, my lord, 0.72. My lord, my land, my lord, total land is 1.58 acres. So, my lord, that balanced land, my lord, I am not in a position to, my lord, enjoy that. So, as per, my lord, section 8 of the Land Acquisition Act, my lord, a demarcation plan, a joint survey, and, my lord, land should be demarcated, showing which portion is acquired. That is my lord, only grievances in this writ petition.
Yes, where is the acquisition notification?
From my inspection, compensation has been paid. So
Compensation has been paid, but a portion of the plot, according to him, has been acquired. So, which portion has been acquired? Show me the.
That's why I asked for the detailed report of the time. Next, I report.
Let a report in the form of an affidavit be filed within 2 weeks from date to establish this matter before the next available circuit bench after expiry of the period fixed for filing of the report. Yes,
Item
next.
number 38, my lord, the same petitioner, my lord, with regard to
Item
the
number?
other land. 38,
Item 39.
Yes.
I beg to
38,
appear on
I
behalf
got
of the petitioner. Lordship, this writ petition has been preferred after being aggrieved by a notice that was received under section 142(1) of the Income Tax Act. Now, Lordship, along with this writ petition, is there a connected application praying for stay? Now, Lordship, what has happened if I narrate the factual background of the matter? Lordship,
Why you have filed a separate application for stay?
Lordship, the stay because Lordship, 142 notice was served. This 142(1) notice was served on the second occasion, Lordship. Previously, it was.
What happened after that? It was followed by an assessment order.
No, it was not followed yet, because in order to prevent it from being followed by an assessment order, which has also previously happened, this connected application has been filed. That is the urgency, Lordship.
Who is appearing for the
Lordship,
Income Tax Authority?
Income Tax Authority, Lordship, they have been duly served. Also, Lordship, I have made my affidavit of service.
Yes.
They may be kindly taken into record. Yes, that's also my knowledge, as per my knowledge. Yes. But they have been equally adequately served, Lordship. That's there. Yes. Lordship, the urgency is of the stay, Lordship. Now, if I may narrate the factual backgrounds, Lordship, in the year 2017, a notice was received by this petitioner alleging that there has been some unclaimed and undocumented transactions in your bank account. Kindly give the substantial appear before the authority with the relevant documents in order to substantiate your case. That has happened. Thereafter, what has
complied with that notice?
He has complied with that notice. This notice was issued on 29th of December 2017. He has appeared before the learned assessing officer. I have also narrated in the list of days, assessing officer. Yes. Thereafter, he has also maintained the same things. He did not, for some reason, under section 144 of the IT Act, the learned assessing officer, he passed his order.
What can be done? If you do not produce any documents,
I'm coming to it. Why I couldn't, that is the crux of the matter. Why I couldn't produce the documents. Thereafter,
challenge the assessment order.
I challenged it, Lordship. Now I'm coming to it, Lordship. Thereafter, it was challenged before the CIT appeals in Jalpaiguri division, Commission of Income Tax. Even the CIT appeals, he affirmed the order of the learned assessing officer. Thereafter, I went before the Income Tax ITAT, that is the Income Tax Appellate Tribunal in Calcutta. Now, what has happened, Lordship? In all these places, what has happened before the learned assessing officer, thereafter before the CIT appeals, and thereafter before the Income Tax Appellate Tribunal, my submission was one point. Lordship, that which is also my submission out here. That Lordship,
you have not preferred an appeal under section 260 capital A of the Income Tax Act.
Lordship, I have preferred an appeal before the Income Tax Appellate Authority, Lordship.
After the tribunal. After the tribunal.
No, in tribunal, what has happened?
High Court division bench on a substantial question.
No. I did not do that, Lordship, because in the appellate tribunal, the order was to remand back the matter before the learned assessing officer. It was remanded. Now, the problem is, Lordship,
After remand, what has been done?
After remand, this notice was issued, which was issued on 25th of July 2025 under 142(1)(a). For now, the order of the Income Tax Appellate Tribunal was to hear the matter afresh after taking into considerations or after giving the petitioner all the opportunity to place his case and place all the
Where is
relied
the
upon
order of the
documents.
tribunal? Where is the order of the tribunal?
It's there, Lordship, in annexation number, if I may.
Page.
Yes, I'm coming to Lordship. It's in page number, Lordship. Order of the Tribunal. 26, page 26, Lordship. Annexure C. Annexure C. Lordship kindly comes to page number 30, the operative part. Therefore, in interest of justice, it is deemed appropriate to remand the case to the file of the learned assessing officer with the specific direction to allow the assessee another opportunity to present his case. Now, Lordship, the problem is I have got multiple criminal cases pending against me.
No, thereafter, let me see.
All right.
Directed to produce the evidences in support of the source and nature of the deposits.
Yes.
Cash deposit as directed to cooperate with the. Yes. What did you do after this?
Lordship, thereafter, I didn't do anything. The learned assessing officer, he sent me a notice. From there on, the matter started to emanate. Lordship, I have got, as I've said, before my submissions, before the learned assessing officer or before the CIT appeals or before the Income Tax Appellate Tribunal was the same. That is, I have got multiple cases pending against me. And because multiple criminal cases to the tune of, I guess there are 8 cases. I have also annexed the FIR, the original complaints of them in the writ petition, Lordship. They are from annexation numbers.
Yes, yes. So you have not filed any documents.
I am unable to file any documents. That's the problem, Lordship. I am unable to file any documents because all those documents, and they are
Then
so
what do you
voluminous
expect
documents.
the assessing officer to do in that case?
Lordship, all that is my prayer. Because the documents are filed, are seized by the various investigating authorities, and I am in no way am I being able to avail those documents or access those documents.
When it was seized?
It was seized in the year
Prior
long back,
to the
Lordship.
passing of the order of the tribunal or before?
Before, Lordship.
So did you bring to the notice of the tribunal?
Yes,
that
I
fact?
did.
Show me
did
that
too,
from the order of the tribunal.
Yes, Lordship, it's there in the or mentioned in the order itself, in the Income Tax Appellate Tribunal order itself.
Yes, show me that.
Submissions has been noted. Unfortunately, Lordship, one lacuna has been there on my part, which I couldn't annex the order of the CIT appeals. I have also in my petition, I have also craved leave of this honorable court to allow me another opportunity in the.
Because what happened after that?
Yes,
after 142 notice, the assessing officer
he passed his order. He did the assessment under 144. He passed his order and he did conclude that
that is after remand.
No, not after remand. That is
after remand by the tribunal, what has been done?
After remand, nothing has happened. As of now, only a 142(1) notice has been issued, dated 25th of July 2025, and further reminders has been issued in pursuant to the 142(1) notice, which has been issued this year. Now, that is my grievance, Lordship, because I don't have any documents. Because I don't have any.
The assessing officer say those things.
No, Lordship, I have already done prior. Now,
after the remand you have not done. After the remand you have not done anything.
No, I have done, Lordship. I couldn't even avail the documents. I have replied to him. I have replied to him, Lordship.
Go and apprise the assessing. Approach the assessing officer. Tell these facts.
I did inform him, Lordship. I did.
After remand, did you appear before the assessing officer?
Lordship, I have sent him a reply. I did not appear personally. I did send him. Lordship, in that regard, if I may.
Where is your reply after remand?
Lordship, that I have to annex. I couldn't annex them. Kindly fix it the next day. I will annex them next day.
Need not annex. You approach the assessing officer with all relevant
Lordship,
materials.
in that regard, may I make one final submission? If I fixes it, kindly fix it. Tomorrow, my senior would appear, Lordship.
No.
Lordship, it's kindly fix it next circuit. I would annex the documents. I also have to annex the documents. That's also I'm praying for that. If your Lordship kindly allows that.
It's logging a dead out.
I genuinely believe that I have a fit case. Kindly give me one opportunity.
From anything, he will have all his avenues open before the assessing officer.
No, Lordship, but the problem is that if I am again sent back to the assessing officer, the same thing would follow that happened from 2017 onwards.
Has challenged the notice issued under section 142 within bracket 1 of the Income Tax Act dated July 25, 2025, issued by the assessing officer.
Lordship, one
pursuant,
Can I just pray for a leave for annexing those documents on the next day?
Please wait.
Alright.
Kibalam, under section 142 within bracket 1 of the Income Tax Act
Income
dated
tax, huh.
July 25, 2025, passed by the assessing officer after an order of remand passed by the Income Tax Appellate Tribunal. First of the learned advocate appearing for the petitioner submits that the petitioner could not file any documents, could not file any documents before the assessing officer pursuant to the notice issued under section 142 within bracket 1 of the Income Tax Act, but has filed a reply to the said notice before the assessing officer. First up, he submits that the reply to the notice under section 142(1) and the order passed by the appellate authority, which was impugned before the appellate tribunal, has not been annexed in this.
That has been annexed. The order passed by the CIT appeals, Commission of Income Tax Appeals, that is the after the learned assessing officer. Thereafter, it comes the income tax appellate.
Sir, I have said that.
Yes, all right, Lordship.
Which was impugned before the tribunal. I have said
Before
that.
the tribunal, Lordship. Yes.
You know.
Sorry, Lordship. I beg your pardon. I beg your pardon.
Which was impugned before the appellate tribunal has not been annexed in this writ petition. First up, we prays for leave to file a supplementary affidavit. First up, let's a supplementary affidavit be filed within a week from date. First up, list this matter before the next available circuit bench.
Grateful.
The learned Deputy Solicitor General appears for the Income Tax Department.
Grateful.
Yes, next.
I don't know 40, I appear for the petitioner, but just like the same case at the 38 item number. Well, out of my lord land measuring 3.14 acres.
Same matter. Same matter.
Same matter, but here my lord interim order is required. Interim order is required because my lord already my lord government project has been is trying to be implemented with regard to my lord unacquired, non-acquired land. Lordship, kindly have a look, my lord, page 22. My lord, kindly have a look, my lord, page 22, my lord. That is all right. The last item your lordship will find, my lord, the plot number 47
This is
by 1.
for the state. Yes, what is your instruction? Yes,
Slightly different than the previous one.
yes. What is the interim order you seek, Mr. Chakraborty?
My lord, status quo, only status quo, because of the fact, my lord, if auto stand is going to be, my lord, erected, my lord, on our non-acquired land. That's what, my lord, we are praying for only, my lord, status quo order. Let status be maintained. Because, my lord, it is their admission, my lord, they have acquired only 0.7 acres of land at page 25. Page 25, lordship, kindly have a look, my lord, they have admitted that, my lord, only 0.72 acres of land has been acquired. And, my lord, page 22, your lordship will find total land is, my lord, 3 acres, 3.14 acres of land.
That is the SJDA needs to be heard.
Am I audible, my lord?
Where is Mr. Dor?
No.
This is the service also.
Yes, what are you doing? Auto stand you are trying to set up.
Well, Gary, don't sort of copy upon us then.
Only one status quo till the disposal of the writ petition. But it is their admission. Lordship, kindly have a look, page 25. Their admission, my lord. They have replied that out of my lord total land, only 0.72 has been acquired. My lord, I am not on acquisition. That will challenge later on. Page 25, my lord, kindly have a look, my lord. In Moja Dabugram, ship number, my lord, just to inform you that total 0.72 acres of land. And total land is, my lord, 3.14 acres.
Yes, Mr. Dor and Mr. Saab, you cannot utilize a portion which is not acquired.
Let us
So
come back to
I'm
our-
only directing you not to restrain you, not to take
Lordship,
any steps.
in that case, takes that matter tomorrow, we shall take instructions. Tomorrow.
No, without any acquisition. If you have acquired, you can proceed with that.
My lord.
I will
My
only
lord.
observe that will not utilize any of the property which is not acquired. If you have not acquired, you utilize. If you have acquired, you
Deeply obliged.
utilize. If you are not acquired, you cannot utilize. Ashun, the petitioner alleges
My
that
lord, demarcation is required because section 8 is there, my lord. They have not demarcated.
Mr.
And-
Chakravarti, that is a different thing altogether. The acquired portion, if it is not acquired, they will not utilize.
No, my lord, in terms of section 8, my lord, of the Land Acquisition Act, they have to demarcate, they have to, my lord, make out a demarcation plan.
Then no
Otherwise,
interim order, I'm directing them to file a report. Because without ascertaining which is
No,
the
my lord,
acquired,
my
which
lord,
is
my
the
lord.
non-acquired,
That will-
no
that will-
interim order
that will-
on
No,
the
I am not on that.
land cannot be passed.
No, I am not on that. No,
Yes, yes.
I am not on that.
The learned advocate appearing for the petitioner submits that only a portion of the property of the petitioner has been acquired and has been acquired, full stop. He submits that the authorities are trying to utilize a portion of the property which has not been acquired in accordance with law. Full stop. Mr. Chakravarti, learned advocate, prays that an order of status quo be passed. Full stop. Since the portion of since the portion which has been acquired has not been specifically described in this writ petition, no interim order on an unspecified property can be passed. For such reason, this court is not inclined to pass any interim order at this stage. Let a report in the form of an affidavit be filed by the respondents within 2 weeks from date. List this matter after 2 weeks.
My lord, kindly appreciate if, my lord, that is utilized. My lord,
Unspecified property status quo is a very vague order, Mr.
not only one with regard to non-acquired portion, my lord,
No,
non-acquired portion. Lordship,
That
kindly
is,
appreciate.
you have specified, it has not been demarcated. Thank you for specifying that. Yes, call the next matter.
Deeply obliged.
Yes.
41, I'm for the petitioner, Lordship.
Yes.
I'm told by learned advocate on behalf of the state respondent that they require instruction and they would proceed accordingly. Lordship, this police inaction matter, Lordship, I have filed after just
Yes, what do you
filing of
want?
the
State.
Ready, man. I am ready with the matter.
Yes, instruction, you have got instruction.
But only one copy, madam. I may be pardoned, only one copy and it is not in proper format, but I have the instruction.
Yes, yes, what is your prayer?
Lordship, prayer is that, Lordship, that a minor son of the petitioner has been committed at the behest of the accused person. Lordship, at the proactive instigation of the instigation, she has been committed suicide, Lordship. Now there is an angle of STS, the caste persecution and all, Lordship.
So no FIR has been registered.
No, till filing of the petition was not filed, but meanwhile I came to know that recently FIR has been registered. Thereafter, no progress has been made. Lordship, I don't know what is the latest status of this. Lordship, a report in a proper form may be called for.
Yes. After that, what steps have you done?
On 31st, the FIR has been lodged.
31st of October.
31st of.
So,
let me finish.
Conclude the investigation.
I will, my lord. The case is that the son of the petitioner has been committed suicide in the month of February. My lord, thereafter they did not lodge any complaint.
Absolutely contrary. Absolutely contrary.
Let me complete, sir. Let me complete.
Sorry.
Thereafter, in the month of September, they made a complaint before the district magistrate that their son had been committed suicide.
District magistrate?
And my lord, copy has been sent to the SP and IC. That is the on 25th. On 26th, they also filed an application before the district magistrate to withdraw the said complaint. Kindly see,
No.
my lord.
Absolutely not.
Yes,
Lordship,
what
let
happened
them
after that? Now you have registered an FIR.
Now they filed an application for registration of FIR on 10th, on 31st, on 13th, on 31st, we have registered the FIR, my lord. Kindly fill.
Conclude the investigation.
No, Lordship, there is an issue, Lordship. The investigation requires to be transferred to the Deputy Superintendent of Police rank
Sir,
officer.
investigation has not yet started.
Lordship,
What is the fault in the investigation?
I am telling Lordship, there
The
is
transfer
a
of investigation is not
why,
a matter of
why?
course.
Because the competency is required. Competency, because this is a case of under section STSC.
All right. So let him file a report, let him disclose the stage. Thereafter,
Lordship.
if you are not satisfied,
Lordship,
only
let them file a
31st of
report.
October FIR has been registered.
Let
and
them
you
file a
think that
report.
it is to be transferred.
Lordship, let them
What
file
is the
a
law
report.
on this issue, sir?
Lordship.
My lord, they have been filed the registration of FIR after, my lord, 8 months.
No. Absolutely. I have approached to every authority. It is absolutely contrary to the record, Lordship.
Petitioner alleges that the petitioner alleges that no steps. Petitioner alleges that the police authorities have not registered any FIR on the basis of the complaint lodged by the petitioner on July 25, 2025, in spite of the fact that the complaint discloses a cognizable offense. Most of the learned advocate appearing for the state submits that, yes, give me your instruction.
Yes, they FIR.
Submits that an FIR has already been registered. Where have you mentioned the FIR number? Banarhat PS case number 268, being Banarhat PS case number 268/2025, dated October 30, 2025, under section 107/303 within bracket 2/3 within bracket 5 of BNS 2023, and the matter has been endorsed to SI for investigation, and investigation of the case is proceeding. First up, the learned advocate appearing for the petitioner submits that the investigation may be transferred to a competent independent investigating agency. First up, at this stage, this court is not inclined to allow such prayer. First up, the inspector in charge, the concerned investigating officer is directed to file a report in the form of an affidavit within a period of 8 weeks from date, disclosing the progress of investigation. Full stop. List this matter after the period fixed for filing of such report.
Grateful,
Yes, next.
Grateful, Lordship.
Lordship, item number 42, Lordship, my senior Mr. Subba is suffering from viral fever, Lordship.
Where is Mr. Subba?
Lordship is suffering from viral fever.
Oh, he's suffering from viral fever.
Yes, Lordship.
Yes, what do you want?
Lordship, I pray for another date, Lordship. Kindly fix this matter in another date.
Adequate compensation and employment. No, as well as employment. There is a scheme. Where is the scheme?
My lord, I was informed to appear here, my lord, because it has been transferred from the principal bench. Now
You don't have the papers.
No, my lord.
So what do you want? Next circuit.
Next circuit.
On the prayer of the learned advocate for the petitioner, list this matter before the next available circuit bench. Call the next matter.
Grateful, Lordship.
My lord, 43, I am appearing for the petitioner. My lord.
Yes.
My lord, this is the the district has been wrongly recorded in the name of Nadia, but instead of Kuch Bihar. My lord, last order, the Justice the Sina has transferred the matter
now
before
what
the
do you
circuit
want?
bench. My lord, just before the last order, the order dated 7th of April 2025, that order which has been passed by Lordship his lordship, Justice Rai, that has to be passed by the circuit bench, my lord. Otherwise,
Yes, now
we
it's
cannot
before
file
the
the
circuit
supplementary
bench.
affidavit.
Now
Yes,
it's
my
before
lord.
the circuit bench. What is the matter?
This is the the vendor, the tendering matter, my lord.
Yes, who is appearing for the state?
It has not been appeared.
Did you serve a copy?
Yes, my lord. I have served here, but I need to serve again for the circuit
Yes,
bench,
you have
my
not
lord.
served upon the GP here.
So, if my lord kindly pass the
Shah, can you
direction, I
appear?
shall serve.
I'm directing you to serve upon you. The learned advocate appearing for the petitioner submits that this matter has been transferred from the principal bench for being and to be taken up by the circuit bench. First of the learned advocate appearing for the petitioner in his usual fairness submits that the copy of the writ petition has not been served in the office of the additional government pleader here or LR in the office of the additional government pleader circuit bench. First up, Mr. Shah Lanet, additional government pleader, is present in court. And is requested to appear in this matter. Yes, along with you, who you want whom to be taken? Subject matter, compassionate appointment, stamp vending license. কি বললাম? First up, let the appointment, he submits that Mr. Rahman be allowed to appear in this matter to assist him. Let the appearance of Mr. Shah along with Mr. Rahman be regularized by the competent authority. The learned advocate on record of the petition is directed to serve a copy of this application upon Mr. Rahman within
my lord, 2 weeks.
Within 2 weeks. Then it cannot appear before the circuit bench.
Then, my lord, I am trying to contact with the advocate on record. I am telling him to as soon as possible to service.
On or before November 12, 2025, list this matter before the next available circuit bench. Yes. হয়ে গেছে তো?
My lord, I'm appearing for the petition in the next matter. It's a,
My
lord, this is a covered matter, lordship.
My lord had said on the last occasion, your lordship will take up. I will take 10 minutes. Your lordship has seen everything. I will only give your lordship one judgment. That's it.
I will not have time to dispose of this.
My lord, your lordship fixed, my lord, matters at 3 o'clock. Last time your lordship refused to fix this matter. I did not, my lord, say anything.
Because
I said
these
today-
motions were there first time, this
This
could
this
not,
was a motion as well.
new motion. I stand
Ah,
corrected.
but 8
New,
years-
new motion because Mr. Chatterjee, these matters were not taken up once. Matters, that is why, and you had the opportunity to move.
And it's an opportunity of no avail. My lord, the mill still stands closed.
Yes, where is Mr. Mojumdar? Actually, he was here, he is present. Where is Mr. Mojumdar? Ask him to come.
Always to cite him. My lord, this matter is a covered matter. It's a very short matter, my lord. Very short matter. I won't trouble your lordship much. Very short matter, covered matter. 43, item number 43. I'm on call.
Yes,
46,
what is
46,
it?
yes.
Give me a minute, yes.
Yes.
So my problem, so my problem is, my lord, your lordship has seen the facts.
I am directing, let this matter retain its position in the list. It will not be altered. Chatterjee, it is difficult because. Yes, Mr. Mojumdar. Yes, fighter din to, what is the item number?
82. Barkuri.
How it could be taken out?
No, it was there. Mariana rice mill.
Machinery is very strong, Mr. Chatterjee.
Mine.
Machinery is very strong.
You know, it's all love and affection. There is no machinery whatsoever. If there is anything that happens, it's all out of love and affection. Even this man will do, Lord, whatever, Lord, if I request him to do something, he will do out of love and affection.
First thing I will.
Right, Tom?
Mr. Majumdar, what is your where is the last order I directed?
Yes.
Where is that?
It's in the last order should be, Lord, before your lordship.
No, not the order of 31st of October. I'm not on that. The order which I directed, in which I directed the Union of India to take instructions.
So that order was passed by probably Shogoto Bhattacharya, Justice Shogoto Bhattacharya.
Yes, where is that?
But that order, my lord, again, it has to come out, my lord, from there.
You don't have a copy. It's not.
It's not there with me, my lord. It's there on record.
All right.
একটু বলো না তুমি কি বলছো?
আমি কিছুই বলছি না, চাল দিলে পরে বলতাম।
This is the
Yes.
May I find it out for your lordship?
28 July 2025.
Yes, Mr. Majumdar, what steps have you taken? Because you have been directed, copy was served upon you. There's a notification or some notification with regard to the extent of that. What is that zone called? Eco-sensitive zone. With regard to the demarcation of that eco-sensitive zone, the state has demarcated, has issued, has given some proposal. He has forwarded the proposal before you. What steps have you done with regard to that proposal?
So far I can recall, actually Mr. Singhani has written to the ministry. I don't have first-hand knowledge about that.
Tomorrow, my lord?
But you take, you file an affidavit with regard to that. Something is to be on
Yes,
record.
on record. Something has to be. My oral submission would do, my lord.
Yes, because, and please see, because it's an issue. Because the area or the zone that is to be finally decided. Now, many things boils out from there. Whether
I'll just tell your lordship, remind your lordship what the problem was with respect to this. So that Mr.
Chatterjee,
Majumdar can.
please make a short submission
Yes.
with regard to this ESZ.
Yes.
So that Mr.
Exactly.
Majumdar
Can
understands what instructions or the report he will file.
Absolutely.
Please
Now, what
restrict your
happens
submission with
my
regard
lord,
to that.
what happens with the eco-sensitive zone was initially, my lord, there was within 0 kilometers, my lord, within the forest boundaries, my lord, there could not be, my lord, any economic activity. Then the Supreme Court said that it's not 0, it was then, my lord, stretched to 10. Then Supreme Court said that it is based on, it can't be a straitjacket formula. So Supreme Court said that
Can vary from area to
it
area.
will vary from area to area. The state, my lord, has said that the eco-sensitive zone within Baksa Forest Reserve should be this. And if that is what it is, my lord, then I am outside the eco-sensitive zone.
Mr. Chaudhary, where is your proposal?
It has been sent to the Milord.
Have you annexed that here?
Said in the bio affidavit, Milord.
No, had you annexed any document here?
Milord,
Because
that-
unless
There was an affidavit to that effect.
Not annexed. Because
you have a copy of that.
that is a
If you can share that copy, so that it will be easier for Mr.
Milord,
Majumdar
that I
also.
can share with you. Because it's a proposal from the government end, Milord.
Yes.
This is the reason by our memo we have forwarded to the Milord MOF, Milord, Ministry of Forest and Environment, Milord.
So disclose that, give a copy to Mr. Majumdar so that he can take
They
instructions.
disclosed that in their affidavit filed by the forest.
Milord, even
Who has disclosed?
The state of
No, he has said the memo number only.
Yes. Yes.
Not the
Not the document.
Not
No-
the
no
document.
proposal, yes.
Because if the document is disclosed, it will be easier for Mr. Majumdar to.
Absolutely.
So,
My lord, that's
Milord-
one part of the story, my lord. The other part of the law is that, my lord, even if there was, my lord, within the eco-sensitive zone, I am still, my lord, in a position, my lord, to run that mill.
That I will decide. So if this is done, that it can be, that is resolved, Mr. Chatterjee, you
That
are
is
true.
True.
You are
completely-
true.
Completely.
Milord,
So-
not only through Milord, as I have indicated in the last occasion, even Milord, the Ministry of Environment and Forest and Climate Change,
That is Mr. Majumdar.
that is Mr. Majumdar, even they approve the proposal which we have said. Then that the gazette notification by a draft notification has to be published.
That will be done unless
Milord-
they approve. If they say no, we reject,
Yes.
then there's no question of.
When the Milord, the draft notification, then it will take Milord further 2 to 3 years, Milord. After.
Why?
Yes, this is the reason, Milord, that's why I say. Suppose the draft notification is published, then they will invite an objection. That in objection for 6 months. at least.
We wanted to have Ruti Milord instead of Bha, because I'm to set up a rice.
Rice mill.
Hey, if you
ওটা
don't have-
ভুটানের জন্য তো।
Sundar says
But,
no.
Mr. Chatterjee, I appreciate, but this is a direction by the coordinate bench, adding them.
Yes, yes.
So
I
let
am
them
not in
come
that
up,
way.
then I will consider, it can be
I will
considered.
consider is a good option. That's a good option, Milord. It can be heard tomorrow. You
I
also
means
can-
the High Court. Yes,
That's
Ashun,
true.
the
Contempt.
learned deputies,
Declaration দিতে বলো, আমি দিয়ে দিচ্ছি।
the learned Deputy Solicitor General appears for the Ministry of Environment, Forest and Climate Change, Government of India, and its Secretary. Full stop. He prays for some time to take complete instructions in this matter. Full stop. The who is your junior, Mr. Chaudhary? The learned, you are representing which authority?
All the state, all.
No, but all the state, which responded? The learned advocate on record for the state is directed,
Accepting pollution control board, Milord.
is directed to, the learned advocate appearing for the state is directed to supply a copy of, what is the memo number? Where do I get that?
That's in the affidavit.
Is directed to supply a copy of the memo number ... blank. Mr. Chatterjee, please ask your junior to put it in a piece of paper. At a kagos din to nake. Is directed to supply a copy, because filing, disclosing that by of a report will again delay that. So to supply a copy of the memo number such and such dated.
Affidavit.
Please give the number. Please check up. Mr. Chatterjee is writing. Please check up.
Paragraph 5.
Number such and such, dated
Page
such and
3,
such.
paragraph 5.
To
লিখে দিন।
the to Mr. Mojumdar. Within, yes, Mr.
Now,
Chaudhary.
No, it is there.
Tomorrow, তুমি কালকে দিয়ে দাও।
No,
The proposal.
Memo.
yes, proposal.
Proposal, Milord, we can share.
I want that memo, not the reference only, the document, so that he can take instructions on that. Tuesday?
Milord, I can, I need little instruction, Milord, that whether that proposal can be, because
Shared
they
on-
forwarded. That is
Yes,
forwarded.
only the copy. Can you not share a hard copy of that?
See my problem. This is where I am.
Give a hard copy to them.
There, all right, Milord, I will.
Tuesday or Wednesday?
So
They
then
have
tomorrow, then
code-
tomorrow I can.
Ah.
If it is there, already it is there. Tomorrow I can.
All right. So I'm making it by Monday, I'm saying. By Monday or Tuesday?
By Monday, Milord.
By Monday kore din. Let a report in the form of an affidavit be filed by the Secretary, Ministry of Environment, Forest and Climate Change, Government of India,
The final draft.
within a period of এটা কবে বললাম, সোমবার বললাম তো। Yes, can you do it that within 18th or 19th November?
Have a look at this letter. This was annexed by my learned senior friend, Milord, with his report. This is probably a reminder.
Draft was prepared.
And then sent. That's the second paragraph.
Yes, but where is that draft? I want that draft to be.
That is a memo which is given at
No,
the
that
top.
is the revised proposal. That is
Yes.
paragraph 5, revised proposal.
Yes.
Yes.
Because initially, Milord, as I say.
Where is the proposal? Concrete proposal, give it to them so that.
I will.
by Monday. And can you file your report by November 19th?
I will try my second.
Let a report in the form of an affidavit be filed by the secretary যেটা বললাম on or
Milord,
before
the secretary, Milord, is in Delhi. Some local authority here.
Uh,
It's just a document which they need to, Milord, some local authority. তোমার local. We don't have. দিল্লি থেকে সে এখানে কোথা থেকে আসবে?
notarized also can be done.
They will affirm it is Delhi High Court and send it. But again,
Don't
that
be
will-
so technical on that.
problem. I will never be, Milord. I want it done tomorrow. I've been waiting here, Milord, for 5 years. But I'm trying to expedite it, Milord, because again, next
I
time they
can
will
say that a competent authority of the Ministry of
Yes.
Environment can also say.
Yes.
Will the affidavit be filed by a competent authority
আশেপাশের লোক খাওয়ানোর জন্য, নিজের জন্য না। সবকিছু নিজের জন্য হয় না।
of the Ministry of Environment, Forest and Climate? And to the said ministry. Yes, Mr. Chaudhary, that's proposal forwarded by the state of West Bengal or the
No.
Forest Department. State of
Yes,
West
sir.
Bengal Forest Department.
না না তো কমিটি
That is
তো
the proposal eco-sensitive zone of Boxer Tiger Reserve.
কমিটি
Uh,
the committee of the
Proposal
eco-
forwarded by the
Eco-sensitive zone.
Eco-Sensitive Zone Committee.
monitoring
Sensitive zone of Boxer Tiger Reserve.
Committee for Eco-Sensitive Zone.
monitoring committee of
Monitoring Committee of Eco-Sensitive Zone of Boxer Tiger Reserve to the Ministry of Environment, Government of India.
Ministry of Environment, Forest and Climate
Yes,
Change.
yes, Ministry of Environment, Forest and Climate Change, Government of India. Full stop.
In the year to 2023, right? Letter number.
Bolo. Give the memo number.
Memo number is Milord, right?
Give it.
Letter number 2247.
memo নম্বরটা লিখে দিন।
Letter number,
Yeah,
করে দিন,
letter
memo number না, letter number 2247
Ah.
So,
28-91 dated 11/11/2023.
Yes, we have that written up by your lordship.
copy is annexed in the my
না ওটা
in the
ওটা
my-
চিঠিটা
Draft proposal,
ওটা
draft
proposal টা
proposal.
চাইছে, ওটা চিঠিটা।
That is the letter, proposal is
Proposal, please send that.
My lord can take it to the Milord to the principal bench.
Why?
As part of
একদম বাদ ছেড়ে গুলো কামড়াবে।
আজকাল